company that was bought out by this other company. They just wanted to.
Okay, we're live stream now.
Yep.
Okay, got it. And then Anna will move me back.
Did you say there was 5 witnesses? I only show 3 for El Paso.
Yeah, there was rebuttal testimony.
I got
from 2 additional witnesses.
Oh, okay.
So you have rebuttal testimony from the 3 original ones, plus you have rebuttal from Davis and Schiestel.
Okay.
Okay.
I did see that name.
Okay. Well, I guess I'll go ahead and let the others in. Anna, have you made me the host yet?
He's muted. Well, no, I think she should hear even if she's muted, but.
Hey, Anna. I am the host now. Okay, well, let's admit them. So we will be waiting for Ms. Stevens, and we will be waiting for. Good morning.
Good morning.
While we get ready for our hearing to begin, I just want to let everyone know we are already being live streamed on YouTube. And so, good morning, Mr. Fisk.
Good morning, Madam Hearing Examiner. Good morning, parties, council parties.
We are awaiting Ms. Lynch, and we are awaiting Ms. Stevens. And I will announce formally when we begin our hearing that Mr. Herman will be delayed and has waived any cross that will occur during the time that he is away. Is anyone going to have any procedural matter that we need to deal with once we begin our hearings?
Hearing examiner, good morning.
Good morning, Mr. Black.
Good morning. I just wanted to make sure that the corrected staff exhibit 2 and the corrected exhibit list was brought to the attention of the hearing examiner and parties. that was uploaded yesterday, I think before noon. I could be wrong. Could have been in the afternoon at some point. And also, I'm testing my mic and my video and all that. Do I come across all right? I've been having like connection problems with my
Yes, yes,
CenturyLink.
I can hear you.
Okay.
I can see you.
Thank you.
Yes, I got, just need to pull it up. I received several notifications. There's Miss Stevens. Several notifications of corrections to the Dropbox exhibits. Which sort of gave me ambivalent feelings. I mean, obviously there's Miss Lynch. Okay. It's kind of ambivalent because parties were supposed to have uploaded the final versions of corrected exhibits so that parties could have them over the weekend. And I kept getting more corrections. So it's good to have the correct version, but it's even better to get the correct version on time. Okay, Melissa, I believe we have all of our parties now.
Okay,
Good morning. Happy Halloween to all you parties. And Mr. Fisk, if it's all right with you, we can begin today's hearing. Good morning.
Yes, please do.
Thank you. My name is Elizabeth Hurst, and I am one of the co-hearing examiners in today's matter. This is case number 23-00086. This is in the matter of the application of for approval of El Paso Electric Company's 2023 Renewable Energy Act plan pursuant to the Renewable Energy Act and 17.9.572 NMAC and 7th revised rate number 38-RPS cost rider. Along with me today is my co-hearing examiner, Russell Fisk, and our court reporter, Melissa Gonsalves. Should anyone need anything to do with the transcript, you will need to contact our court reporter directly. Today is the date, time, and place that was noticed for a hearing in this matter. And if we could, I would like to have counsel put their appearances on the record. And I just want to remind parties that we are live streaming on YouTube, thus any of your staff or the public or the witnesses who are not yet giving testimony should feel free to watch on YouTube. So with that, Ms. Olson, we'll begin with you. If you'd like to put your appearance on the record, please.
Good morning, Madam Hearing Examiner and co-hearing examiner, Mr. Fisk. Carrie Olson from Montgomery and Andrews on behalf of El Paso Electric Company. And I have Ms. Nancy Burns, Deputy General Counsel for El Paso Electric here in the room with me. She's going to be doing this hearing with me.
Very well. Good morning. And I believe we have someone in the witness room, and I've also allowed your IT support to join the Zoom link.
Thank you.
Thank you. Ms. Souls?
Good morning. My name is Mary Lee Souls. I am a pro se party in this case. I'm representing myself.
Very well. Thank you. Ms. Stevens?
Morning, I'm Anastasia Stevens of Stevens Law LLC, representing the city of Las Cruces.
Very well. Mr. Black?
Good morning, Hearing Examiner Hurst, co-hearing examiner Fisk. My name's David Black, and I am staff counsel for the Utility Division Advocacy staff.
Thank you. Ms. Lynch?
Morning, Examiner Hurst and Hearing Examiner Fisk. I am Kara Lynch, attorney representing Coalition for Clean, Affordable Energy.
Thank you. Good morning. And as I indicated prior to beginning the evidentiary hearing, I got an email yesterday from Mr. Herman, who is counsel for Doña Ana County, an intervener in this case, indicating that he had an appointment this morning. He waived any cross that should occur during the time that he is away, and I excused his appearance until he is available to be here. With that, I would like the record to reflect that there were no persons who signed up to give public comment in this case, and that let's see, there were just had the computer on Dropbox, and there were no written comments filed by the public in this matter. Therefore, I believe that the procedural items have been taken care of, and we can now begin the evidentiary portion of our hearing. Ms. Olson, you have a witness.
Yes, thank you, Madam Hearing Examiner. Before EPE calls its first witness, do you want to take care of introducing the bench request order or the response to the bench request order?
Yeah, that would be fine.
Okay. So EPE has uploaded what's been marked as Commission Exhibit 1, and that's EPE's response to the Commission bench request order. And I sent you an email yesterday evening providing a table that's not in the record, but just for informational purposes, that assigns a witness to each response. And I did copy all the parties on that email.
Madam Hearing Examiner, this is Anastasia Stevens.
Ms. Stevens?
Yeah, I'm just wondering, I just went to the Dropbox, and partly because I had just uploaded another exhibit in a revised service list, I'm not finding EPE's filing of yesterday. Everything says 3 days ago, 16, maybe 18 hours ago. Is that it? I apologize for being inept, but I'm just not. Commission Exhibit 1, EPE response to Commission bench request 3 days ago.
Are you scrolling down throughout through the whole
I'm
Dropbox?
scrolling down in the Dropbox and looking at the timing that they're giving for things, and I'm confused as to whether, I know that yesterday Ms. Olson was making some changes for the footers and things like that. I'm just wondering what to make of the timing listed in the Dropbox.
Well, I can tell you that they're not all chronological, so I see yours.
I just uploaded just minutes before the hearing, I uploaded a CLC exhibit 35 and a new hearing, second corrected hearing exhibits list. And I don't see either of those. Actually, let me look in my inbox and see whether they were received. But when I look down to Commission Exhibit 1, it says 3 days ago, and Ms. Olson said that
That's because we uploaded it on Friday.
Oh, okay. So it was actually uploaded. So we didn't get the message till okay, thank you.
Everything, the EPE, all EPE exhibits were uploaded on Friday.
Okay.
Yesterday, it came to our attention that Mr. Novella's rebuttal testimony was missing page numbers. So we provided a substitute corrected exhibit with the page numbers. That's the only correction that we made.
Okay. And I also see that my exhibit 30, I didn't get an acknowledgement from Dropbox. Is the Dropbox still open, Madam Hearing Examiner?
Yeah, I haven't closed it.
Okay, I'll try that. It's not for the first witness. I'll if with your.
So,
with
Ms.
your
Stevens, has it been clarified now from Ms. Olson?
Yeah, no, I understand.
Okay,
She's good to go.
very
I
well.
was afraid that there was something that was yesterday and now it's saying 3 days
Okay.
ago. Yeah,
Very
appreciate
well.
that. Thank you.
And I did get Ms. Olson, I did get the email that you sent to the parties that identifies for Commission Exhibit 1 the witness who would be able to answer any questions with regard to that. So thank you for doing that. And if you want to proceed with, well, I guess we need to call your witness first.
Yeah, did you want to admit Commission Exhibit 1 or?
Well, let's get some verification from your witness first. You have Mr. Novella?
Yeah, EP would call its first witness, Mr. George Novella, and it looks like he's there in the witness
He is. Good morning, Mr. Novella. Happy Halloween.
Happy Halloween, Madam Hearing Examiner.
Appreciate that. Melissa, would you swear the witness in, please?
Raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth? So help you God.
I do.
Thank you.
Go ahead, Miss Olson.
Okay, could you just provide a little direction on how you want to proceed? Do you want me to move forward with direct testimony?
Yeah, Mr. Or Mr. Novella, you're the one that's I realize Mr. Schiestel filed some testimony, but is it correct that you're the one that is basically in charge of the application and how this particular case for EPE proceeds?
That's correct.
Okay, and as part of that, part of those duties, you responded to you and or the people that you know of from EPE responded to a bench request that was issued by the commission in this case. Is that correct?
That's correct.
And are you familiar with what has that was issued on the 16th of August? Are you familiar with what has been labeled as Commission Exhibit 1? And that is El Paso Electric Company's response to the commission bench request order. And that document was filed upon your behalf, upon EPE's behalf, on August 30th of this year.
I am.
And to the best of your knowledge, were EPE's responses true and correct?
Yes,
And you assisted in filing this particular document? Did you?
I did.
Is there anything in this document that you think here today would need to be changed, or is it still true and correct?
That's still true and correct.
And do you believe if El Paso Electric were to be given that bench request right now, that the answers would be the same?
Yes, I believe so. There were a few key experts that answered other questions than the ones I answered, but I believe I answered them the same way, Madam Hearing Examiner.
Okay. Thank you, Mr. Novella. Is there any objection to what has been identified as Commission Exhibit 1, El Paso Electric Company's responses to the commission bench request order? And this exhibit has been identified as Commission Exhibit 1. Hearing no objections, Commission Exhibit 1 is admitted. Ms. Olson?
Thank you, Madam Hearing Examiner. And good morning, Mr. Novella. Could you just please state your full name for the record and spell it for the court reporter?
Yes, George Novella, George, N-O-V as in Victor, E-L-A.
And Mr. Novella, what is your current profession?
I'm the Director of Economic and Research with El Paso Electric.
And do you have before you what has previously been marked as EPE Exhibit number 1?
I do.
And do you recognize that document?
Yes, it's my direct testimony.
And was your direct testimony drafted by you or under your direct supervision?
It was.
Is the direct testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
And do you have any corrections to that testimony today?
I do not.
If you were asked these same questions today under oath, would your answers be the same?
They would.
Madam Hearing Examiner, El Paso Electric offers EPE Exhibit number 1 along with the accompanying exhibits.
And just so we're clear, Ms. Olson, is there only one El Paso Electric Exhibit 1 in the Dropbox?
Yes, we didn't make any changes to El Paso Electric Exhibit number 1. That one should be the one that was downloaded on or uploaded on Friday.
Okay. Any objection to what's been identified as El Paso Electric Company Exhibit 1, the direct testimony of Mr. Novella as verified by him here today? Hearing no objection, El Paso Electric Exhibit 1 is admitted.
Thank you. And Mr. Novella, do you also have before you what's previously been marked as EPE Exhibit number 2?
I do.
And do you recognize that document?
Yes, that's my rebuttal testimony.
And was your rebuttal testimony drafted by you or under your direct supervision?
It was.
do you have any corrections to that rebuttal testimony?
I do not.
And if you were asked, oh, is the rebuttal testimony that you prepared true and accurate to the best of your knowledge and belief?
It is.
And if you were asked these same questions today under oath, would your answers be the same?
They would.
And Madam Hearing Examiner, we offer EPE exhibit number 2 into the record. And that EPE exhibit number 2, there could potentially be 3 versions. It would be the most recent version with the prints corrected. And if you open it, it should read in the footer EPE exhibit 2 and have page numbers.
So if I am, okay. So I see 3 versions. I see one from 10/27. I see one from 10/30. No, yeah, from October 30th at 2:52. And then I see one from October 30th at 4:53. Which of the 3 of those are you offering?
I believe it's the 4:53.
With that clarification, is there any objection to what's been identified as EPE Exhibit 2, Mr. Novella's rebuttal testimony as verified by him here today? And I believe council has made representations that the only difference between the original testimony and the corrected testimony had to do with page numbers?
Actually, the only difference between the original testimony that was pre-filed and the version that we're introducing today is that the version we're introducing today has an exhibit label EPE Exhibit 2.
Okay, so it was the only thing that was missing was the exhibit label.
Yeah, and then on that version that was uploaded at 2:50, for some reason the page numbers disappeared.
Okay, so you put them back in the 4:53.
That's correct.
Okay, must be one of those Halloween tricks.
Yes.
And not the treat. Okay, and with that clarification, you adopt the testimony EP Exhibit 2, Mr. Novella, with the exhibit label on it as your testimony?
I do, Madam Hearing
Very
Examiner.
well. Any objection to EPE Exhibit 2 as corrected and labeled? Hearing no objection, EPE Exhibit 2 is admitted. Ms. Olson?
Madam Hearing Examiner, that's all of Mr. Novella's exhibits. So at this time, we tender him for cross-examination.
Very well. And just I'll reiterate from what I believe is the correct intervention order. The cross-examination would be Ms. Stevens for the city, Ms. Souls, Mr. Herman for Doña Ana County, Ms. Lynch for CCAE, and then Mr. Black for staff. However, Ms. Stevens, you can get ready to go, but I'm going to do something that I don't normally do. I have a question I'm going to ask first because I believe it will be efficient and appropriate in case anyone else has would like some clarification on the issue for me to ask this question first so that we all have an understanding. So, unless someone objects to that, Mr. Novella, I'm going to ask you one question about your testimony and about El Paso Electric's proposed 2024 plan. Okay, and essentially, I'm going to be asking you about the component of purchasing the RECs from the DG customers. So I would like for you to look at page 25 of your direct testimony, EPE 1. And you are answering the question posed on page 25, line 11. Well, let me just start out with the precursor. At the beginning of that page, you indicate that 2023 amendments to Rule 572 changed how that the RECs generated by DG customers were registered and retired, and that EPE interprets this new rule to allow only an estimated 13% of customer-owned generation to be counted for RPS purposes absent an agreement. That's your testimony on page 25, sir? Beginning part?
That's right, Madam Hearing Examiner.
So in answering the question posed at lines 11 and 12 about EPE's proposal in this case, you say, beginning on line 16, under the proposed procurement, EPE would purchase all eligible DG customers' RECs, and that's capital R-E-C, and it's plural, S, associated with the energy delivered to EPE's system, except for the excess net DG energy already purchased by EPE pursuant to rate number 16, purchase power service, which you say is the approximately 13% discussed above. That's your testimony?
That's right.
And then on the next page, page 26, at line 5, you say, EPE is therefore proposing to pay DG customers for these RECs, which were previously provided at no cost, for any energy delivered to EPE's system, i.e., not consumed contemporaneously on site, excluding the energy and RECs that EPE purchases under rate 16. Correct?
Correct.
Okay. So that we're all on the same page and we understand what's happening here. The distributed generation customer and generator has some type of renewable facility that qualifies them as a QF, correct?
Correct.
And so they are actually generating energy, right?
Right.
And they have energy that of that energy that they generate themselves, they use some of that energy, correct?
Correct.
And then the rest of that energy is put into the EPE system, and EPE buys that energy, correct?
Correct, Madam Hearing Examiner, either via the rate 16 or through net energy metering.
And so if you are, if the energy that's available to El Paso Electric, i.e. that energy that's not being used by the customer, you're already purchasing under rate 16, and they're being paid for that energy, right?
Yes,
And El Paso Electric gets the rec from that energy, right?
that's correct.
Then what energy are you saying is going to be available if you're already buying the energy they're not using? What would you be buying under this new program?
Okay, so we'll be buying the difference. We'll be increasing from that 13% to say about the mid 50%. We'll be buying the energy that's coming back to our system that isn't rate 16. So of all that energy that comes back to our distribution system, we will not be counting that energy that is bought under rate 16, or the energy that, as you mentioned, is used contemporaneously.
Well, if that's the only two types of energy, then what energy are you talking about?
The portion that we're buying is getting us from the 13%. 13% is just the rate 16 purchase power, getting us to about the 50%, which is that net energy metering portion that comes back to our system and gets credited on a one-for-one basis on their bill at the end of every month.
See, and that's what I don't understand. If there's only two types of energy that's actually produced by the DG generator, and it's the energy the energy they don't use themselves, which they sell to you, and the energy they use themselves, then what would be left for you to buy?
Oh, okay, I'm sorry. So let me be clear. So on the energy, I would see it as three buckets. The one that they self-consume would be number one, as you mentioned. And the energy that comes back to our system, I would put that in two separate buckets. One that we're able to use now for RECs based on the new amendments, which is at under rate 16. And the portion that we're currently not able to use as a result of the amendments, where it's energy coming back to our system, but we're no longer being able to buy those RECs based on our interpretation of the amendments.
Does the energy that they self-consume go on the EPE system?
No.
Then what is there to buy?
It's the difference between, so if you would imagine about 55% of the energy that they produce at their homes will get pushed back into EP's system. The only portion of the RECs of that, say 55%, that we're able to claim currently under the amendments is about 13%. So we're looking to buy the RECs, specifically the RECs, of the difference between that 13% and that 55%. So that energy that comes back into EPE's system, but isn't bought under rate 16, but it is being credited for them under net energy metering.
Why aren't you able to buy all of the energy that they're not self-consuming?
Well, we're purchasing it, and we do believe we're purchasing under NEM, but just under the, I guess, a reading of the amendment, we see it as we're only able to claim the RECs for the portion under rate 16. So we're trying to be able to increase that to also get the RECs for that rest of that portion, that about 40% or so that we do get back to our system, but it isn't bought currently under rate 16.
So you're saying that they put energy into your system that you're not buying?
We're buying it via NEM, so I do feel like we're purchasing it because they get a one-for-one credit on the based upon that type of net energy metering, but we can't claim those RECs based upon the amendments to the DG 2572 that occurred last year. The way we interpret that amendment change is that we can only claim those RECs that were bought under rate 16 or 13%, although we are getting much more energy delivered to our system, about 40% or so.
So it's not about timing then.
I don't see it as much about timing as much as it is about the wording and the amendments talking about a pricing scheme. So we wanted to apply a price to the RECs, those additional RECs that I've described, so that we're able to purchase them ideally at a low price, and it is a much lower price than the other procurements that we'll talk about today, so that customers can take the benefits of these lower priced RECs in order to meet REA standards.
Again, I wondered if it had something to do with your language in your testimony on page 26 at line 7, where you say energy delivered to EPE system, i.e., not consumed contemporaneously on site.
That's correct.
So
Go ahead.
Oh, well, so to me that meant, okay, if they're not using, if they produce X quantity today, but they're not self-using all of X quantity today, and that gets pushed into the system, but tomorrow they used more than the quantity that they made, then somehow the timing of when they used it and when it was actually put into the system at the end of the month, when you looked at that was the energy that extra energy that you were buying based on your not consumed contemporaneously testimony. Is that not right?
So let me clarify on the timing. I do see the issue there. It's confusing. It's on the timing. We just wanted to more so address the timing as well, and we went into it in my rebuttal testimony with regards to responding to staff's testimony. And I believe that some could understand that the Rule 570 meant that we could only count RECs that were used after the netting process, after the per month billing. So at the end of the netting process, which would really be just those, again, going back to those RECs that we can buy under rate 16 if the customer produced more than what they self-consumed. But we wanted to be very clear that beyond just that monthly end of month netting, we wanted to be able to purchase all of the energy that was sent back to our system in real time beyond that monthly end of month netting process.
Okay, thank you, Mr. Novella. I'll have to think about it because basically it just looks like to me that there's two kinds of energy, the kind they use and the kind that they put on the system that you buy. And the change in the rule says you can't get RECs for the kind that they use, correct?
That's correct.
But yet that seems like that's what you're trying to do. With your program is that you're just saying, okay, we're not taking them now, we're going to pay for them, but basically it's the energy you've been told that you can't get RECs for, and now you want to try to get RECs for them.
Based on
Is that not correct?
The way I understand the change, the amendments to the 572, Madam Hearing Examiner, was that we can propose under an alternative pricing scheme a method which we can acquire additional RECs, and that's what we wanted to propose here is a low cost option to acquire RECs that are already being produced in the state of New Mexico by our customers and that are already getting pushed back into our system, which wouldn't be to your point, it wouldn't be 100%. There would be a bucket that they're self-consuming, but there would be an additional amount of RECs that we could claim if we offered an alternative pricing scheme per the language in the amendments.
Okay. Thank you, Mr. Novella.
You're welcome, Madam Hearing Examiner.
Ms. Stevens, you have some questions for Mr. Novella?
You're on mute.
I'm sorry, I had the screen. I'm trying to put too much on the screen. So good morning, Mr. Novella. How are you?
Good, yourself?
Good to see you again. Thank you. I'm a little confused here because I have too many things going on my screen. But let me, and at risk of getting myself totally confused, let me pick up with the hearing examiner's questions. Would you please turn to CLC Exhibit 12?
What is it?
It is a group of responses to city interrogatories 3-1 through 3-5 that were sponsored by Mr. Novella, the responses. And
Okay.
they
File.
relate. Yeah, do you see them? You have them?
I have Exhibit 12 open.
Okay. And these are your discovery responses with questions regarding the excess net energy, and particularly in response in regard to the terminology used in the company's response to the bench request order, which is now Commission Exhibit number 1. Is that right?
I'm looking through them. That's right.
And I'll take you specifically to the response to 3-1C. It's on the second page of the PDF. Are you looking at that answer? Is it true that EP has never submitted any type of filing with this commission or otherwise, or report where it measured or reported energy related to GG facilities in the manner in which it's proposing to separate that third bucket that you just referred to with the hearing examiner?
Let me read the Q&A.
Yeah, please do.
Which page, Ms. Stevens?
It's page 2 of 21 of the PDF, and the question he's going back to is on page 1. 3-1B.
Madam Hearing Examiner,
Yes, ma'am.
I would object to the question. I think Ms. Stevens can ask Mr. Novella to verify his answer to this discovery response is accurate, but I hear Ms. Stevens asking Mr. Novella to verify her characterization of Mr. Novella's answer to this response.
Madam Hearing Examiner, I'd be happy to just admit this exhibit as is. And I was afraid that if I asked Mr. Novella just to say this is your discovery response, I'd get an objection. But they are his discovery responses, and they are related to the questions raised in the bench request.
I don't object to this discovery response coming in as evidence.
Okay, so you're
okay.
offering CLC Exhibit 12 as bench request responses from El Paso Electric regarding the commission's bench request. Is that correct?
Yes, I am. Earlier than I thought, but yes, the city moves to admit CLC Exhibit 12.
Any objection to what's been identified as CLC Exhibit 12 as previously identified? Hearing no objection, CLC Exhibit 12 is admitted.
Thank you.
Go ahead, Ms. Stevens.
Okay.
Questions for Mr. Novella?
Yes, let me find my. So let me go back. I would like to. I'm going a little bit out of order here to pick up on what the hearing examiner was asking you about. Would you please refer to CLC Exhibit 17, Mr. Novella?
What is it?
That is a response, the company's response to CLC interrogatory 1-30.
Do you have that, Mr. Novella?
Yes, just open.
Are you ready, Mr. Novella?
Let me read the Q&A, ma'am. Okay.
Okay. And it is it consistent with your discovery response here? Is it your position and the company's position that the DG, this is a little bit off what the hearing examiner was asking, but that the DG rec purchase program proposed in this case is not subject to requirements for a proposed procurement in section 6216(4) of the Renewable Energy Act, because it is not a procurement, quote unquote, procurement as defined under Rule 572. Is that the company's position?
Yes, that's my understanding.
Would you like to explain that understanding a little bit?
With advice from legal based on Rule 572 and the proposal that we had here just didn't fall under 572 as a procurement.
Isn't the purpose of this case to present the company's proposed procurements under for approval?
Sure, but this is very different than seeking a new facility where I already have the energy within the state being produced by our own customers, and we're not seeking to buy any energy. We're just looking to purchase the RECs under this new pricing scheme as worded in the amendments, the 2023 amendments for 572.
The city moves to admit CLC Exhibit 17.
Any objection to what's been identified as CLC Exhibit 17? The interrogatory response.
No objection.
Hearing no objection, CLC 17 is admitted. But just so I don't lose the point, Mr. Novella, because I also had that particular question, and but I thought it was through a different witness. But the thought came up to me similar to the question that Ms. Stevens was asking, and I didn't know which word I needed to focus on. Was EPE trying to redefine procurement or new procurement or all of those things?
I got advice on legal with regards to it not being defined as a procurement under 572, but I understand that this would just be a very different type of request from what would typically be considered a procurement, purchasing the energy type of contract. This is already buying existing energy, and I'm sorry, not buying the existing energy, buying the RECs for existing energy, and it wouldn't fall under the typical procurement definition that you would see under 572.
But you call it a procurement. all the witnesses call it a procurement,
I
right?
think that's correct. I think it just makes it easier a bit to understand with regards to purchase, bringing these recs online to help satisfy our 2024 plan.
Well, I mean, you got to understand that. I mean, if you're, if you're calling it a duck and then you're saying it's not a duck, that it's kind of confusing for your audience.
Yes, and I think what we wanted to also highlight, Madam Hearing Examiner, is that the price on these is so low that it's not even comparable to alternative procurement says. That's why we have that second half of the answer. I think when we start looking at the requirements of 570-200 procurements, one thing is to look at costs and to make sure that they're reasonable. And here it's just so low that we wanted to highlight that this is something that's very different, because again, we're not buying the energy, we're just buying the associated recs. So something that we see as very different from a typical procurement.
Thank you. Go ahead, Ms. Stevens.
Yeah, Mr. Novella, could we go back to CLC Exhibit 12 and this time look at your response to CLC 3-2? And I'm going to that would be on page 4 of 21 of the PDF. No, wait a second. No, I'm in the wrong place. It's the answer. It's on page 5 of 21. And the answer, I'm looking at C, and I'll ask the question and ask you to read the answer. The question was, with respect to QFs or GG customers that elect the net metering option, provide copies of EPE's general ledger, financial accounting statements, reports to the NMPRC, the FERC, the PUCT, and the Securities Exchange Commission that demonstrate EPE's treatment of all energy that is delivered to its system from QFs as purchased energy. Explain the manner in which each such transaction.
I'm sorry, explain the manner in which.
Each such transaction, including the purchase by EPE and the financial credit given by EPE, is shown in each such set of documents, is reported and treated on the agency's forms for reporting of energy sales, energy purchases, and related revenues and expenses. At minimum, provide such documents covering the period from 2018 through 2022. And if you would read aloud your answer, which is shorter than the question, and then we can talk about it, I'd appreciate that.
You'd like me to read?
Read it out loud so everybody can hear it.
Not all energy that is delivered to EP system from QFs is purchased energy. Only the net metered energy over a billing period, i.e. the energy supplied to EP by the QF exceeds the energy supplied to the QF, my apologies, by EP, is purchased by EP pursuant to rate number 16, purchase power service. Those purchases are recorded in FERC account 555 and are reported by EP as purchase power costs to public available, as purchase power costs in publicly available reports. The financial credit effectively provided to NEM or net energy metering customers is not quantified and recorded in EP's records, but it is the result from lower levels of sales recorded in FERC accounts 440, 442, and 445.
So, Mr. Novella, did I miss, is there somewhere, anywhere in regulatory, not just PRC, but other regulatory entities where this, your proposed treatment in this case of the energy that is delivered from a QF facility into the company's system and then credited back as delivered energy during the month, that it is shown as a sale of as a purchase by EPE and then a consequent sale to the customer.
I'm sorry, that was a bit long. Do you mind
Yeah.
just kind of
So
restating that?
is there any regulatory or accounting format that we would ever see this treatment that you're proposing in this case, where we're in, as I understand it, you're saying that the energy is sold to EPE by the QF at the time it enters into the system, and then is purchased back by the customer at the time that energy goes back through the meter. You know, say in the daytime it goes into EP's system, in the nighttime the customer is taking off of EP's system. Is there any
I'm not following your logic or question there.
is there any, I'm just asking, is there any reported documentation anywhere that supports the company's theory about this financial credit being a purchase of energy? What there being a purchase of energy, renewable energy by the company that coincides with these RECs that you wish to purchase?
I'm not sure I'm following your question, but I will say is that it's pretty clear that we're buying this power under rate 16 and other energy that these customers deliver to our system. They're getting paid in a 1-for-1 credit at their full retail rate that offsets their bill and produces a lower bill. And as this answer says, reduces the FERC accounts 440, 442, and 445.
I'm saying, is it shown anywhere as a transaction that's a sale and a purchase and then a sale? That's all I'm asking.
Well, to me, it's you're seeing that math done every month on their net energy metering bill, where they're getting that transaction and that credit is being shown on a 1-for-1 basis every month that occurs. They produce more than what they consume, and they'll get it offset of other time periods within that month, and they're able to benefit at the full retail rate for that exchange.
Would you please turn to CLC exhibit number 10? And that's the company's response to CLC 6-12. And the key element here is that there's an attachment with, are you with me?
Just open.
I don't want to rush you.
It's open, ma'am.
Okay. And you can read the question and answer if you'd like, but I think if you turn to page 3 of 24 of the PDF, since I know that you're the chief economist always, or forecaster for the company, that you'll recognize this as the company's long-term forecast of retail sales in megawatt hours, correct?
That's right.
And these New Mexico numbers, the lower half of the lists, do they include retail sales of the type that you're talking about, that the company sells energy back to the DG customers?
Let me look at the Q&As just to make sure I'm understanding.
Yeah,
Okay, I read it. What was your question?
The question is, on the lower half here, the New Mexico numbers and the New Mexico totals, do these include as retail sales these amounts of energy that go back to the DG customer through net metering, and are what you're calling part of what you call a financial credit?
I'm not sure I fully understand your question. So these would be the load requirements for these specific groups over these specific time periods that
Right.
EP has to deliver.
Okay. Do you do these let's use the delivery term then. Do these delivered numbers, I mean do these delivered numbers include the amounts delivered back through the net meter during the month to a DG customer that are reflected in this credit mechanism as you describe it, net metering?
So these will be billed retail sales that EP has to deliver, and it's based upon a historical time series of data, and it's forecasted in an econometric model for all of these different categories. And the history of it would be their overall billed sales that they incurred. So for example, New Mexico residential would be a history of their billed retail sales, and that would be the primary input to run an econometric model, say with weather, the economic variables, so you could get to a forecasted amount. Now, the history of these numbers are lower or depressed because these customers have solar facilities on their rooftop. If they didn't have a rooftop system, EP would have higher load requirements in their historical data set that it's using to forecast this period out.
Can I put that in simpler terms and saying that no, these numbers do not include the amounts that are associated with the DG RECs that you're proposing to purchase in this case?
It is lower as a result of the energy that they're self-consuming. On the incremental portion, it would not be reduced for that amount, but that reduced amount, or that would be captured more in allocation, not in forecasted sales.
I don't think I followed that answer. I think simply the one, let's use 2024 because that's the year of the plan. That 1,781,700 megawatt hours for New Mexico. Does that include what is the number you're using for DG RECs? Would that include or exclude the new group of some 40-something thousand DG RECs that you are proposing to purchase as the net excess metered amounts that go into the system and then go back out of the system?
There would be an auto model adjustment to the future period to
I'm
reduce
sorry, please repeat. There would be a,
out of model adjustment done in the future periods to account for that energy that is self-produced and consumed directly by the consumer.
And when you say future periods, that would include the years that we're talking about in this case, the 1.781 and 1.792 million figures. Those are adjusted for those amounts.
I'm sorry, I didn't get your whole question.
Those
I have-
are
Wait. I want to tell you where I left off.
Oh, sorry.
So, and when you say future, hang on. Future periods, that would include the years that we're talking about in this case, the 1.781 and the 1.792 million figures, the large.
I'm sorry, large?
That's right.
You
guys are talking over each other and it's making a mess of my record and I want to make a clean record for you.
Thank you.
So I don't know. I'm asking you to clarify it.
Okay. So those two numbers that the court reporter just read back, those have been adjusted for the fact that you're not counting the 40,000 some amounts that you are seeking to associated with DG Rec purchases, correct?
I'm not sure on those amounts. Let me say it this way. It's in future periods, El Paso Electric makes an auto-model adjustment to reduce forecasted energy sales downward by the amount that we estimate new and incremental DG customers will self-produce and consume in their homes.
And in that adjustment, self-produce and consume in their homes includes both the on-site contemporaneous consumption that never goes into Epe'S system and the net metered consumption, correct?
No.
No.
So again, they're going to use less energy because they have a solar system, but EP is still delivering that energy to them that is being net energy metered. So it's still delivered to that customer.
And is that the amount that's delivered through net metering, is it included in this figure of 1 million, the 2024 bottom line figure? Is it included or excluded?
I'm sorry, I guess I'm not following you.
The amount that the adjustment that you just spoke of, has that adjustment been made to reduce the 2024 New Mexico total figure?
No, I believe what I'm describing is what their load requirements are less because they have a solar system. With regards to that banking or that netting, I would need to check the exact mechanics behind it, but I would imagine that since it's still delivered to the customer, it's included as part of that number.
So looking again at this exhibit, when it says total retail sales, are you treating that as a sale, or are these the numbers that you expect to actually sell, make money on, charge rates for?
Yeah, again, we reduce it to account for their load. I'm sorry, to account for their DG systems. Anything that we expect to still have to deliver to them is counted as part of these numbers.
And when you say we expect to deliver to them, you mean incremental deliveries that the company needs to supply from its own resources? Is that what you mean?
Yes, to deliver.
I think I've got it now. Thank you. City moves to admit CLC Exhibit 10.
Any objection to what's been identified as CLC Exhibit 10? El Paso Electric's response to CLC 6-12A.
No objection.
Thank
All right, hearing no objection, CLC Exhibit 10 is admitted.
Ms.
Ms.
you.
Stevens?
Yeah, I'm still trying to get back to the start of my plan cross-examination. So let me try one more question here, if I can find. Okay. We've got 12, we've got 10, 17. So during your answers to hearing examiner Hurst, you referred to the concept of you referred to Rule 572 and the concept of exceptional transactions, and under that rule, particularly 72 Rule 779, 72, 17.9.572.10C3, correct? That was what you were alluding to?
Can you point me to where that's in my testimony? I don't recall.
Yeah, let me find you in your testimony. It's actually in your direct and your rebuttal, Mr. Novella. But let's take a look at both, and let me find my notes where they are. So page 19 of your direct, please. This is where you actually quote the statute, the rule, in some lane. And I'm not moving quickly enough.
Okay, I'm on page 19.
Okay. And then again, in your rebuttal testimony, EPE Exhibit 2 at page 19.
Okay, I'm there.
Yeah. Now you read Ms. LaRocque's testimony on behalf of the city because you rebutted her testimony, correct?
I did read it.
You did. Okay. Do you recall that she pointed out that when you quoted that rule, the rule 10.3c, you omitted the first sentence of that subsection of the rule?
No, I don't recall that in her testimony.
Okay, and you didn't. So, when you were reading it fresh and writing your testimony, did you respond? You didn't respond to that point in your testimony, in your rebuttal testimony, did you?
I don't recall responding or reading that line.
Okay. Would your testimony about the usefulness of EPE's proposed rec purchase program change if you had taken into consideration that rule 572-10C3 begins with the sentence, for any rec that a public utility claims to own pursuant to the exception stated in subparagraphs A, B, and C of paragraph 1 of subsection 62.16.5 NMSA 1978, the public utility shall have purchased the associated energy.
Madam
No,
Ms. Olson?
I apologize. I object. I don't think Ms. Stevens asked Mr. Novella if his testimony addresses the full provision of the rule.
Okay,
Okay. May
First,
I
ask
just
him,
address
yes.
that?
Absolutely. Ask him if he addressed that section.
Yeah. Mr. Novella, when you twice in your testimony in your direct and your rebuttal, copied down the subsection C3 of part 10 of the rule. Did you deliberately omit the first sentence of that subsection of the rule?
no, I don't believe so. I believe I got the section that was pertinent to what we're describing and discussing.
So you did choose to take less than the full portion of that subsection? Is that what you're saying?
I don't recall what I was thinking exactly as we pulled it, except for that this is the section that is responsive to the proposal that we're making.
No, my question is, did you choose to not include the entire subsection 10C3 when you were writing your testimony?
I don't recall the entire 10C3.
Are you aware that there is more of 10C3 than what you quoted both times?
Yes.
Okay. And then why did you not include it all?
I believe because we got the portion that was pertinent to what we're describing here, where it's talking about a different purchasing scheme, which is again what we're offering here is a low cost purchasing option to get these DG Recs program and use them to be able to satisfy our 2024 plan.
And when you're talking about those different purchasing options, you are referring to the language here about subsections A and C of paragraph 1 of subsection B of section 62.16.5. Is that what you're referring to? The purchasing option?
Can you restate your question?
Yeah. So when you say that what's relevant, you are testifying in your testimony, and not just this portion of it, that what this different purchasing option is supported or justified by subparagraphs A and C of paragraph 1 of subsection B of section 6216(5) of the Renewable Energy Act. Is that correct?
I'm referring to that portion because I mentioned purchasing scheme because I use that language, and that's pursuant to those subparagraphs you listed.
Okay. And given that those are the relevant subsections, is it the company's position, is it your personal position that the first sentence of the rule, which says that for any rec that a public utility claims to own pursuant to the exceptions stated in subparagraphs A, B, and C of paragraph 1 of subsection B of section 6216(5) NMSE, the public utility shall have purchased the associated renewable energy?
Well, as you're saying it, I don't see any issue. I mean, we are purchasing again all this energy. We're purchasing this energy either under rate 16 or on a 1-for-1 basis through net energy metering. But again, in practice, we'll cite rules or statutes, but sometimes these can be pretty lengthy, or we'll take the excerpts that are pertinent to what we're describing and discussing. In this case, I believe I got that section, and I put that section here in my testimony.
So basically, you're saying that the company is purchasing that energy. Your position is that the company does purchase the energy that's associated with the RECs that this proposed new REC purchase plan would acquire on behalf of the company.
Yes, the company is a forced taker on this energy as a customer is producing energy and pushing that energy into our distribution system. El Paso Electric takes that and again credits it on a 1-for-1 basis, even at times where El Paso Electric might not even need that energy.
Okay. Let me try to go back to the start of my notes. Okay. We'll move on from the DG Rex question. Okay. So as the company's policy witness, Mr. Novella, are you familiar? Obviously, the Hecate PPAs are important to the whole concept of a contingency plan in this case, correct?
Yes, very important and central.
Would you please refer to CLC Exhibit 2, which is the Hecate 1 PPA?
I'm sorry, can you say the exhibit number again, please?
CLC 2. You can just pull them up I hope they show on your thing consecutively. 2, CLC 3, CLC 4, CLC 5.
You want me to open multiple?
Well, you can go one by one, or I just would like you to take a look at them and acknowledge that those are indeed the agreements, the original agreements, and the amendments to the original agreements of Hecate 1 and Hecate 2.
I'm sorry, can you be more clear? What exactly do you want me to open?
I just open CLC Exhibit 2, please. We'll do this one by one.
Okay, it's open.
Madam Hearing Examiner, Ms. Stevens, I'm not sure that Mr. Novella is the appropriate witness to be asking questions about the PPAs. So it suggests you start by asking him if he has knowledge of these agreements. He did say, I believe he did say he does. And Ms. Olson, I don't intend to ask detailed questions about this. I just would like him to be the sponsor, since he's because I guess I've been told that maybe Ms. LaRock shouldn't be the sponsor. Just would like to get the contracts into the record. Right. Mr. Novella is not the appropriate witness to sponsor these contracts. Those are resource planning documents.
Well, let's let him answer, Ms. Olson.
Yeah, because he's.
Are you familiar with this document, sir?
No, ma'am.
Let me try something else, Madam Hearing Examiner. Would you please turn to page 24, lines 17 to 19 of your rebuttal testimony?
What page?
724.
Okay.
Okay, I'm on page 24.
On line 17 to 19. And you give your testimony about EPE's obligation to follow the terms and timelines of the NMPRC approved PPAs. And then you talk about understanding that that's being done. So are you familiar with these contracts?
No, in fact, the last line says that you could address Mr. Sheetzel about these items. And just for clarification and rebuttal, we brought in two EP witnesses, Mr. Bryn Davis and Mr. James Sheetzel, specifically to help answer questions on Hecate.
Well, I will do that, Mr. Novella, but I think I'd like to, now that you've raised the question here, given that your testimony is all about the necessity for a contingency plan, if it's not based on the terms of the PPAs, what is your position about the need to completely eliminate Hecate for all of 2024 based upon?
Well, again, we're providing a contingency plan because we want to provide a plan that is successfully compliant under the REA for 2024. Now, with regards to Hecate, the timing, and those types of questions, I wouldn't have any knowledge on those items. And those would be, for Mr. Bryn Davis and Mr. James Sheetzel.
Is it not your testimony that the contingency plan is necessary or appropriate because the company has concerns that its previous commitments to have Hecate online by June 1st, 2024 are at risk?
Madam Hearing Examiner, I'm going to object to this. Ms. Stevens has now asked the same question multiple times and Mr. Novella has answered it. She may not like the answer, but that's the answer he has.
Well, I think you're wrong, Ms. Olson. So I'm gonna overrule your objection because I'm looking at Mr. Novella's testimony on page 16, where he specifically says, due to delays in commercial operation of the Hecate facilities, EPE, and then he goes on to testify about it. So if he has no knowledge of that contract, then how does he know when the commercial operation date is?
Maybe you could ask him that.
How is it, Mr. Novella? Are you picking and choosing of what you know here?
With
I mean,
regards,
you say you don't know anything about the contract, but yet you testify on page 16 of your direct testimony that you know there have been commercial operation delays. If you didn't get that information of when the commercial operation date was from the contract, where'd you get it?
thank you for the question, Madam Hearing Examiner. And over the last several months and years, this has been a constant item that we've worked on with the amendments, the PPA amendments over last year and the year previous. And I have seen delays in Hecate previously. It's been delayed, I believe, at least once before. And I understand that and know that because I'm a part of several meetings with our planners and they've discussed and talk about the COD dates for these facilities. And in fact, I believe in my direct testimony, I have a table with the current COD dates of a lot of these facilities. And I just understand that they have been pushed back at least once previously. And I know when their current COD date is, but I didn't work at all on the Hecate project with the PPA contract. I've actually never opened it or looked at it. And I just don't have any knowledge about it. That's generally done with the resource planning group.
Wait a second. That's fair, Mr. Novella. I mean, if you've only gotten your knowledge in your position, if you only have knowledge from meetings, and not from looking at actual documents of projects. If that's your testimony, right?
That's correct.
Okay, well, I think he's answered the question then, Ms. Stevens. You're gonna have to find out about contracts and amendments to contracts. He has no knowledge of them.
May I ask one other attempt?
Not related to this, you can't,
No,
no.
I can't. Okay, because I was just hoping that as the company's lead witness, he can attest to something being a company signed document of the company. That's all. I'm not going to ask him
Well,
questions about the content.
all right, you can
that
ask about a
permissible?
different document.
What, pardon?
You can ask about a different document, but not the PPAs and the contracts.
Okay, all right.
He's already said he has no knowledge.
No clue. Okay. Would you look at page 9 of your rebuttal testimony?
Okay, I'm there.
Come on, Ms. Stevens, let's
And-
move along.
Okay, and your testimony here in the lines 10 through 12 indicates that the objective of that the opposition to the contingency plan is in contrary to the objective of the REA and Rule 572 to present a procurement plan to meet RPS obligations in the upcoming year. Is that correct?
I would qualify that specifically for Ms. LaRock. I believe you use languages.
Well, okay. Do you believe that the objective of the REA and Rule 572 is to present a procurement plan to meet RPS obligations in the upcoming year?
I think not just to present a plan, but to get it done, to present something that's reasonable and can occur. And that's what EPA is doing here with this contingency plan.
And under this contingency plan, and then on page 17, flipping through here, page 17, lines, notes here, page 17, I'm saying same place. Line 17 through 19 of page 9, you refer to the contingency plan as being for the purpose of providing alternatives to meet RPS obligations under the most plausible contingencies. Is that correct?
Let me read that section. Did you say 17 through what?
Line 17 through 19. I need to go back.
I'm sorry, Ms. Stevens, what page are you on?
Back to 9.
Line.
I got myself confused, but we're back to page 9 of his rebuttal. Actually the phrase is the last line on the page.
Okay, I read it.
Okay. So is it the company's position, therefore, that the most plausible contingency or outcome is that the Hecate 1 and 2 PPAs, which have already been delayed from their initial COD of May 2024, will not provide any energy at all during the entire year of 2024, despite amended CODs approved recently by the Commission that are as of June 1st, 2024. Is that the most plausible contingency?
Well, I'll say this. When we look at a plan year, it's forward-looking, and a lot of things can happen that can change a plan year. We'll have different retail sales. We'll have some projects that come in on time, early, late. So there's a lot of different items that can occur. And this is one of those items that we've highlighted because we've seen projects being delayed, and this can possibly occur. And that's why we're filing this contingency. If we didn't believe that that was plausible, we wouldn't make this filing. So it is plausible, but again, this is a forward-looking analysis, so there's always items that can come up that are unplanned.
Well, lots of things are plausible, Mr. Novella. Is your standard most plausible as your testimony? The phrase that your testimony uses?
Recently, I mean, based on what we're seeing right now, I think it is very plausible. Two items have occurred, right? The change in the DG amendments and right now possibly the Hecate project being pushed back. And we just have to look at the items that are most likely to occur or can occur over the plan year and plan for them so we can effectively be compliant for the plan year under Rule 572. And I think we've done that, and we've packaged something that can get us there at a low cost for our customers. And that's this contingency plan.
On page, now let's talk about what makes it contingent. And your discussion starts at page 10, and there's on page 10, line 10, and I'm picking up on the sentence that says this 50 lines 15 to 16. This concern, Ms. LaRocque's concern, is that this concern misunderstands EPE's proposal and the nature of contingency planning.
Okay.
Referring to your direct testimony now on page 8, at page 28, line 17 to page 29, line 4.
I'm sorry, Council, do you mind first just saying again the page and the numbers?
Yeah, back to the direct. I'm looking at page 28 at the bottom, well, page 28 near the bottom, 17, and I'm not quite there yet. This is the sentence that begins with on line 17, if approved by this commission, EPE will temporarily reassign solar energy. Pick that up.
A page and number, please.
Yeah, this is your direct, page 28, page 30 in the PDF that I'm looking at.
And the line?
Line beginning at line 17, and the beginning with the phrase, if approved by this commission.
Okay, I'm there.
Okay, and then carrying over into the next, the rest of the answer in the next page. In your original testimony, you were proposing that an additional 8.69% of the output of Buena Vista 1 would be initially assigned to New Mexico customers with additional assignments as needed. So the intent there was that this assignment, reassignment, reallocation, whatever you would like to call it, would begin at the start of the year, correct, with the approval of this plan?
Let me read that section.
Yeah, please do.
Okay, what was your question, ma'am?
Okay, and under your original testimony, I'm also looking at line 21 on page 28, carrying over to line 1 and 29. Your original testimony, is it correct for me to read for us to read your original testimony as saying that at least an additional 8.69% of Buena Vista 1 output would be reallocated to New Mexico from the start of the plan, improved in this case, presumably January 1st, 2024, until EPE's new resources, Hecate 1 and 2 and Carne, are commercially operational? Is that the original proposal?
Well, just generally, the proposal is going to be using this BV1 reassignment to make up just in 2024 for any energy that doesn't get produced by the Hecate project.
And I want to get into the specifics of how when, why that would be done, when it would stop, when it would start, okay? Because you're calling it a contingency plan and saying that it's contingent upon Hecate not coming in on time. So just, would you please answer the question? Would, under your original testimony, would the reallocation of Buena Vista 1 start at the beginning of 2024?
I believe that's correct. And for those detailed type of mechanical questions that you were mentioning, I would ask that you ask Mr. Victor Martinez. He can best answer those detailed questions.
Okay, let me turn you to CLC exhibit number 6. That's one that you and Mr. Martinez sponsored. That's El Paso Electric Company's response to CLC interrogatory 1-16. And do you see that you're a sponsor of that answer as well as Mr. Martinez?
I do see that I'm a sponsor.
Okay. So at that point in time, was your intention and expectation that the reallocation of Buena Vista 1 would begin at the start of the year and might be altered based on the timing of the Hecate project coming online?
Madam Hearing Examiner, I'm going to object to this question on 3 grounds. 1, I think Mr. Novella has already answered the question. 2, I don't know that his direct testimony on this and his initial testimony is relevant because EPE clarified its position in rebuttal, as Ms. Stevens has pointed out. And 3, Mr. Novella already told Ms. Stevens that with respect to the mechanics of the reallocation, Mr. Martinez is the more appropriate witness.
Ms. Stevens?
Madam Hearing Examiner, first of all, yeah, I mean, I want to get, I need clarification on his clarification in his rebuttal. So I think my purpose of asking the question is to clarify what the company originally asked for, so that then we can compare to what the company is now asking for. So that's one point. Secondly, both in his direct testimony and his rebuttal testimony, Mr. Novella is the primary or possibly even the sole witness on the kind of the conceptual issue of what is a contingent program. Yes, it's true, Mr. Martinez gets into the weeds a little more, but the question is going to a conceptual idea of what is a contingent plan. And thirdly, he sponsored this response, so I think he knows what he's talking about.
May I respond briefly?
Yes, ma'am.
I think the witness has told you who you should be directing questions as to timing and specific energy allocation. If you're asking conceptually about a contingency plan, I agree that's within the scope of Mr. Novella's testimony, but that's not the question you're asking. You're asking about the specific details of when EPE plans to start the allocation, and Mr. Novella explained that is within the scope of Mr. Martinez's testimony.
And I do believe that the question is repetitive. I believe it has been asked and answered. So I will grant your objection on that basis. And if you have a different question, Ms. Stevens, as you related about conceptual contingency, you may ask that question. Or this particular exhibit.
Okay, first of all, I'll move to admit CLC Exhibit 6, because I am going to ask him about the difference between Buena Vista and Hecate.
I'm not sure that CLC 6 discusses a difference between between Hecate and Buena Vista. But I don't object to admission of that exhibit.
All right, let's see. Mr. Novella, you helped answer CLC 6.
Yes, I reviewed it. Mr. Martinez prepared it.
Do you think it's accurate?
Yes.
Okay, there's no objection to CLC 6, so I'll admit it. Ms. Stevens,
Thank you.
how many more questions do you have?
I have, give me a few, I may have a second here because I jumped around in my own notes because I wanted to follow up.
I'll
on
tell
your
you what,
questions about the DG Rex. I think that,
while you're looking, I think we're going to go ahead and take our morning
Okay.
recess. I don't want I don't want to wear down our court reporter here.
Yeah, okay. Yeah.
Right now. So I've got 10:42 on the computer. We'll take a 10-minute recess. We'll come back at 10:52.
And I'll take the opportunity to trim it down.
Okay.
Thank you.
Right. Remember, we're still live streaming on YouTube. Act accordingly, please. And we're recessed for 10 minutes. Okay. Okay, so I believe we are now returning from our recess. You have a few more questions, Ms. Stevens?
I do, and I'm horrified. I'm working on, hold on a second, my camera isn't working. Why am I?
Okay, I just want to tell you, I think when we spoke on Friday, you had indicated, let me find my notebook.
Oops, there it is. I think I said 2 hours for all witnesses, and then later I said more if it was I was gonna need.
Right. Well, you're already in an
exhibits.
hour and 15 minutes into your 2 hours.
Well, I hope you're not gonna hold me to this, because I am trying to get in all of Ms. LaRock and most of Ms. LaRock's exhibits. But
Let's go.
going, okay, Mr. Hello again, Mr. Nadella. I want to pick up where we left off, more or less. And that is turning to your rebuttal testimony. Is the company changing the nature, is the intent of the company's rebuttal testimony to modify the contingent nature of the contingency plan?
Can you point me to the section you're describing?
Page 11, lines 10 through 13, you state that Mr. Martinez's testimony clarifies that even if the contingency plan is approved, EPE will not reassign the Texas portion of Buena Vista One Energy and Rex if it does not require that reallocation to meet its plan year 2024 obligations.
Okay, that's correct.
So, I mean, and this is a conceptual question. I mean, are you trying to modify, clarify, narrow down what was originally proposed in terms of, as I was trying to ask you earlier, kind of the timing and duration of the Buena Vista One PPA reallocation?
I'm sorry, say that again.
In the rebuttal testimony, yours and Mr. Martinez's, are you trying to, is it the company's intention to somewhat modify what it originally proposed to make the use of Buena Vista One contingent on an actual known shortfall as opposed to a potential shortfall in REX for the year?
I don't think I follow your question, but just generally, I don't see a change from what we're presenting in direct rebuttal.
Okay, that's what I wanted to hear, needed to hear. I'm not sure. So, and quite my questions about when the reality. Well, let's start with one simple one. Is it correct that the Hecate, that the DG Rex program, the company's position is that would, if that's approved, that would be in place month by month for all of 2024?
It would start in January of 24 and continue to run.
Continue to run at least through 2024, and then you would reassess it in the next year's program? Is that the general gist?
Well, I would imagine that it's going to be continued to use beyond 24, but yes, it'll be in operation starting in January 2024.
And the Buena Vista One reallocation, is it the intention that would start at the beginning of the year, or as of June 1st if Hecate is not online?
Beginning of the year, and again, this is a temporary reassignment, so just for the plan year 2024.
But you're saying, if I heard you correctly, Mr. Novella, that this DG program is not temporary.
That's correct.
It's a permanent request.
I don't know about permanent. I guess so. It would be something that we would request, and it would continue until the commission would cease it existing. We, or at least I like the idea of it because it's such a low cost means of getting us our customers these recs that are already being produced within the state. It's much cheaper than any other option.
Go ahead, Ms. Stevens.
All right then. So now that we've kind of clarified the big outlines, do you agree that staff and the city also, in addition to questions about the legality of the program, also raise questions about the implementation of the proposed DG rec plan?
Can you point me to where you're referring?
Well, let me see. In your rebuttal testimony, well, actually, the problem here is that you say that you're rebutting staff and Ms. LaRock and Ms. Souls, not Ms. Souls at this point, but and then you discuss the legal issues, but not the practical ones. Was that a choice of yours not to rebut them?
I'm lost on where you're referring me to and what you're reading.
Let me find.
Ask a specific question, Ms.
Yeah,
Stevens.
okay. Let's see. Let me see here. Beginning in the beginning on page 17 of your rebuttal, if I can find that. Under the heading responses to arguments recommending denial of Epe'S proposed DG rec purchase program procurement. And if you just kind of scroll through that, do you see it's and then on page 21, you talk about City and Ms. Souls's issues on the DG rec purchase program. And
what's your question?
yes, did you respond to any of the practical objections raised by the city or Ms. LaRock, by city or Mr. Dunn for staff?
I'm very confused by your question. I guess, can you point me to something specifically?
Well, let's see.
I think
did Ms. LaRock, let me find you. Would you look at staff exhibit number 1, pages 21 to 22, which is Mr. Dunn's testimony, and CLC exhibit 1 is LaRock's testimony, pages 51 to 52.
Let's do one at a time.
Okay, one at a time.
Which exhibit did you want me to open?
Okay, staff exhibit 1, Mr. Dunn's direct at pages 21 to 23.
Okay, I'm at page 21.
Okay. Now, did Mr. Dunn question the idea of automatic enrollments into this program for individual DG owners?
Let's see. language on automatic enrollment on page 22.
Right. And do you recall whether Ms. LaRock raised similar issues in her testimony?
I don't recall.
Okay, it doesn't really matter. Would you please turn to CLC Exhibit 8, which is the company's response to staff interrogatory?
Well, wait a minute. Let's before we go there,
Okay.
does your rebuttal testimony, Mr. Novella, purport to rebut the claim that you've just been pointed to in the staff testimony?
I don't believe I, in rebuttal, discussed the enrollment. I know I discussed it in my direct testimony. And I can't recall exactly the issues that Mr. Dunn had with the automatic enrollment.
Okay, thanks. Go ahead, Ms. Stevens.
So following up on that, on page 17 of your rebuttal, under the heading of Roman numeral 5, response to arguments recommending denial of EPE's proposed DG Rec purchase program procurement. Are you saying that you only responded to some of the issues raised by these witnesses, Mr. Dunn, Ms. LaRock, and Ms. Souls?
Well, I definitely replied to what I believe is the key issues at stake for this item, which is if it's permitted or not.
Okay. Would you please again refer, because you testified to what it was, let me try having you look at CLC Exhibit 8. I'm sure that they've got your name on them, because otherwise I wouldn't have put them here. Is that one of your discovery responses about the automatic enrollment process?
It is a discovery response. I haven't read it. Over what theme?
Sorry, is this how you provided some detailed information about how the automatic enrollment would work?
Let me read it. Okay, I read it.
Okay. Do you agree that that's the company's in your position of how the automatic enrollment, how EP is proposing to implement the DG Rec program?
For enrollment, yes.
Okay. City moves to admit CLC Exhibit 8.
Any objection to what's been identified as CLC Exhibit 8? Hearing no objection, CLC Exhibit 8 is admitted.
And
Ms. Stevens?
if you would look to CLC Exhibit 9, Mr. Novella. I'm sorry. Oops. This also is regarding your testimony on the DG Rec program, is that right?
Let me look at it. Yes, it's about the DG Rec program.
And specifically, subsection B asked whether the company attempted to solicit offers from DG customers to sell their recs to the company, is that right?
Let me read
Yeah, B.
B. Okay.
B.
Okay, read it.
Okay. And was your response to that EP did not try to solicit individual offers from DG customers because that would be, quote, a monumental undertaking, unquote?
Correct. And the second half describes it just like being energy purchased under rate 16, where EP doesn't ascertain from each individual customer their interest to sell their excess power.
Are you aware of the origins of rate 16 and net metering, Mr. Novella, in federal law?
I don't know. Can you be?
Well, I don't want to be. Are you aware of PURPA, the Public Utilities Regulatory whatever Act of 1978?
Can you be more specific?
Are you aware of a statute called PURPA, a federal statute called
Yes.
PURPA? Okay. And is it your understanding that the nature of the requirement to purchase power from DG customers is essentially mandated by federal and then state law?
I'm not familiar with that detail.
Do you know whether there's any, do you believe that there's a commission rule that requires either EPE to purchase these sorts of recs that you're proposing from DG customers, or for DG customers to sell their recs to this utility to which they're connected by rule, by PRC rule?
I'm unaware of one.
City moves to admit CLC Exhibit 9.
Any objection to what's been identified as CLC 9? Hearing no objection, CLC 9 is admitted.
And then I'd like to take you back briefly to your direct testimony, Mr. Novella, which may have disappeared from my screen. In your direct testimony at page 24, this is what you've got listed as question or Q35. The question, are you with me?
Your page and line number, please.
Page 25 of your direct on lines 11 to 12.
Okay, I'm there.
Okay. And the question, which is conveniently numbered, I think that's a nice idea. Is EPE proposing an agreement to purchase additional eligible DG recs? And your answer is yes. My question to you is, do you understand the DG rec purchase program to be an agreement between the company and the DG customers to sell these RECs? Focus on the word agreement.
So I'll point you to my exhibit GNR, so you could see what the purchase, in this case, the proposal for the rec purchase is tied to.
I'm sorry, which page are you on?
Exhibit GN3.
GN3 in your direct.
That's correct. And when you're talking about agreement and what it's subject to, and for the rec purchase, you'll see the rate number 48 that we're seeking for approval in this filing. And this is the document or agreement that allows EPE to purchase the recs from these customers.
Okay, and my question, I guess, still is, if do you see the tariff as an agreement if the customers don't want to sell their recs to you?
Well, we made it clear, I believe, in testimony where I say that if a customer doesn't want to take part in this process, they can so choose so and decide to not take part in the process for the rec purchase program.
But your default would be that they would be into the program, right?
Oh, yes. It would greatly reduce the administrative burden from seeking each individual of thousands of DG customers. This makes much more sense.
All right. Think. I think one little question in your rebuttal testimony about the DG Rec program, and then we'll move on to Buena Vista. And that is on page 23. Page 23, lines 12 to 16. I'm not there myself, so give me a moment. '23. And here I'm looking at lines 12 to 16. Would you read that, please?
You want me to read that out loud? Or?
No, just to yourself.
Oh.
Just review that for yourself.
Okay, I read it.
Okay. And you're an economist with several degrees, aren't you, Mr. Novella?
Yes.
We're interested to see you in a new role, because so used to being the forecast guy. As an economist, can you explain to me why it makes a difference, why the administrative cost burden of a rec purchase program with a lower purchasing price is different from a rec purchase the administrative cost burden of a rec purchase program with a higher purchase price? I don't see that.
So in general, I guess just some thoughts on this paragraph. I think I agree with Ms. Souls in that we want to make this a low cost offering to our New Mexico customers so they can take advantage of these already existing recs that are out there, and we can use them for our 2024 plan. Now, we used the $5.40 because that was the only market rate that we could find. In this case, Mr. Martinez found that item, and he can answer specifics on the 540. Now, with regards to Ms. Souls' proposal of 1 cent per megawatt hour, it's so low that one thing that we have to analyze is that now we are creating a new line item on the bill, something that's going to be audited and checked by customer. That wasn't done in the past when they weren't being credited a price. And 1 cent is most likely much too low. I believe, and you'd have to check this with Mr. Martinez, but I believe we're getting about 44,000 megawatt hours, say, additionally for this program. So 44,000 megawatt hours at 1 cent per megawatt hour, you're looking at $440 to create a new line item on a bill that's got to be checked and so on. So it's just real low. It's one of those things that we'd have to look at and spend more time on. If the commission was interested in keeping this program and putting that at a price lower than the 540, say, it's just something that we'd have to look at it. What does it cost to introduce this type of new charging into our billing system and have that going forward?
Is the company proposing cost recovery for the in this application? And maybe Mr. Martinez is the person to answer it. Is the company proposing administrative cost recovery for this line item and the implementation process at $5.40?
I don't believe they are, but you'd have to ask Mr. Martinez what exactly all in goes into that price.
I'll move on to the turning now, going towards, actually, we're pretty much in the same place. Good. Page 20, next page, 24 of your rebuttal testimony. And this question and this answer, am I correct, allude to the potential remedies under the Hecate PPAs? Is that right?
Which question are you referring to?
Oh, I'm sorry. The question 31 from line 3 to 13.
And what's your question?
Just without reciting it all, does this question and this and this question and this answer refer to the Ms. LaRock's testimony concerning potential remedies under the Hecate PPAs that would allow EPE to recover RECs and renewable energy?
I'm sorry. I'm gonna have to read the Q&A first, and then maybe
Okay,
ask.
yeah, no, that's fine. Please do. I'm not trying to trick you.
Okay, I read the Q&A. Can you
Okay.
ask?
So is that question and that answer alluding to the possibility of contractual remedies from Hecate providing RECs and renewable energy to EPE if the COD is not met?
I'm sorry. I guess the question to me is just comparing the pricing of the two facilities.
So, okay, I will just, it's not worth taking the time to go back to Ms. LaRock's testimony. Let's move on to the Buena Vista. We're actually going consecutively now. It makes it a little easier. Let's go on to the Buena Vista reallocation. This starts on the bottom of page 25 of your rebuttal testimony.
Okay, I'm there.
Okay. In order to file testimony, to submit testimony specifically on the Buena Vista 1 reallocation proposal, Mr. Novella, did you familiarize yourself with the Buena Vista 1 contract and the amendment to it?
Madam Hearing Examiner, I'm going to object to this. We've already gone through this line of questioning.
No, I asked him about Hecate, not Buena Vista. This is different because Buena Vista is he's actually proposing a brand new procurement based on Buena Vista.
Ms. Olson, I think she's right. I think the first were Hecate. I think we're at Buena Vista now.
I withdraw.
Okay.
Mr. Novella?
Sorry, can you re-ask your question?
Yeah, did you familiarize yourself with the Buena Vista 1 PPA and Buena Vista 1 amendment in order to, prepare your testimony supporting this reallocation?
No, I've never read the
Yeah.
Buena Vista agreement.
Okay, well, then I won't ask you to sponsor them, but let's move on to say that it's your testimony on page 26, lines 7 to 8, that prior approval of the BV1 PPA for Texas is not a requirement in that jurisdiction. Is that right?
Yes, that's what's there.
Okay. And then you go on to say that EP has lines 9 through 11 that EP has described and highlighted to its Texas regulators several times about the Texas portion of the BV1 facility. Is that right?
That's right.
That you also testify, I believe, that you expect the costs.
Come on, Ms. Stevens.
I'm sorry, I'm lost track of
Question.
a quote here that doesn't seem to be matching. I have line numbers and everything. Oh, here it is. The first sentence here. EPE, your testimony at line 6 to 7. EPE expects the cost of the Buena Vista 1 facility will be formally approved in the company's next fuel reconciliation file or other Texas rate proceeding. Is that right?
Yes.
Does the company presently have a fuel clause proceeding pending before the Public Utility Commission of Texas, in which the Buena Vista 1 PPA is at issue?
We had a hearing yesterday on that, but that wouldn't be as part of that. That would be part of the next reconciliation period. They do them every 3 years.
Does the company have a general rate case pending where that would be brought up?
I don't believe there's a finalized rate case in Texas outside of the requirement where we have to file one every 4 years.
There is not one. There's no one, not a case pending in which Buena Vista 1 is at issue, is there?
A rate case? No.
General rate case.
No.
Is EPE recovering energy costs under the Buena Vista 1 PPA through its Texas fuel clause at the present time?
It's recovering it through fuel.
Huh?
Through fuel.
Through fuel? Is EPE recovering capacity costs for the battery storage through Texas rates in any way, shape, or form currently?
I don't recall. I know the storage was done slightly different, that I can't recall off the top of my head how it was structured.
As the Public Utility Commission of Texas.
I'm sorry, please repeat.
Has the Public Utility Commission of Texas authorized EPE to create an accounting order or regulatory asset for future recovery of Buena Vista 1 PPA costs?
I'm not sure that they have, or it needs to be done. Again, it'll be approved in our next fuel reconciliation.
You just said it will be approved. Are you speaking on behalf of the Public Utility Commission of Texas, Mr. Avell? Are you saying it's going to be proposed?
I expect it to be approved.
Does EPE's Texas fuel clause mechanism or methodology obligate EPE to include Buena Vista 1 costs allocated between New Mexico and Texas in a ratio of approximately 21 to 29% presently?
Can you say it again? I think I followed.
Under your fuel clause methodology in Texas, is the company obligated to maintain the 21%, 79% ratio that is the basis of the, more or less the basis of the 21% ratio that you're using for New Mexico in this case?
So that's the typical allocator, I believe, for that. Since it's a system resource, they would probably use an allocation based on energy.
And you said probably would, if it's not, my question was, is it mandatory under Texas statutes or the mechanism, however it's implemented, the fuel clause mechanism in Texas?
Mandatory. I don't believe it is. After seeking legal counsel on this entire proposal, one of the things we feel comfortable is that we're able to, again, temporarily transfer that energy from Texas to New Mexico, and we feel comfortable with that, and that we're supplying an option that makes Texas whole.
Does Texas's fuel clause methodology or some other rate mechanism require EPE to make Texas customers whole?
I'm not sure if it does, but it's the right thing to do.
Would you please refer to CFC exhibit number 22? And this is a series of responses to CLC exhibits 1-32, interrogatories 1-32 to 1-37. And the reason so many of them are in there is because they tend to refer back to later responses. And the ones that I'm particularly interested in, Mr. Novella, are the ones that have your name attached to them. And that would be 1-36. It's page 5 of 23 in the PDF.
Okay, I'm there.
And yes, would under the reallocation, would New Mexico ratepayers receive an additional 8.69% on an annual basis? And you supported a response referring to CLC 137. So then if you go to the next page here, even though it's Mr. Martinez is the sponsor, I assume that you're familiar with this rationale that he describes here.
Let me read it. Yeah, I'm not, this wasn't prepared or sponsored by me, and I'm not familiar with the level of detail. I might have read it, but beyond that, I would suggest you ask questions on this of Mr. Martinez.
Okay, I'll ask you a very general question then. The portion of the under the state of affairs in the regulatory state of affairs in the state of Texas, is the company, could the company lawfully sell in the market the portion of Buena Vista One energy that is not allocated to New Mexico?
Madam Hearing Examiner, I'm going to object to this question to the extent she's seeking a legal answer because Mr. Novella is not a lawyer. If she's asking his understanding as a regulatory witness, I'm okay with that.
That's a fine, clarification. Mr. Novella, as a regulatory expert, do you believe that the portion that isn't assigned to New Mexico under the approvals granted by the PRC could be sold into the market by El Paso Electric Company?
I'm not sure if it can be, but if it would, we'd have to make our Texas customers whole because it is their resource.
And it's their resource just because it isn't New Mexico's resource?
It's a resource because we procured it as a system resource. We've told them several times and shown it in CCNs that it's a Texas resource when it comes online and so on. So it's clearly a Texas resource. And currently, again, it'll be picked up and I expect it to be approved in our next Texas field reconciliation case.
Okay, I have three more questions, I think, here. And that is, since you're the sponsor, you're sort of the master of ceremonies here, Mr. Novella. And you did this in the last RPS case as well. Does your testimony or Mr. Martinez's testimony address all of the requirements for a new procurement under Section 6216(4)G of the Renewable Energy Act and Rule 572.14 of the Renewable Energy Rule? Is it your intention to cover all the bases?
No, and we could go to my direct testimony, outline who responds to what portions.
Well, in previous cases, in the last case, I think you went section by section of allocating it between yourself and Mr. Martinez, and I don't see that in your direct testimony in this case. Is that true?
I'm not sure if that is. I felt that there was a summary version of who responds to what.
How about let's go back to your direct testimony. If I shut it down. No, I have. Give me a second here because I think I just closed your direct in order to make some space. Let's turn to page 30 of your direct testimony.
There.
You're there. Okay. And this is the one place that I found testimony. Again, I don't think you referred specifically to the rule. This is on page lines 30, lines 16 to 17. Well, 16 through 19, I guess. Is this testimony here that EPA has determined that PV1 energy is the only available renewable energy resource? Is that the company's response in this case to the statutory and rule requirement that any new procurement be the result of a competitive procurement?
I'm sorry.
Yeah.
Can you just restate that?
Yeah. So you agree that the rule and the statute require, one of the requirements of the rule and statute is that the that any new proposed procurement be the result of a competitive procurement. Is that right? Understand that requirement? Are
I
you
don't know
familiar
the
with that
exact
requirement?
language, but to your question, again, this in the short run, in the short term, this was the only available resource, and this is at a very low price compared to any alternative, and it's already been previously approved by the commission.
And when you say it was previously approved, you're talking about the original case number 00348 UT, and then last year's amendments to that PPA and the combined case, which I'm not going to mutter out the docket number. Is that right?
That's correct, after the amendments, because when you look at this price under $30, the only comparable we really have is that short-term RFP that Mr. Martinez went out for, and that's over 3 times the cost of what BV1 is.
Well, I'll ask Mr. Martinez about that, but did EPE, so what EPE competitively bid that project in the first case, is that right? The BV1, that was a part of a competitive procurement that was issued in 2017, I think, and approved in 2020. Am I right?
I don't recall all the details. I wasn't involved in those cases.
Oh, you
I
weren't involved in those cases.
refer you to Mr. Martinez.
Is it, you were involved, too many cases, Mr. Novell, I'm sorry. Do you understand that the current energy price was changed as of actually earlier this year in the amendments docket?
Yes.
And was that price change the result of a competitive procurement process?
Again, I wasn't involved in that amendments case. I wasn't a witness, so.
And is the addition of the DG rec price, the $5.40 to the previously commission approved price, is that the result of a competitive procurement?
And again, one thing I'd want to clear up, the DG rec price and the 540 that's being added here, they're different things, right? So the rec purchase program is for a customer distributed DG. And here that rec portion that we're adding here is just to make our customers whole, because Texas has the rights to those recs and there's value to them, and we're just supplying that value back to them. So it's not for a rec.
I understand that I'm sorry. I understand that's what you're doing on behalf of the Texas customers. I'm asking what you're doing on behalf of New Mexico customers under New Mexico law. Was there a competitive procurement that for a reallocation that ended up costing $5.40 more than the price that was approved by the commission in May of this year?
Again, so
Just yes or no, please.
I think it goes beyond a yes or no. The price was approved before the $5.40, but we have to add back the incremental price to make our customers whole. And that price is still a great price, under $30 relative to anything else out there. So I think we're offering our New Mexico customers a package in our 2024 plan to be compliant while still offering as low as we can means to get there.
Now, can you give me the yes or no?
Can you re-ask your question?
Yeah, okay, the question was, I think, was there a competitive procurement that included tacking on $5.40 to the price that the commission recently approved as being whatever reasonable?
Again, we're not
How about
procuring.
you say yes or no? That was
Wait a minute. I'm confused. Let him answer the question.
Yeah, so what we're trying to do here is assign a value to the RECs from the energy we're moving from BV from Texas to New Mexico. The only available market for those RECs is that $5.40. That's that a dollar value that Mr. Martinez calculated. And so it's the only value that we can use for the value of the rec. So it's not something we're going out there to competitively get bids on. It's just that is the market value of recs in New Mexico for that period. That is the only avenue we found to get a market rate for recs. So we're adding that to the approved price to again make Texas whole, because Texas would have sold those recs and received that amount of funds.
I think
To
you've
who?
I think, okay, you've given
Wait a
that,
minute.
you've given that answer several times.
Ms.
but I
Stevens,
still-
wait a minute.
Sure. So there is
Since the energy wasn't generated in Texas, how do they have any rec value in Texas for that energy?
Yeah, that's a good question, Madam Hearing Examiner. So my understanding is that since the Macho Springs facility is located on a transmission line that goes to Palo Verde, and from Palo Verde to California, they're able to sell in that market. So we'll sell it on their behalf and use those funds then to buy RECs within the state of Texas for our Texas customers.
So you're saying it does have a value, even though it's not a value for RPS compliance in Texas?
It does have a value, and we'll use that value then to buy Texas RECs, yes.
Now, I think the specific question to try to move this along, Mr. Novella, is Rule 572.14, which is the Annual Renewable Energy Plan Act. You're familiar with Rule 572?
Yes, ma'am.
Okay. It has in item C a list of 15 requirements that C says the annual Renewable Energy Act plan shall include. And the question is, on item 12, information including exhibits as applicable that demonstrates that the proposed procurement was the result of a competitive procurement that included opportunities for bidders to propose purchase power, facility self-build, or facility build transfer options. Did you, or to the best of your knowledge, any EPE witness provide testimony in this case to comply with item 12?
Madam Hearing Examiner, can you please read just the section 12 line you read?
I can. C says the annual Renewable Energy Act plan shall include, and then you get down to 12, information including exhibits as applicable that demonstrate the proposed procurement was the result of a competitive procurement that included opportunities for bidders to propose purchase power, facility self-build, or facility build transfer options.
Okay, now I believe that's responded to with Mr. Martinez, and briefly in mind how we described that the pricing was originally part of a competitive bid for BV1.
Okay, so you're saying yes, there is testimony and that's it.
That's correct. At a high level
Okay.
in mind, there may be more of Mr. Martinez, ma'am.
Okay, thank you. Ms. Stevens,
Yeah,
are you finished?
one very last question on the rule requirements. Are you familiar with the requirement of the rule that the company, let me find the rule, provide information demonstrate, and it is 13, demonstrating that the plan is otherwise in the public interest, considering factors such as overall cost and economic development opportunities. Is there any testimony by yourself or somebody else that discusses overall cost and economic development opportunities of these two arising from these two procurements.
Yeah, definitely. I mean, that's a theme in the entire filing, that we're trying to do a low cost proposal for 2024, comparing the two proposed procurements, DG Rec Purchase Program and BV Temporary Transfer, to say the short term pricing that we just got that I mentioned, that is 20 times that of our DG Rec proposal and over 3 times that of our BV1 proposal. This is a very low cost option to our customers, and we're proud to present that.
Okay, I have no further questions. Thank you,
Thank
Mr.
you.
Novella. And
Thank
thank
you,
you,
Ms.
Madam Hearing
Stevens.
Examiner, for letting me go on this long.
Um,
And I'm going to
Ms.
try.
Souls, do you have questions for Mr. Novella?
Yes, ma'am, I do.
Go ahead.
Mr. Novella, would you go to your direct testimony, please?
There.
At page 15.
I'm there, man.
Beginning at line 13. When EPE proposed the reassignment of renewable energy and associated RECs from Macho Springs, did EPE propose a price for the RECs in addition to the PPA price for the bundled energy and RECs?
I don't believe they did. That was a very different project with very different pricing, if you recall, right at the RCT of $60. And I don't have that history at the top of my head. So I'm thinking that they just couldn't offer it. It would have exceeded the RCT because you were just shy of it. But if you wanted more history on that or have detailed questions on that presentation that EP made, then I would maybe ask those of Jim Sheetzel, since he's on here as a rebuttal witness, man.
Thank you. Would you agree that Macho Springs is basically a bundled price for energy and RECs? There's not a separate price for the RECs.
Again, I'm not very familiar with Macho. It's a few years before my time working on these specific type of cases. I would ask that you ask those more detailed questions for Mr. Sheetzel.
Mr. Novella, even though Macho Springs is still being purchased and is still represented in El Paso Electric's renewable energy plan, you're not familiar with that situation?
Madam Hearing Examiner, I'm going to object to this question. It's been asked and answered, and at this point, it's becoming a hostile question.
Well, I don't think so. I think she asked specific information, and then I think she can ask him whether or not he's generally familiar with the term. So I'm going to overrule the objection. Answer if you know, sir.
I don't know, ma'am.
Okay, go ahead,
Thank
Ms. Souls.
you. Yes, would you please go to page 25 of your direct testimony?
I'm there.
Beginning at line 13. You're describing EPE's proposal for a new DG Rec purchase program as part of its contingency plan. Is that correct?
Let me look at the section, ma'am. That's right.
And would the proposed REC purchase program for renewable DG customers, would it add additional renewable energy to EPE's system?
To the system, no. To the jurisdiction, yes.
How does it add additional renewable energy to the jurisdiction?
It's adding, it's serving more of our New Mexico customers' load with additional renewable energy. Now, in some, if you look at it from holistically at the total system, we're not adding a new system, but again, under the REA, my understanding, it doesn't have to be a new facility in order to be used under the REA. So now there are more renewable energy serving our customers as if this proposal were to be approved.
It was my understanding that you're talking about purchasing RECs, but not purchasing energy. Is that correct?
For DG, yes.
So explain to me again how it adds additional renewable energy.
I think it's, again, pretty well described in rebuttal testimony where I rebut this item. And it goes to the very nature of what we're trying to do, I believe, with the REA. And that's use renewable resources to serve our New Mexico customers. And here we're able to use this energy that's being used in our service territory already by our customers. And it's not being credited as part of the REA. And I think what we're trying to offer is bring that in at a very, very low cost. And currently we're unable to do so. But doing this will benefit our customers by, again, providing a low cost option versus any of the alternatives we've talked about today.
I think I just heard you say that it's energy that is already being provided, and that this has to do with a mechanism to allow you to count it.
I'm sorry,
for
to allow you
renewable energy
to,
purposes.
I'm sorry, I
count-
missed part of your question. Mechanism to allow you to,
Allow you to count it to satisfy your Renewable Energy Act requirements. Is that correct?
Well, what I will say, and I would point you to my rebuttal testimony, and I talk about it quite a bit, but primarily
Where?
22 of my rebuttal testimony, 22 line 3, starting with the REA only. And I'll say that the REA only addresses resources used to serve New Mexico and only requires EP to serve New Mexico retail customer load with incremental percentages of energy generated from renewable resources. Contrary to Ms. Sol's assertions, EP is not required to procure new resources to meet obligations under the REA.
Mr. Novella, that isn't the question that I was asking you. I was asking you about the energy, the electricity produced by a DG customer. Is that energy going to be increased?
As a result of DG, no, but I would say yes in a forward-looking basis, because each year we get more and more DG customers. In our entire system, we get about 5,500 customers get these systems per year. So on a forward-looking basis, it will be increasing. And if we're able to get this program approved, it's only going to be able to grow and grow as our customers start adding more of these systems onto the rooftops.
Thank you. And prior to those new systems, the existing systems, are you saying they do not produce more energy, electricity as a result of your proposed procurement of the RECs?
Generally speaking, no. It would all be the new
Okay,
increment.
thank
that.
you. And would the proposed REC purchase program cost El Paso Electric's New Mexico ratepayers more money?
Then what?
Than what they are currently paying for that energy?
I'm sorry, say your first question again.
Would the proposed REC purchase program cost El Paso Electric's New Mexico ratepayers more money?
No, to me, it costs less, because the alternative is you're either putting BV1 reassignment, temporary reassignment, at under $30 versus $5, or you're doing some type of short-term purchase that's over $100. So to me, this is a great cost savings. We're able to leverage and use these resources for RECs.
Yeah, but what about, that might be going forward, Mr. Novella, but she's asking you whether or not this is going to cost New Mexico ratepayers more money than they're paying right now.
So it would be an increase, but the statute, we still have the percentage goals for renewable energy. So we're going to have to meet those one way or another. And I think just the way I see it is this an increase? Yes, but it's a much smaller increase than any other alternative.
Go ahead, Ms. Holes.
Thank you, ma'am. Would the proposed REC purchase program cost El Paso Electric more money?
No.
Please go to page 28.
Still in my rebuttal, ma'am?
I was in your direct testimony, so you took me to the rebuttal. Let's go back to the direct testimony, please. And beginning at line 15, you're describing El Paso Electric's proposal to reassign and deliver energy and associated RECs from BV1 that are currently allocated to Texas. Is that correct?
Yes, ma'am.
Would the proposed reassignment of energy from BV1 add additional renewable energy to El Paso Electric's system?
Again, at the system level, no.
And would the proposed reassignment of energy from BV1 cost New Mexico ratepayers more money?
And similar, I would answer similarly to the DG. And I think this is the avenue that we can use to serve our New Mexico customers and offer them the RECs needed at this scale at the cheapest price. So is it an incremental cost? Yes, but compared to what? And compared to what is a much higher price?
And would the proposed reassignment of energy, would it cost New Mexico ratepayers more than what they currently pay for energy and RECs from BV1?
If I'm understanding your question correctly, under the current purchasing, this would be, again, treated almost as like a different resource, all this from the same facility, because it's helping fill the need for Hecate on a contingency basis. And in that scenario, you're going to have that incremental price that we discussed with making Texas whole.
Would you agree that currently New Mexico ratepayers are paying for energy and RECs from BV1?
Yes.
And did I understand you correctly that the proposal is for the additional energy reallocated from BV1, that it would cost New Mexico ratepayers more than that amount?
Yes.
Would the proposed reallocation of BV1 cost El Paso Electric more money?
No.
Okay, and beginning at line 21, on that same page 28, and this goes into the following page.
I'm sorry, ma'am. Did you say 21 or 28?
You're on page 28. It begins at line 21.
Okay.
You indicate that El Paso Electric intends for the BV1 reallocation to continue until EPE's Hecate 1 and 2 and Carne are commercially operational. Is that correct?
Let me read that full sentence, ma'am. So EPE is just looking to temporarily reassign this for the Hecate facility just in 2024.
Then your reference to Carne is not correct.
I believe I should have cleaned that up and just had it as Hecate. It's less confusing.
And if you look on page 29, at line 3 and 4, you say with additional reassignment as needed to fully meet 20% RPS in plan year 2024, and 40% RPS in 2025. Is that your testimony?
Let me read that section. Yes.
And the 40% in RPS in 2025, is that dependent on Carne or not?
It is, but again, I guess, and my apologies, I should have made this section clearer. This proposal, again, is only for 2024, and it's a contingency proposal only on the Hecate facility not coming online in 2024. It's not going beyond the 2024 year.
Have you made this change in your rebuttal testimony?
We've described this in discovery probably numerous places, and I'm sure several of the witnesses talk about that this is just a 2024 temporary reassignment throughout the filing.
Madam Hearing Examiner, I don't know exactly what's appropriate here, but I would move to strike on line 21 the words "and Carne," and also on line 4 of page 29, the lines "and 40% RPS in 2025.
Well, I think, Ms. Souls, that the witness basically has clarified or changed his testimony here live. So I don't know that we necessarily need to strike the testimony. So I'm going to deny that request
Very well.
since he
Thank you.
orally has changed his testimony. Okay.
Thank you. So I want to go back to the term commercially operational. By that, do you mean until Hecate 1 and 2 have achieved COD?
I would refer that question to Mr. Martinez. He will let us know when the facility is right to use or not, and what COD is defined as.
Thank you. And on page 29, in line 2, you specify an additional 8.69% of the output. Does EPE consider the additional 8.69% to be the minimum amount assigned?
Again, that'd be a question for Mr. Martinez.
Is El Paso Electric asking the commission in this proceeding to authorize additional assignment as determined by El Paso Electric as being needed?
What we're seeking here is the temporary assignment of BV1 to make up for a potential shortfall if Hecate doesn't materialize in the summer of 24 and is not present for the entire year of 2024.
Who will determine whether or not that any amount of BV1 is needed?
Well, it's needed to satisfy the requirements of the REA, especially if we're really needed, if we don't have the Hecate resource come online. We will not be in compliance.
Right, but the
Mr.
question is, who's going to make that actual determination as to when, if, and how much is going to be made?
How much, what, ma'am, would be made?
The question, Mr. Novella, is under your proposal, who would make the determination that it's needed? And when would that determination be made?
Okay, understood. So under this contingency proposal, it is set that Hecate will not be operating in 2024, and the shortfalls in the amounts And the timing for all of those energy and the associated RECs would be presented by EP Witness Martinez.
Okay, go ahead, Ms. Souls. Mr. Novella is deferring a lot of his paycheck to another witness to answer questions.
I believe that's correct. So let's go to page 31 at line 17. You reference supply chain issues previously described. What supply chain issues are you referring to?
Well, it's been a constant theme since COVID, and I think everyone here has heard a lot about supply chain and understood them in their personal lives. And earlier, Ms. Stevens brought up some cases on some amendments on these PPAs that we're talking about today because they were pushed back due to supply chains as a result of the COVID pandemic and pricing going up, labor shortfalls. That theme has been just a constant.
Then is it your testimony that this is a generic theme as opposed to something specific?
Well, what you're referencing in this piece of testimony is for the community solar program. And that is just a general theme that we've been seeing with facilities generally. So yeah, I would just call it a general theme of supply chain issues.
You say supply chain issues previously described. Where is it previously described?
I just mentioned them.
In your testimony?
No, just in general that we've been had them in several cases, and we've talked about these issues over and over again.
Very well. Please go to your rebuttal testimony at page 23.
Okay, I'm there.
You rebut Ms. Soul's proposal that the commission should approve a price of no more than 1 cent per megawatt hour. Who would be paying DG customers for the proposed purchase of the additional DG RECs?
Well, they would be in the RPS rider.
Would you agree that means that other New Mexico customers would be paying that bill?
Yeah, every customer that has an RPS line item would be paying that, yes.
And would you agree that earlier this year that those customers were paying $0, no money at all for those same DG RECs?
That's right.
Would you agree that it takes a customer and a seller, a buyer and a seller, to have a market?
Yes.
So in that market dynamic, would you agree that a price of no more than 0.1 cent would actually be reasonable?
No. So, and just to elaborate on that, earlier I described that there's a market for Texas to sell their Macho Springs RECs via Palo Verde to California. That wouldn't exist for these types of RECs. It's very different. I believe that they essentially have no value, and I've talked about that in the past. But per the amendments to the Rule 572, it asked for a different purchasing scheme. So we offered the one market-based rate that we have seen for RECs, and that's the $5.40. And back to that 1 cent per megawatt hour, we would now be introducing a new line item to a bill. And again, there would be more administrative burden associated with that. So that would be just something we'd have to look at a bit more to understand what would be the incremental cost for doing so.
Incremental cost to whom?
To the company to administer a new charging line item.
Would that cost be any more than if the price was set at $5.40 per megawatt hour?
No, I believe it'd be generally about the same if it's the same pricing.
Thank you. Please go to page 25, beginning at line 16.
Okay, I'm there.
You are discussing the BV1 reallocation proposal. Is this proposal similar to EPE's previous proposal related to Macho Springs reallocation?
We just talked about that. I would say they're very different again. There's been quite a bit of time between the two, but Macho Springs was already in base rates for Texas, unlike the BV1 facility, and much different pricing, as you recall, was right at the RCT practically, and this is much cheaper. So again, very different.
Are they both related to a solar PPA arrangement?
Yes.
Are they both related to pricing for that PPA that includes the energy and REX bundled?
Again, I don't know the exact detail of how the Macho Springs is structured. Earlier, I referred you to Mr. James Sheetzel, but again, I would say that they may have some similarities in that they're solar facilities, but again, very different pricing. One's in base rates, one's in not. Just very different facilities.
And just for clarity, when you say one's in base rate, one is not, you mean in Texas, not in New Mexico?
That's correct, ma'am.
Thank you. Is there a requirement that the output of system resources like BV1 be allocated between Texas and New Mexico in a particular manner?
I'm not sure. That'd be a question probably for Mr. Martinez, who does our system planning.
And then you wouldn't know where that requirement might be stated. Is that correct?
Yeah, I would ask Mr. Martinez. Generally, we look at system resources, it's broken out by load requirements per state, and he could help define what those are.
Why does El Paso Electric believe that the output of a system resource can be reallocated?
Well, we could reallocate it, and it's a win-win for everybody, is the way we see it. Our Texas customers are made whole. New Mexico customers get a facility that delivers renewable energy at a much cheaper rate than anything else that's out there. So I think this is a great way to be successful in 2024.
Is it your testimony then that if El Paso Electric believes it's a win-win for everyone, that El Paso Electric can determine that the output of a system resource can be reallocated? Is that what your testimony is?
I'm not sure I'm following your question, ma'am.
I thought I heard you describe El Paso Electric believes this is a win-win for everyone. Is that correct?
Yes, I do believe it's in the benefit of our New Mexico customers, and since our Texas customers are being made whole, I think it's a great proposal.
Would you agree that parties in this case see that somewhat differently as not being a win-win for everyone?
I mean, like any case, there'll be some portions that people will disagree with. I don't know if you want to be more detailed with what specifics.
And so you believe El Paso Electric can change how a system resource is allocated. Is that correct?
Well, again, this system resource, BV1, is not in base rates, it's in fuel. We can do a temporary reassignment, make Texas customers whole, at the same time, give a cheaper resource than anything that's out there to our New Mexico customers to satisfy the REA. I see only positives there.
Has El Paso Electric done this before?
I'm not aware of any time we've done it before, but I've only been working on these types of REA cases recently in the last 2 years or so.
Does reallocation of a system resource output cause the electrons that are produced by that resource to be redirected?
No, I don't believe they do.
What approvals does El Paso Electric believe are required in order for El Paso Electric to reallocate a resource?
I don't believe we need a Texas approval, and that's what we're seeking here, is approval here in the NMPRC.
So the NMPRC is your understanding the critical approval that's required?
For it to be counted under the REA.
I was asking to reallocate a resource.
Well, we're seeking that approval here for this temporary procurement. with New Mexico, and we are not seeking that in Texas, no.
Very well. Over what period of time can El Paso Electric reallocate a resource?
We're seeking here for 2024.
You're seeking for 1 year.
That's right.
Could you do it for 2 years?
I'd have to seek legal counsel. We're only seeking 1 year, and eventually it'll be in base rate. So I'm not sure what that entails, but I would seek legal counsel for an answer to your questions.
What's the constraint on what period of time a resource can be reallocated?
Can you restate your question? I don't understand it.
I'm asking you, what is the constraint? Why not for, say, 5 years?
Oh, because we're only needed for 2024 because that's the plan year in question. And we're hoping that we'll be fine and we'll be able to be in compliance beyond 2024. So right now, we're only year in question is 2024.
Would it be appropriate to say that the constraint then is based on need and not anything else to your knowledge?
Can you define what you're talking about, need?
I thought I heard you say we only need it for 2024.
And we need it in 2024 under the plan that's the contingency plan. Again, the contingency plan lays out a framework if Hecate doesn't materialize in 2024. So if we do not get that facility in 2024, we would need it to be in compliance with the REA for 2024. And that's where it stops. We just need it for 2024.
If you needed it also for 2025, say there's another pandemic, is there a reason that you could not do it for another year?
Madam Hearing Examiner, I'm going to object to this line of questioning as outside the scope of this case. We're here seeking approval of a plan for 2024.
Madam Hearing Examiner, 2025 is also part of this case, as the company is required to include for informational purposes what their plan is for 2025. I believe that 2025 is appropriate.
Ms. Olson, 2025 is part of the informational filing requirement.
We have provided the information for informational purposes. We're not seeking approval, and Ms. Souls seems to be going down the path of asking Mr. Novella to speculate whether or not we'll be seeking approval of a similar procurement in our next plan filing.
Ms. Souls.
I'm not actually doing that. I'm trying to understand what Mr. Novella believes is the parameters under which EPE can seek approval for a reallocation of a system resource.
On that basis, I'm going to overrule the objection. Answer the question if you know, sir.
Can you restate the question, ma'am?
Ms. Gonzalez, do you have that question as I phrased it?
If you needed it also for 2025, say there's another pandemic, is there a reason that you could not do it for another year?
In that hypothetical, and again, big hypothetical, I would imagine the following year we would request that treatment if we needed it, and that's what we deemed that we would need for 2025 compliance. But again, a lot of hypotheticals and assumptions to get to an analysis that hasn't been done, I would imagine.
Okay, thank you very much. I have no further questions at this time.
Very well. Ms. Lynch, are you going to have questions for Mr. Novella?
I just have a few, hearing examiner.
Go ahead.
Okay. Mr. Novella, is it Novella?
Yes, ma'am.
Yes, sorry about that. I am wondering if you can describe for us what it means that renewable energy is delivered to a public utility?
Sure. And you're referring to the language around the DG rec proposal?
Generally, that's what I'm referring to, yes.
Okay, so as a customer is producing electricity from their customer-owned rooftop solar system, some of it is going to be used contemporaneously with load on the home at the exact same time they're producing energy. But beyond that, energy is going to be exported and pushed back into our T&D system, mainly distribution system. And that's how I would describe that.
Is the energy from that DG get delivered back to EPE or the utility?
Yes, and when I describe it gets pushed back into our system and it's in the poles and wires of our distribution system, I consider that already to be EPE because it's EPE's distribution system.
So it gets delivered to the distribution system.
Yes, and it's all one system. When you hear operations, people talk about it. They just talk about generally the EPE system or their utility system.
Okay. So then I'd like to hear a little bit more based upon your knowledge and experience, for you to describe what is an energy supply portfolio.
Can you point me to the language where I have that in my testimony? I don't believe I'm familiar with that wording.
This refers to the statute, the Renewable Energy Act statute, and specifically, I can point you to 62.16.2B1 where it's used, but it's used throughout the statute. Specifically, the purpose of the Renewable Energy Act, or the purposes of the act, are to prescribe the amounts of renewable energy resources that public utilities shall include in their electric energy supply portfolios for sales to retail customers in New Mexico by prescribed dates.
Okay.
So
Thank you.
what is an electric energy supply portfolio from your experience?
So thank you for reading that, first of all. And I would ask, I'll answer your question, but I would say that Mr. Martinez would be a better resource since he oversees resource planning to define how he would define that. But I would see it as the portfolio of resources that a utility can use to serve native load.
Okay. And also then, or building upon this idea of what is an energy supply portfolio, I was wondering if you could describe for us what are retail sales?
Sure. Retail sales are those customers' sales to our end users that typically exclude wholesale sales or wholesale contracts.
Okay. Let me return to the statute. Do you agree then that for reasons of meeting renewable portfolio standards, the electric energy that EPE uses to meet the standard must be delivered to the public utility and assigned to the public utility's New Mexico customers?
I believe so. It's energy that's getting delivered and supplied to our customers. Yes.
Okay. And do you agree that the reason EPE is submitting this contingency plan is that EPE will not meet the prescribed requirements by 2025 for the amount of renewable energy that shall comprise your retail sales to
No,
New
ma'am.
Mexico customers?
I apologize, ma'am. I cut you off there.
That's okay.
No, I would say no, since you mentioned 2025. What we're seeking here is a contingency plan again, just for 2024, not for 2025, because of the possibility that we may not be in compliance if the Hecate resources does not come online.
So you expect that EPE will be in compliance in 2025?
Again, that goes beyond this case, but from my understanding, yes, we should be in compliance in 2025.
Are any of the other like based upon your knowledge, do you know if any of the other utilities supplying electricity in New Mexico or to New Mexico customers are out of compliance with the renewable portfolio standard?
I don't know.
You don't know.
No, I haven't researched that.
Would you accept it as true that the other utilities are in compliance?
Subject to check, sure.
Thank you. Those are all the questions I have, hearing examiner.
Thank you, Ms. Lynch. Mr. Black, does staff have questions for Mr. Novella?
Just a couple questions, if I might.
Go ahead.
Mr. Novella, in your rebuttal testimony in general, you respond to Christopher Dunn's testimony regarding the challenge to the DG REC purchase program. Is that correct?
Yes, sir.
And you, in general, mentioned that that's a legal determination. Is that correct?
Yes, that's right.
What EP witness in this case can answer questions about the contours of that legal question?
I guess it would be primarily myself, sir.
Okay. Are you aware that the case for the rulemaking for the RPS case is up on appeal currently before the New Mexico Supreme Court?
That's my understanding.
Okay, and that a similar plan in the rulemaking case was that EPE made the argument that now in this case you're trying to implement. Do you understand what I'm asking?
No, I did
With
understand
regard to what?
In terms
Mr.
of
Black?
the DG, in terms of the DG REC purchase.
I don't know,
plan.
sir. I don't recall what EP was advocating for, and where you referenced their exact position.
Okay, so in general, can you explain to me, well, why there is a legal challenge to the DG REC purchase plan? Under, I believe it's under Rule 572. What part of Rule 572 is legally incorrect?
With regards to when I referenced that it's a legal issue?
Yes.
Okay, and when I write that, it's specifically to the interpretation of EP being allowed to claim those recs under that new verbiage that I used in my testimony from the amendments, where it talks about proposing a new pricing scheme, and EP has done that here. So I think under that new wording, we've done what's been requested, and we think we are in compliance to get that approved. But ultimately, that would be a legal question if it should and could be approved.
So you just generally, you believe that this is the case in which EPE is requesting an alternative pricing scheme,
Yes,
and that there needs to be no other application under the REA to request an alternative pricing scheme.
my understanding is that the request here would approve that pricing scheme and allow us to use these recs going forward. Yes.
Okay,
So-
but my question is, should there have been a separate petition or application specifically asking for an alternative pricing scheme in terms of purchasing DG Rex from existing customers?
I'm unaware of one.
Okay, thank you. No further questions.
Thank you, Mr. Black. I believe that we have gone through our parties that are here. And believe it's also time for luncheon break. I've got a few questions for you, Mr. Novella. When we come back and perhaps co-hearing examiner, Mr. Fisk might or might not have some for you, then I'll allow for some redirect and we will briefly go back through again for limited questions. So I have 12:35 on my computer. So we will recess for an hour for luncheon. We'll come back at 1:35. Please remember that the YouTube still going to be on if you happen to leave your computer on. Thank you. Hey, Melissa, can you hear me?
I can.
Great. I just got a message that I switched audio,
Oh,
so I was
I'm-
concerned.
hear you loud and clear.
Great. Excuse me. Okay. We'll get Mr. Fisk back on. There he is. You could. Think we need Miss Olson. There she is. Who am I missing? Miss Lynch? Okay. Well, we're back from our lunch and recess. Hopefully everyone got their fill of their trick or treat goodies. Just to let you know, there's not any in the building here at work, so. Okay, well, Melissa, if you're ready, let's go back on the record. We're back from our lunch and recess. And Mr. Novella, I have a few questions, and I want to start back where I started first thing this morning. Because I want to make sure I understand this. And if you can recall, I was looking at your direct testimony around page 20, and I asked you a couple of questions with regard to the energy that was generated by the DG customer. You remember that?
Yes, Madam Hearing Examiner.
Okay, well, so I'm still not totally clear on this. So I thought maybe we could go through this one more time. And you're saying on page 20, beginning at line 9, that El Paso Electric did not count or apply the portion of REX corresponding to energy generated by a QF that's consumed contemporaneously on site by a DG customer and never exported onto the system.
That's right.
And when we're talking about generated by the QF and on site by the DG customer, we're talking about a same customer, right?
Yes, Madam Hearing Examiner.
Okay, there's Miss Lynch. So the energy that's consumed by the DG customer and generated by that DG customer was not utilized based on the rule change, correct?
Correct, Madam Hearing Examiner. And may I elaborate a bit?
Well, let me just get to the bottom of the question here. The line 13. This portion of total DG production represents approximately 45% of the energy and associated RECs generated by the average net energy metering customer. So is the portion you're referring to, this, the source of that portion, is that you're still referring to line 9 and 10?
Yes, here I'm referencing that we used to get 100% of all RECs generated by our customers in New Mexico. And the very first cut, if you will, based on the new rule change, is that we cannot count that energy that is produced and immediately or contemporaneously consumed by the customer themselves.
Okay. So that's the 45% of the energy produced.
That's right.
Okay. And then on the next page, do you need to tell me anything else about that?
Well, I guess what I was going to say is that, at least the way I like to lay out that proposal, is that we used to get 100%. And after, at least our interpretation is after the rule change, is that it went from 100% down to 13%, and 13% just being, again, the energy that was bought under rate 16. As you noted, that decrease going from 100 to 13, 45% of that was what you just walked me through, Madam Hearing Examiner. And the rest of it is energy. Now, because after you remove
Okay,
that,
let's wait 1 second. Let's just talk about the part that they're using.
okay,
Okay. So the part that they were using and keeping themselves, EPE used to claim, however much that was, EPE used to claim RECs for that part prior to the rule change.
that's correct.
Did EPE pay the people for those RECs?
No,
Okay. All right. And so now, under the, so then the rule changed, it went to 13%. Okay. So now the part that EPE thinks pursuant to the rule change that's appropriate would be to basically count toward the its RECs and renewable percentage is this 13%, which you say is the estimated portion of total energy generated by DG customers and purchased pursuant to rate 16 purchase power service, right?
well, yes, Madam Hearing Examiner, I believe we get those RECs automatically post the change, but what we're requesting here is.
Wait, let's just talk about that part.
Okay.
Okay, so we've accounted for 45%. That's the part they're using, that they generated. Then they're selling to EPE 13% of the rest of that energy pursuant to rate 16, correct?
Correct.
Now, do you also pay them for a REC in rate 16?
We pay them for the energy.
Okay. You pay them for the energy, but you get to claim the REC.
Yes.
Okay. So if we have the energy they use and this 13%, now, is this 13% all of the DGQF customers?
Yes, that's our estimate for the amount we could estimate based on all the customers.
Okay. So is there any DG energy out there that's not being consumed by the DG generator or being sold to you under rate 16.
Yes.
Okay,
that would be-
now tell me about what energy that is.
Yes, Madam Hearing Examiner. So as you know, the customer will produce the solar energy in their homes, and roughly they will consume contemporaneously at the exact same time that that solar is being produced, a share of that energy, and that is that 45% we talked about.
Right. Yep.
So then they're pushing back then in a given period on average about 55%. So the remainder, after you take out that 45%, 55% goes back into the distribution system, EP
Okay.
distribution system. Now, of that 55% of energy that goes onto our grid, there's going to be a netting process at the end of every month for NEM customers. And when a customer has sent us, EP, more energy than what they consumed, they will then get a payment via rate 16, the purchase power.
Right.
Now, as you start adding those up, all those payments for a given period, typically that's about that 13%. So about 13% of the 55% that goes back into the grid would be excess. The customer is producing more than what they are consuming for that given period. So with this request, we're looking at that difference between the 55 and the 13, saying that under this amendment change, it offers EP the opportunity to provide an alternative pricing scheme in order to be able to account or take ownership and claim those RECs. So we're seeking to claim those RECs because they're both delivered. They're delivered onto our system by our customers, and here we're providing that alternative pricing scheme.
So not looking at the 45% that they consume, but looking at the 55%, you're saying of the 55%, 42%, the net metering generator, the DG customer is going to utilize at a different point during your net metering calculation.
I would describe it slightly different, Madam Hearing Examiner. That 42%, it's energy that was pushed back onto our system,
Right.
but they weren't paid for under rate 16. They were fully credited on a 1-for-1 payment or credit under NEM.
But they basically use that energy amount during your monthly period.
Yes, they were.
They didn't use it when they generated it, but they used it at some other point.
Exactly. It would be a transfer for one time period to another time period is the way I like to think about it. And again, we're a forced taker, taking that load or generation from them whenever it's produced, and we'll swap it out, if you will, on a 1-for-1 basis with them under NEM. And that's that 42% that you reference. And we're seeking here that if under the amendments, they say if you provide an alternative pricing scheme, if approved, we're seeking is recovery or being able to claim these RECs for the purposes of meeting the REA.
So earlier when I asked you, when we looked at this, is it a matter of potentially of timing? And I think you answered no. But timing on when the energy is actually used by the QF DG generator is important in your calculation, isn't it, Mr. Novella?
It is, Madam Hearing Examiner. I think for me, the at least the overarching issue is a legal one. It's that, in my eyes, that we're presenting an alternative as proposed by the amendment language to 572 for the DG Rex. And ultimately, if this type of program is allowed based upon how we're filing it and under that new language.
Again, I'm just trying to understand. And I believe in response to one of the interveners' questions, you answered that the rule that made this change is under appeal, correct?
That's my understanding. And in fact, we seek clarification on this change. However, since it was appealed by the city of Las Cruces, I believe we were unable to get clarification on how to use, how to apply the new rule, the amendment.
That's a separate appeal?
I believe it was an appeal to our RPS case, our previous RPS case earlier
Last year.
That's correct.
Yeah, no, you're right. Last year's case, this year's decision, correct? Case 22000093. Is that the case you are referring to?
That's correct, Madam Hearing Examiner. That's how I remember.
Okay, but that's not the appeal of the rule.
No, that was just, I believe, us seeking clarification on the amendment change.
Okay. And you wanted clarification from the commission as to?
What did they define as excess energy? A lot of the kind of items that we're talking about here. So we took a conservative approach and are only using the 13% under our interpretation of the amendment change. I think one could argue that we should automatically claim all 55%, but we didn't want to take that position and took the more conservative approach.
Okay, but the amendment change, I don't have the rule in front of me. Let me put it this way. In the order on your last year's case, 22000093, on page 15 of the order at finding 55, the commission replaced finding of fact 14 and replaced it with the following. EPE must immediately discontinue its practice of registering and retiring all New Mexico RECs associated with energy produced by DG customers for the purposes of RPS compliance. Specifically, New Mexico's RECs that are generated and consumed by EPE's DG customers must not be applied to EPE's RPS compliance, as this practice is in violation of the Commission's amended Rule 572.17.9, which is 17.9.572.10C in MEC. So that's the ruling by the Commission that you're referring to when you say that you didn't count part of the RECs, right?
That's correct, Madam Hearing Examiner, and that's why we offered instead of the 100%, 13% in this case.
Right. But then when you come up with your plan with the 45%, no, it's 55%, minus the 32, right? So,
The 13, ma'am.
yeah, sorry. The 55% that's left over that's not sold under 16. But then you do the net metering part to figure out how much more did they actually use of that other part that they generated. Then you say, okay, there's 42% left for us to buy the rec.
That's
Correct?
correct. That's correct, Madam Hearing Examiner. Based on the metering that we have on these customers, they'll have what's called a bidirectional meter. And we have a channel called delivered. And if you just measure all of delivered, that's that 55%. So we're able to easily, see those calculations and see those numbers for each customer.
But you don't believe that even though they might not be contemporaneously consumed by the DG customer when generated, EPE believes that a later consumption by that DG customer isn't what the commission meant in its finding.
And going back, Madam Hearing Examiner, that's exactly why we wanted to seek clarification. And since it went to appeal, we weren't able to get it. So we went with a more conservative view of that change, going down from the 100% to the 13 to only the energy that we receive and expressly pay for under rate 16.
But even if you go to the language that says, what the rule is, unless there's an agreement, that's the part of the rule you went to, right? That's how you came up with your agreement.
Yes, the portion that talked about offering a new or alternative pricing scheme. Yes.
But you don't think that even though you're offering an agreement to purchase something that the rule says you can't purchase, or that you can't utilize for RPS compliance, you think by having an agreement that gets you around that other part of the rule?
My interpretation was that if you present an alternative and it gets approved, then in that case, you can then count the RECs.
Okay. Okay, good. I understand better. Thank you, Mr. Novella. Anything else you'd like to tell me so I can
No, ma'am.
understand this? Okay.
Thank you.
Thank you. I appreciate that. Okay. See, and I thought when I was asking you about contemporaneously and whatever before, I thought I understood it, but it's good that we did this. If El Paso Electric, well, let me ask you this. Do you know what, if anything, that the DG customers do with their RECs?
They can't really do anything. I've looked into this with Regis, the group that they're able to claim their RECs with, and from my understanding, it would be overly burdensome and costly for any one individual to try to do anything with their RECs. And I believe there was even some limitations around just one premise or entity claiming RECs. They typically have to be bundled because these are huge amounts. So from my understanding, there's pretty much nothing they can do with these RECs.
Okay, because that was sort of my question of your testimony on page 27. The question posed at line 4, how would EPE's DG customers be impacted by the proposal, down at beginning on line 16, you say absent EPE's proposed purchase program, these RECs are essentially lost for compliance purposes and provide no benefit to the DG customers who generate them. So my question was, well, couldn't they sell them in this New Mexico REC market that was referred to with regard to the RFP?
And if I may, my understanding is they can't, and it's because it's built in such a way for that market. The facility has to be at the transmission level, supplying energy, and that energy will have to have a path directly to California. And Macho Springs has a path to Palo Verde in Arizona that can then go to California.
Okay. So basically you're saying then that if the commission didn't approve your alternative plan, even if the commission interprets and the court interprets the rule as being legitimate, they're not going to get any payment for their REC.
Yes, I believe absent this type of program, they can't get any payment.
Okay. And speaking of Regis, I did have a question. So if you could look at your exhibit 2, page 19 of 303, and it's a table, and it has RECs and Regis RECs. And what I'm going to ask you about, sir, is that there's a lot of like little footnotes on that table that says due to Regis, and Melissa, that's capital W, capital R, capital E, capital G, capital I, capital S. Okay. Due to Regis software update implementation issues, EPE has not yet received approximately, and then for certain time periods, I mean, it really looks like that to the detriment of EPE that you're not getting credit. Is that right?
You know what, Madam Harris, I'm not too familiar with that item. I have heard about some issues with Regis, but Mr. Martinez will be better versed to handle your question.
Okay, well, it's your exhibit, so, you know, I will. Let me just move my postie. Because, you know, generally that's what happens is when questions get deferred, if we forget or we somehow, then zoom, that question's gone. Okay, all right. So now we're back to your testimony on page 28. And this just has, you know, there were some questions this morning, and so just so I'm understanding here, on page 28, the question posed at line 1, how would EPE's DG customers enroll in the program? Answer, they're going to be automatically enrolled and receive their REC payments on their monthly bills. Customers that choose not to participate in the program can contact EPE for renewal. So basically the impetus then, everybody's included, and the impetus is on the customer if they want to opt out, right?
Right, that's correct.
And I had a note from an answer that you gave to Miss Stevens that I just wanted to clarify. And I think it had to do with your testimony about the reassignment of Buena Vista 1. And I thought what I heard you say, this is a temporary assignment for 2024. Is that correct?
Yes,
And then I thought I heard you say, and then the cost would go in rate base.
no, ma'am. I believe anytime I talked about rate base was about Texas's portion of BV1.
Okay. Because I see here on your testimony on page 29 at lines 19 and 20, the cost of BV1 energy and capacity currently allocated pro rata from BV1 is recovered, I guess here in New Mexico through the FPPCAC, right?
That's correct.
So that would go through the FPPCAC, but are there any rec costs that would go through the rider?
What we were suggesting here would be that although BV1, New Mexico's portion of BV1 is recovered in fuel through the FPPCAC, that the temporary reassignment portion of the energy and the rec supply to New Mexico would be recovered through the rider.
Okay. And in looking at some of these resources over the weekend, I think it's in somebody else's testimony, but when you refer to Buena Vista, when you refer to Hecate, when you refer to Macho Springs, those are all projects that are cited in New Mexico, aren't they?
They are.
And some of them were system resources, or all of them are system resources?
Some of them. So in the case of, say, Buena Vista, there was a Buena Vista 1 and 2. And number 2 was a state dedicated facility for New Mexico. And 1 was system. And in similar fashion, I believe that's how Hecate was broken out as well.
As the RPS requirement increases in New Mexico, have you given any thought to trying to get, since, can it be said that your renewable requirements are greater in New Mexico than they are in Texas?
I would say so.
And considering that, is there any thought to trying to go back and figure out a procedure to get the system resource reconsidered or allocated as a dedicated to New Mexico facility?
No, Madam Hearing Examiner. I think we've gone out there and made it pretty public that this was a Texas resource from the inception. And we feel it's just right just to leave it there because we made it pretty clear in our planning that that's where it belongs.
But aren't you going to get more bang from your buck out of New Mexico than you are with Texas, since it is in New Mexico?
You know, and that's something that we've talked about, but I think if we were to do anything like that, I don't think we can do that, but we'd have to make, again, Texas whole on that pricing of this facility, which right now looks very attractive, you know, and
I just can't forget though that they can't get any rec out of New Mexico Energy.
Yeah, we have to do that process where we sell them and then buy them Texas Recs.
Okay. Not trying to take anything away from Texas, just, just wondering, like I say, I mean, 40% and 25, I mean, it's really creeping up there. And if you've already got these, if you've already invested and gone through the approval processes to have these, these renewable generations, just seems like in your contingency planning that maybe that might be something, but I'm not in your business and not trying to micromanage you. So let me ask you this. In your contingency, and I think I understand your testimony, but kind of my question is, and it gets more to the historical nature of renewables and El Paso Electric. I mean, I think it's fair, Mr. Novella, to say that EPE has had its issues since the 2016 with either being excused or not being able to meet the RPS targets, hasn't it?
Yes, I believe partially, at least from reading history and reading the past cases, that a lot of it was due to the really tight RCT constraints that we had pre-RCT amendments that moved that up to $60. The company couldn't get any facilities with that constraint. And then as we moved forward, we saw a lot of the supply chain issues as facilities were coming online, post 2020, that just pushed some of those facilities back. But for right now, from what we're seeing is that we're hopeful and we're planning as if we will attain our 2025 40% goals and here with our 20% goal with 2024.
Well, I mean, I think everybody wants, wants compliance. I think compliance is a good thing. And, like I say, EPE has had its struggles where it's been either excused or there have been these stipulations that, we don't have it now, but we'll pay you later. And I'm wondering when later ever comes, Mr. Novella.
Yeah, I think my expectation is that now as you started seeing these supply chain issues improve and these facilities come online, I'm expecting that's in the near term.
So along in this theme of contingency planning, having looked at EPE's history, why is now the first year that you've actually looked at a contingency plan of, well, we may not have those resources available and we want to have something. Why are we just seeing this now?
That's a good question. And a few years ago, we did come with something similar that some of the interveners have brought up. Is the Macho Springs proposal, which was a reassignment of that facility to New Mexico, but that was broadly opposed, and that led to a lot of the backfill, allowing EP to backfill for certain years that you referenced.
Also, I'm just wondering, I mean, I understand your testimony about things that have happened and changes that have been made. Things have been delayed. But really is, delays in construction, supply issues, aren't those kind of part and parcel of your business?
I believe they are, but they've been much more magnified and extreme. I would ask that you probably possibly ask that question of Mr. Bryn Davis. He's an operations uh, employee for El Paso Electric, and he's a rebuttal witness in this case, but he understands the lead times on specific equipment. And I can tell you that I've been in meetings with him where I can't tell you the exact lead time on certain equipment, but he's talking about them, and you're talking years sometimes on several pieces of equipment. And that wasn't the case a couple of years back. It's just times have changed.
I also wanted to ask you, if you look at page 32 of your testimony, the question posed on page 31, line 21, does EPE seek any variances? And you say you seek a variance from the minimum data requirements from rule 17.9.530 with regard to the data schedules, et cetera, that that are required to be filed. Is there anywhere in your testimony that you actually address the requirements necessary to get a variance? Mr. Novella?
I don't know if I do outside of that one section. I don't believe I do, Madam Hearing Examiner.
Okay. Are you aware, Mr. Novella, that that in our procedural rules, 1.2.2.40 in MAC, which is labeled variance, that there are specific requests and information for a variance from a rule?
No, Madam Hearing Examiner, I don't. I believe I've used this language in the past, seeking variances from 530. I'm not sure the portion that you're referencing.
Okay. Well, specifically in section E, it says that you can request a variance and you need to identify the section of the rule from which you're asking the variance, which you did. Describe the situation that necessitates the variance. You think they're unnecessary. I don't know that that's necessarily a situation that necessitates the variance because you think it's not applicable. Describe the effect of complying with the rule or order on the applicant if the variance is not granted. Describe the result the variance will have if granted, and describe how the proposed alternative will achieve the purpose of the rule and why it's in the public interest. I don't think you did those things, Mr. Novella. Do you think you did?
I'd have to go through those items slower, but it is a fairly summarized request in lines 1 through 4 for a variance from 530. Again, I believe I used the same language in previous years and didn't take a harder look at it this year.
Not with me. Also, I wanted to look at your attachment GN-2 beginning on page 14 of 303. And that section 4 is called Rule 572 requirements.
Okay, I'm there.
And just generally, your exhibit 2 is in fact your 2022 annual report, right?
That's correct.
So this is a report that is about 2022, not why you think the 2024 plan is compliant, right?
Yes, that's correct.
And additionally, your exhibit 4 is, I believe in your testimony, you reference it as the places that you believe you are setting forth compliance with the commission's last order in 22-00093, correct?
Correct.
Okay. So if we look at your rebuttal testimony, one of the questions I wanted to ask you is, I believe that with Ms. Stevens earlier, you indicated that you had reviews, City of Las Cruces witness testimony. Is that correct?
It is.
And they assert that El Paso Electric is not requesting approval of your baseline plan. Do you agree with that?
I agree. We're seeking approval of our contingency plan.
Then why did you even why do you even have information about your baseline?
Just to provide it for informational reasons.
Because what I thought is you were asking for approval of your baseline and only asking for approval of your contingency if necessary. That's not true?
No, Madam Hearing Examiner. We're asking
Okay.
for our contingency.
Okay. See, because if I look at page 11 of your rebuttal testimony, where you're responding to Ms. LaRock's concern that EPEL will overproduce renewables, and then your continuing answer on page 11, you say on page 10, Mr. Martinez discusses and clarifies that even if the contingency is approved, EPE will not reassign the Texas portion of BV1 Energy and REX to New Mexico if EPE does not require the BV1 reallocation to meet its plan year 2024 obligations, right?
That's correct.
So that wouldn't put you back into the baseline because you would still have the new REC for the DG people, right?
We would still ideally have the DG program, and with regards to this specific portion, if Hecate ends up reaching their COD date and we no longer have to reassign Texas's portion of BV1, we don't have to do that. So we will only do the temporary reassignment if needed.
Do you have any update to how you're feeling about that, Mr. Novella?
No, I don't, Madam Hearing Examiner, but I believe Mr. Davis and Sheetstall may have some updates that are more updated than anything I have.
Okay. And I don't know, this is tomato versus tomato, Mr. Novella. Page 15 of your testimony, and I've already touched upon it briefly, but you say you don't like the characterization about historically failing. You say EPE has been considered compliant every year since the REA's inception, including prior to recent REA amendments increasing the RPS. That's your testimony on page 15?
That's correct.
But I think, as we have already discussed, the better characterization is that EPE has not met what the proposed standard RPS percentage was since 2016, correct?
Yes, Madam Hearing Examiner.
Page 17 of your rebuttal testimony, you're answering the question posed at page 16 about the city of Las Cruces history regarding EPE's proposals regarding the RPS. You say on page 17, lines beginning on line 8, the city has opposed each REA plan procurement proposal made by EPE in every REA plan case which the witness testified in over the past several years. That's your testimony?
Yes, Madam Hearing Examiner.
Why do you think that is, Mr. Novella?
I'm not sure. I think we're providing things that are benefiting the customers, bringing in new technologies, or seeking some solar battery, and it's just a constant obstructionism that we're seeing.
Do you have, I had seen in some of the testimony that there are, in fact, meetings and information sessions. Does the city of Las Cruces participate in those?
Yes, they do.
Think the city is trying to micromanage your operation, Mr. Novella?
I'm not sure what they're intending.
Has El Paso Electric found some of the inquiry to be helpful or corrective to some of its information?
We appreciate all criticism and testimony and all these matters, and in fact, it just makes it better and stronger and better programs for our customers. So we appreciate all feedback.
Let's look at page 20, and again, don't want to hit this too much, but this is the part where you say that EPE filed a request for clarification, asking for guidance, but the case is being appealed. On page 20, question at 7, answer 8 through 15, correct?
Correct.
If this is being appealed, do you believe the commission can actually approve your rec plan in this case?
Yes, I believe so. I believe that was just an appeal for the 23 case. And the only thing that we were seeking there was just clarification on the DG amendments. But again, that was pertaining to 2023.
Okay, so you don't somehow think that this, the appeal of this case, has some kind of prohibitive effect on making a determination in this case?
No, Madam Hearing Examiner.
And I think after the questions this morning, Ms. Solz's questions to you, I think I understand what the EPE position is with regard to procurement, new resource, new procurement. Understand it's just a little confusing when you use the word and then you say it's not the word. So when you say procurement and then you say, well, it's really not a procurement, maybe we should call it something else then. Okay.
Understood, Madam Hearing Examiner.
Or come up with a definition of procurement that has 4 different definitions and say we're using definition A, B. I need a pathway, Mr. Novella. Okay. All right. I think I understand that. Oh, the 540 on the rec, page 23, EPE requests an opportunity to present analysis on the administrative cost burden if the commission is considering adopting something other, I guess, than the 540.
Yes.
Mr. Novella, when would you do that? We have an end of the year. We have the end of the year deadline here. When would you present such an analysis?
If the commission so choose to do a price other than the 540 and it was low to the point where we're at the levels that Ms. Souls presented, that 1 cent per megawatt hour, I think it's something reasonable just to ask the utility for an estimate on what would be the administrative cost just to employ or to have a fee so small and to administer that charge on customers' bills to make sure that we're recovering those fees.
Okay, now let's talk about the end of your testimony with these backfill obligations. Your testimony on pages 28 and 29. And apparently the city is advocating that the commission should no longer require EPE to use RECs in the future to make up for past deficiencies. And then on page 29, apparently you agree with that. Is that correct?
That's right.
You agree with the elimination of your obligation to make up prior year deficiencies using excess future RECs. So you're willing to accept that part where you don't have to make up the deficiencies, but you don't want to be barred from seeking an incentive to exceed your obligation under the REA in future years. Is that right?
That's correct.
Well, you can see how I might be a bit quizzical regarding that, can't you, Mr. Novella? I mean, if you owe all these tens of thousands of recs that you agreed to were your obligation, and you agreed to make them up in the future as part of some legal obligation. Now you're agreeing, yeah, let them go away. And oh, those excess recs that I could have used to fulfill my legal obligation, I might try to get an incentive on. I mean, don't you think that's a bit inequitable to your customers and to your regulators?
Well, as you mentioned, we've agreed to backfill these recs, and here we're mainly just agreeing, just like we would do in the course of rebuttal, agreeing or disagreeing on positions, and we happen to agree on this position, but we disagree on the seeking incentives in the future case. Again, we're not seeking incentives here.
Well, and you're not required to make up the backfill until the future anyway, are you? 2025 and beyond?
I don't recall the when they're required to be fully met, Madam Hearing Examiner.
Okay. Never can tell. That question might come up in the future, so I thought I'd better ask it now. I had one more compliance. And it was with regard to that. And this is finding 54 of the order that's on appeal. Finding of fact 12 is modified to add the following sentences at the end of the recommended finding. EPE must, in its next REA plan filing, show the effects of applying versus not applying future surplus recs to previous RPS deficiency years. The Commission hereby places EPE on notice that the Commission will review the practice of retroactive application of recs for 2023 and subsequent years. Did you do that in this filing, Mr. Novella?
I believe Mr. Martinez has done that analysis.
Okay. Thank you. That's all the questions that I had for you, sir.
Thank you, Madam Hearing Examiner.
Ms. Olson, any redirect for the company?
No, Madam Hearing Examiner, I do not have any redirect.
Very well. Ms. Stevens, any questions based on my questions?
Madam Hearing Examiner, I have one question.
Okay.
Hello again, Mr. Novella. I do truly have just one question here. You may have more than one answer. Early in her examination, fairly early in her examination, when you and the hearing examiner were talking about the nature of the DG Rex purchase, and what was available for, what were the options for Texas as well as for New Mexico. She asked you a question about the Rex, and your answer about the Rex not being usable, oh wait, maybe it was about, maybe it was in this, I'm sorry, it was in the context of the reallocation. Texas resource. So was it when she switched over from Texas allocation from I'm sorry, I'm very confused. I'm going to start over again. It was in the context of the DG Rex associated with the reallocation, and she asked you about whether you would get more bang for your bucks on Buena Vista One Rex in New Mexico. That's to places where the question was, and you explained that you can't use the New Mexico Rex for Texas RPS purposes, and that you have to sell them and buy for Texas. Is the company's position that the money that you're gonna get here, if this were approved, the extra $5.40 per rec, is that going to be passed through directly to customers in Texas to compensate them or make them whole? Or is the company going to go out and procure a certain amount of recs that it needs to comply with Texas? Is it a 1-for-1, or is it a satisfy your Texas RPS requirements?
I believe that, and I would ask this of, actually, I would ask this of Mr. Martinez. I feel like he would know exactly how we would do it. I would venture a guess, but it might be slightly incorrect.
So when you answered the hearing examiner's question by saying you have to sell and buy for Texas, what was the scope or the confines of what you were testifying to?
Sure. So generally, the way it works currently is that for Macho Springs, Texas owns a portion or Macho Springs, and they also own the recs that are associated with that energy. And in order for them to see the benefit of the value in those recs, we sell those recs in the manner I kind of described, and then we use those funds to purchase Texas recs for Texas RPS compliance.
And
Now,
in that circumstance, do you take all the money that you get for those recs and use all that money to all the money you get for the New Mexico recs and spend all that money on Texas recs, or are you searching for a specific number of Texas recs?
and that's where I'd ask Mr. Martinez. He would better answer that question.
I will, thank you. That was it.
Thank you, ma'am.
Thank you. And I apologize, Mr. Fisk. Did you have any questions for Mr. Novella?
No, I do not. Thank you.
Thank you. Okay. So Ms. Souls, anything based on my questions?
No, ma'am, thank you.
Thank you. Ms. Lynch? I didn't hear you. I need audible.
No, ma'am. Can you
Okay,
hear me
thank
now?
you. I
Okay.
can. Thank you.
Thank you.
Mr. Black?
No, hearing examiner. Thank you.
Thank you. Thank you, Mr. Novella. Your excuse, sir.
Thank you, Hearing Examiner Hurst, and thank you, Hearing Examiner Fisk.
Ms. Olson, you have another witness.
I do, Madam Hearing Examiner. It might just be 2 minutes while Mr. Novella vacates the room and Mr. Martinez steps into the room.
Okay. While we're waiting for a witness, I'm had hoped we could conclude today. I don't know if that's going to happen unless people have no questions for all the rest of the witnesses. So I'm anticipating we're going to come back tomorrow, which means I'm going to try to figure out how to break the witness order near the 5 o'clock or so in a business date, since we have to come back tomorrow. Just to let you know there. The only other thing we can be thinking about that I indicated on Friday, we need to be trying to come up with definitives for briefing. I still like my proposal, but am willing to listen to others. And just to give you, again, as I age myself, preview of coming attractions, or as they're called now, trailers, for what's going to happen. Right now, I have none because I have the wrong notebook. That's okay. I have another notebook. Right now, I have 4 questions that that I'd like to be included in some kind of pre-hearing writing. I'm going to go back and discuss these with hearing examiner Fisk and see if those can be refined. So I won't tell you what they are now. We'll just have to wait. Okay, we're in the witness room. Hello there. Just need to unmute yourself. There you go. Good afternoon. Still not hearing him. Are you hearing him?
Yes, can you hear me now?
Now I can hear you. Yay!
There you go. I knew I'd eventually get it right. Good afternoon, Madam
Oh.
Examiner.
Miss Olson?
Good afternoon, Mr. Martinez.
Do you want me to?
Yeah.
Yes, yes. I just wanted her to identify her witness.
Oh, sorry, I stepped right on your toes.
No,
Please
that's
excuse
fine.
me.
No, not at all, Melissa. Yes, would you please swear in Mr. Martinez?
Since I'm overly anxious, raise your right hand. Do you solemnly swear the testimony you are about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Go ahead.
Good afternoon, Mr. Martinez. Will you please state your full name for the record and spell it?
Yes, of course. My name's Victor Martinez. That's Victor. Last name Martinez, Martinez.
And what is your current profession, Mr. Martinez?
Right now, I am the Director of Energy Resources for El Paso Electric.
And is that the title that was listed for you in your direct testimony?
It was not. It's been changed throughout the process.
Okay. And is that the title that's listed for you in your rebuttal testimony?
That is correct.
Okay. Do you have before you what's previously been marked as EPE exhibit number 3?
Yes, I do.
And do you recognize that document?
Yes, I do. That's my direct testimony.
And was that direct testimony drafted by you or under your direct supervision?
Yes, it was.
Are the exhibits identified on the table of contents as part of your direct testimony?
I'm sorry, can you repeat that? I apologize.
And you have exhibits identified on the table of contents. Are those part of your direct testimony?
Yes, they are.
And were those exhibits also prepared by you or under your direct supervision?
Yes, they were.
I mentioned that your title has shifted since your direct testimony was prepared. Do you have any other corrections to your testimony?
None.
If you were asked these same questions today, would your answers be the same under oath?
Yes, they would.
Madam Hearing Examiner, El Paso Electric offers EPE exhibit number 3 along with the accompanying exhibits.
Any objection to what's been identified as El Paso Electric 3? Mr. Martinez, direct testimony as verified by him here today. Hearing no objection, EPE exhibit 3 is admitted. Ms. Olson?
Excuse me. And Mr. Martinez, do you also have what's before you what's previously been marked as exhibit number EPE exhibit number 4?
Yes, I do.
And do you recognize that document?
Yes, I do. It's my rebuttal testimony to this case.
And was that rebuttal testimony drafted by you or under your direct supervision?
Yes, it was.
And were the exhibits to that rebuttal testimony also drafted by you or under your direct supervision?
Yes, they were.
Do you have any corrections to your rebuttal testimony?
I do not.
Is the rebuttal testimony and exhibits that you prepared true and accurate to the best of your knowledge and belief?
Yes, they are.
And if you were asked these same questions today under oath, would your answers be the same?
Yes, they would be.
And Madam Hearing Examiner, EPE offers EPE exhibit number 4 along with the accompanying exhibits.
Any objection to what's been identified as EPE exhibit 4? Mr. Martinez rebuttal testimony as verified by him here today. Hearing no objection, EPE exhibit 4 is admitted. Ms. Olson?
And at this time, we tender Mr. Martinez for cross-examination.
Ms. Stevens, you have some questions for Mr. Martinez?
I do. Good afternoon,
Okay.
Mr. Martinez. How are you?
I'm doing well, and yourself, Ms. Stevens?
Good. And I think I had a lot fewer deferred from Mr. Novella to you than Ms. Souls did. So I hope this will be relatively painless. But let me start with your rebuttal, please.
Yes, of course.
And from page 2 to page 5, you discuss some changes to your original position and basically the tables of the numbers of required recs based on something. Did that you can admit, don't you, that those changes were not provoked by your need to rebut the staff or intervener witnesses, don't you?
That is correct.
And are the round trip losses for Buena Vista 1 defined in the Buena Vista 1 PPA and the amendment to the Buena Vista 1 PPA?
I believe they are.
Are you familiar with those PPAs?
I am somewhat familiar with them. Yes, I am.
Would you please refer to CLC exhibit number 24 and number 25, which are the PPA and the amended PPA, or the PPA amendment?
You're just a bit muffled there.
Oh, I'm sorry. You know what it is? I think I've got my
There you go.
That better. I had my notebook on my computer. If only I could figure out how to get my camera so it doesn't look like one shoulder is way. Okay, so you are familiar, you have seen those contracts before? You refer to them in your work?
I have seen them, yes.
And do you agree that those are the two contracts that are at issue in this case? Well, they are. Do you understand that those two contracts are at issue in this case insofar as the company is proposing a new procurement based on a portion of those contracts?
Is this the BB1 and the BB2 contracts?
The BB1 and the BB1 amendment, BB1 and BB1 amendment.
Yes, I agree.
Okay. The city moves to admit exhibits CLC exhibit 24, the Buena Vista 1 PPA, and CLC exhibit 25, the Buena Vista 1 PPA amendment.
Mr. Martinez, have you had an opportunity to look at those and can you verify that those are complete?
Let me take a quick look at them right now.
Madam Hearing Examiner, while he's doing that, can I just ask Ms. Stevens for what purpose she's admitting these previously approved commission contracts into evidence in this case?
Two reasons. First of all, previously admitted in a different case does not put them in evidence in this case. And secondly, the new procurement, the larger, well, not necessarily larger, one of the new procurements is these contracts, or these contracts with some twists. And the record should reflect what we're buying if it's approved, or what we're not buying if it's disapproved.
Madam Hearing Examiner, I would just make clear that these contracts have been previously approved by the commission. That we're not asking to modify the contracts. The contracts are not in any way before the commission for approval. To the extent Ms. Stevens is bringing them in to provide terms of the BB1 project, I don't oppose that, but these contracts themselves are not at issue in this case, and are not subject to change or anything. They're previously approved contracts.
Ms. Stevens, is it possible that you could just ask that administrative notice be taken of the previously approved contract and its amendment. And you can give me the case number for the record in which the commission approved the original and the amendment.
Madam Hearing Examiner, I could do that. I've always read the rule on administrative notice to require that you offer the documents into the record. I know it's not a rule that's invariably followed, but I do believe that that is the rule. And I don't have the rule up right in front of me. I see that you do. And I can tell you, I know this because I've been burned the other way, by not having it in hand, the document in hand.
Well, the section on administrative notice is 1.2.2.35, and it's the general rule of evidence. Section D, Commissioner presiding officer may take administrative notice of the following matters, if otherwise admissible under section A of 1.2.2.35. And among those include rules, regulations, administrative rulings, published reports, licenses, orders of the commission, the governmental agencies, decisions, records, and transcripts of other commission proceedings.
And I'm sorry,
So I think that.
Could you give me the citation again, please? Because I've lost.
Yes, ma'am. It is 1.2.2.35D. And I would offer to you, Ms. Stevens, that that I believe, and it does say on section 3, parties requesting administrative notice to be taken of the documents or contents must submit those documents to the commission in the form of exhibits.
That's the part, having been on this side of the bench, Madam Hearing Examiner, that's the part that I'm attempting to follow.
Okay. Well,
if it's not a hearing examiner, I don't object to taking administrative notice, and if no other parties object, I don't see that it would become an issue.
okay. Well, it doesn't sound like there's an issue to have the document in the record so the commission can have an immediate reference in the transcript. So is there any objection to taking administrative notice and admitting CLC Exhibit 24? Hearing none, CLC, will take administrative notice of CLC 24 and admit it. Is that all right, Melissa?
Sure.
Okay, well, we've got the definitive word now, so I want to make sure that it's good with Melissa, so we're all right. Any objection to taking administrative notice of CLC Exhibit 25, which is the Buena Vista amendment to the PPA? Hearing no objection, CLC 25, I'll take administrative notice of and admit into the record.
Thank
Ms.
you.
Stevens?
Thank you. Let's get back to business here, Mr. Martinez. Again, I'm in your rebuttal testimony, page 8, lines. Oh, geez. This is question numbered 16, beginning on line 4, and you describe how at the time EPE's plan was filed, EPE's understanding was that the volumes were volumes delivered at the point of interconnection, and this understanding has changed. Is that is that an aspect of the relationship with, or the contract with Buena Vista, a function of the language that's in these two documents that we just submitted into evidence?
Yes, after kind of going back and reading the contract, we ended up realizing that what my understanding was in my direct testimony wasn't necessarily the case. So we went back and corrected in my rebuttal.
And do you remember whether in previous cases, including 2293, 22000093 UT, and the Buena Vista amendments case last year, 19-0099 UT, 19-00348, do you recall whether the city of Las Cruces through Ms. LaRock pointed out that there was an issue about the about the round trip losses?
Madam Hearing Examiner, I'm going to object to this questioning as irrelevant to this proceeding.
Ms. Stevens?
If you let me, the next question is just why did it take this long to make this change if it's based on the contracts that were in existence? And
Well, there's an objection to your first question.
So
maybe
the relevance is that the company has had opportunities to be aware of this change that they're making. And I'm going to ask him, I would like to ask him why they're making the change now.
I think that's the operative question. So I guess I'll overrule the objection and ask you to answer the last question posed by Ms. Stevens. Mr. Martinez, why'd you make the change now?
Well, it's
what caused you to make it?
Yeah, well, we made it now because that's actually when we noticed that it was incorrect. I wouldn't be able to tell you exactly why it was not done before. This is a PPA that was, it was as a result of the 2017 RFP. And I believe the contract, I need to double check, but it was signed, I believe, somewhere around 2019. And there's really no reason for me to go back and reread or go through it. So there was just no reason to do it before. And that's pretty much the best I can answer.
Go ahead, Ms. Stevens.
Okay. Mr. Martinez, did you perhaps become aware of this issue, notwithstanding it having been raised in past cases, when the time actually came to have some billings and money flowing back and forth between the company and El Paso Electric, between El Paso Electric and NextEra?
That was not the case. I believe as a result of one of the RFIs that came in. And at the time when the RFI came in, we started, it took us back to the PPA and when we realized that we had misunderstood it and corrected it in our rebuttal.
And you're referring in RFIs, you're referring to the September 15th, 2023 request for proposals?
I do not recall the exact date. I know it's just one of the RFIs from the city of Las Cruces that came in.
Oh, request. Okay, you use RFI. You're talking about discovery request. I thought you were
discovery request.
Okay, gotcha. Okay, and now I understand. And is that if you look at exhibit CLC 23, please.
Give me 1 second, please. Okay, I'm there.
Okay, is that the request for an RFI or an RFI request for interrogatory and request for production of documents that you were referring to?
That's it, Ms. Stevens.
And with that, I move to admit CLC exhibit number 23 into the record.
Mr. Martinez, you've seen CLC 23?
Yes, I have, ma'am.
And you were a sponsor on that?
Yes, I was, ma'am.
Any objection to what's been identified as CLC Exhibit 23? Hearing no objection, CLC 23 is admitted. Ms. Stevens?
Yeah, let's hope we can go a little more quickly through the change on the CRLEF amounts. Again, you had last year's figures for CRLEF, at least by the time that the company filed its 2022 annual report on May 1st. Would that be the case?
Yes, I believe
that was a couple, no, June, 2 months before.
Can't talk at the same time.
That was a couple of months before you filed your application in this case.
I believe so.
And can you explain why you didn't pick up on this proposed revision prior to filing your application, the company's application in this case?
I wouldn't be able to tell exactly the reason why. Like as mentioned in my rebuttal testimony, in the past, when we were looking at the energy from CRLEF, we would typically be looking at the RECs generated. And we just continued doing that from previous experience. As mentioned in my rebuttal testimony, in the past, the RECs generated by CRLEF were were very close to the energy produced by CRLEF. So in the past, we would just simply look at the RECs, and we did the same thing this year.
Okay. Now let's go back to your rebuttal testimony. Set my exhibits and maybe find your rebuttal testimony on my screen. I'm looking at table VMR1, which I don't have a note on the page number. It'll jump
Page
right
9.
on in. Roll through here. There it is, VMR1 on page 9 of your rebuttal testimony. This exhibit only shows the impact of the changes to round trip losses and CRLEF RECs under the contingency plan. Is that right?
That is correct.
And you did not provide a parallel exhibit for the baseline plan.
That is correct.
Would the change in the baseline plan amounts be essentially the same amounts, relatively modest differences?
If we were to update our baseline, yeah, they would show the same adjustments to the CRLEF energy, which is it's in the RPS energy approved resources line, and it would also affect the planned round trip efficiency losses line in that table by the same amount.
By the same amount. That's okay. Now we're going to go to one of the questions referred to.
I'm sorry, I'm not hearing you very well.
Yeah, you're
Oh,
muffled
sorry.
again.
I know what it is. I put my tablet down on my computer again. I don't even know where the sound is. I will not do that. Okay, so Mr. Novella referred to you the job of explaining just how contingent the contingency plan is. Can you explain to me just very kind of step by step under and I won't even ask you what the original testimony seemed to provide, but just in your final position on, first of all, on the DG Rex, if your position is if that's approved, the company would
Really getting compound, Miss Stevens. You need to ask one question at a time.
DG Rex. The company's final position on that is that the DG Rex would begin as of January 1st, assuming that the order comes out year end?
I believe so, yes.
And they would continue throughout the year of 20?
Yes.
And they would, because it's a tariff, they would continue, that process would continue into the following year and future years unless the commission or the company sought to change it.
That was our position, yes.
And the amounts will be based on the eligible RECs produced. You will not make any monthly adjustments for your need or your quote unquote contingencies. Is that right?
As far as monthly adjustments, that specific question, I'd probably defer to Mr. Shisto. I believe there would be some monthly adjustments, but I think he'd be a better person to answer that.
Well, I'm thinking monthly adjustment. Don't take this too literally. I'm talking about monthly adjustment in the sense that if Hecate came online in June, you would not cease giving people those credits. Is that right? That's the company's position.
I believe the company position on DG Rex is that we would continue doing it, whether Hecate would come online or not, and continuing forward until the commission's either disallows it or disapproves it. And it's because we feel it's a way to be able to meet our customers' RPS needs at the lowest possible price.
Now the proposed Buena Vista 1 reallocation that does have some contingencies within the year. Is that correct? As defined. And is it the company's position that if the proposal as presented were approved, you would start allocating the extra 8.69% in January?
Yes, in order for us to be able to attain the RECs needed, I believe we said we would allocate a total of 30% of Buena Vista 1 to New Mexico. And in order for us, with the 30%, and in order for us to be able to retain the 30,000 RECs at the end of the year, it would have to start in January.
And but there's other testimony that says that, let me find it. Give me a second here. Page 17, lines 16 through 19 of your rebuttal.
Yes.
And that testimony says if the contingency plan is approved, EPE can begin the allocation at any point in 2024 to make up for any portion of energy and RECs projected to be provided by Hecate if Hecate does not meet the June 2024 COD. So what does that can begin the allocation at any point in 2024 mean in terms of the whole idea, the whole reallocation being contingent on the June 2024 COD?
The easiest way of looking at it is we're going to need 30,000 RECs for the entire year. In order for us to be able to attain the 30,000 RECs from the Buena Vista, we would either have to start procuring a total of 30% of Buena Vista starting in January, or we could start in June, but the allocation would have to be higher, which would be closer to about 50%. So either way, we need 30,000. We can either spread out the 30,000 throughout the full 12 months, or we can spread out the 30,000 within 7 months.
And my question to you is, what actually is the company's proposal right now? Because I'm very confused.
Okay. Well, our proposal is for us to be able to start in January and just allocate a total of 30% of Buena Vista to Mexico. And by doing 30% in January, will get us to the 30,000 at the end of the year.
But now this 30,000, if Hecate comes online in June 2024, under your baseline plan, you're going to end up with something like 119,000 megawatt hours from that and a annual surplus of 79,000 megawatts. So when do that need for 30,000, you are assuming no Hecate at all, right?
In our contingency plan, yes.
Okay. And again, please look at your testimony, your rebuttal testimony here, and tell me what it means that by Alternatively, if Hecate, this is, let's beginning at line 18 on page 17.
Okay.
Alternatively, if Hecate is in service by June 2024 and EPE has sufficient energy and RECs to meet plan year RPS, EPE will not reallocate any Texas BV1 energy to New Mexico, effectively EPE's baseline plan. Can you
Yes, I'm sorry.
explain? That seems to me to say that I don't want to be trying to. Can you explain what that testimony means in light of what you just said about the plan would be to start reallocating on January 1st?
Well, again, our contingency plan is for us to be able to, in essence, parse out the 30,000 RECs that we would need from Buena Vista within a 12-month period. However, if Hecate does come online in June, we could potentially just stop the reallocation and just continue moving forward with the RECs received from the RECs and energy received from the Hecate facility.
And is that a change from your own rebuttal testimony, or is that your literal reading of what you said here? EPE will not reallocate any Texas BV1 energy to New Mexico, effectively the baseline plan.
So here's the thing, if, I'm sorry, can you repeat the question again? I just want to make sure I understood it correctly.
What you just testified to orally, is that, do you believe that that is consistent with your written testimony from last week that says if Hecate is in service by June 2024, blah, 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 EPE will not reallocate any Texas BV1 to New Mexico, effectively EPE's baseline plan? None.
Okay. So the way I interpret what I wrote is that we would follow the contingency plan, which means we will start allocating RECs starting in January. Once we get to June, if Hecate happens to meet COD in June, then we would just stop the reallocation at that specific time and just continue moving forward with the RECs and energy generated from Hecate.
So you would end up, are you going to give back or rebalance the balance the other way if you don't need them?
For that one, I'd refer to Mr. Schiestel. I think he'd be a better person to be able to address exactly what we would do if we're faced with that situation.
And if that were the situation, would ratepayers be compensated for the fact that they paid the extra Hecate price and the extra $5.40 for DG Rex?
Again, that'd be another question better suited for Mr. Schiestel.
You're the one who testified. Mr. Schiestel does not testify about the details of the plan. So I'm going to ask you to do your best.
Madam Hearing Examiner, I'm not sure that's right. I think that exact question that Ms. Stevens asked is addressed in Mr. Schiestel's rebuttal testimony.
Maybe I'm mistaken. Excuse me, maybe I'm mistaken. I don't recall him getting into the weeds.
Well, so we're not holding things up. Let's just say we'll defer that to Mr. Schiestel, and if Mr. Schiestel says nope, that's Mr. Martinez, then Mr. Martinez can come back.
I was
okay.
Maybe Mr. Martinez will want to reconsider his answer. He's at risk of having to come back. I'll
go ahead.
Thank you. I'll move on. Okay. Let's talk about your rebuttal testimony at page 10. Is it when page 10? When under the heading alternatives to BV1 reallocation.
Yes,
And here you talk about you refer to the September 15, 2023 request for proposals issued to meet RPS requirements, correct?
correct.
And you say that you sent it to 85 entities, got 3 notices of intents and only 1 actual bid. Is that right?
That's correct.
Do you consider that to be a competitive procurement, Mr. Martinez?
I would, it was done through a competitive bid process. So yes, I would consider that.
And your RFPs do say that the company always has the opportunity to not purchase anything, right?
That is correct.
And if this were for a long-term purchase power agreement or for a generating station, a company-owned generating station, would the company go forward on a single or rely on a single bid, or would it revamp the RFP?
Well, if it was just for energy only, I don't think we would have this problem. Being the fact that our RFP was done specifically for renewable resources, I think it's just an indication that there's just really not much of a market for renewable energy out there.
Would you please refer to exhibit CLC exhibit 18, please?
Give me 1 second, please. CLC 18?
18.
I have it open.
You're faster than I am because my boxes. No, please. Well, since you're there and I'm not quite yet, do you recognize this as, where did it go? Oh my. Okay. Do you recognize this as a response to a discovery request that both you and Mr. Novellis prepared and sponsored?
It does look familiar. Yes.
And are there attached to this, or was attached to this discovery request 2 RFPs?
Oh, I'm scrolling down. Yes, looks like they are.
And attachment 1 is an RFP issued in September 2019. Is that right?
That is correct.
And that is not the RFP that you referred to earlier as having taken place in 2017 that actually got you Buena Vista 1, right?
Yeah, the RFP that got us Buena Vista 1 was the all-source RFP in 2017.
Mm-hmm. This September 19th, 2019 RFP, is this the one that's referred to in the bench request response?
I believe it is.
And was this a short-term request for renewable energy for RPS purposes?
Yes, correct. That's what this RFP was for.
And then attachment number 2,
Mm-hmm.
which is begins on page 9 of the PDF. And this is the one that the company issued this fall. Is that right?
Yes, I believe so.
And it's the one for which you received 1 bid.
Correct.
First of all, why did the company wait until September 15th, 2.5 months after you filed the application in this case to issue this RFP?
Well, we have tried it before and again in 2019, and when we submitted our 2021 New Mexico RFP, we also requested short-term renewable bids as well, and we just haven't received any bids in the past. So there's really, we saw there was really no point at that time to submit an RFP, knowing that there's really not much a renewable market out there.
Well, then what was the point of doing it in September of this year after the case is already filed?
Well, we just thought we'd give it one more shot.
Would you actually look at the terms that you're seeking?
Mhm.
And I'm on page 3, attachment 2, page 3 of 4.
Yes, correct.
The list says product firmness WSPP Schedule B.
Mhm.
Just in very, lay terms for those of us who are not WSPP experts, what is the product firmness of a Schedule B?
It's for unit contingent power.
And these products, the 4 products that you've listed here, product 1 is, does that mean 6 by 16, 6 days a week, 16 hours a day?
Correct.
And product 2 is 7 by 24, is 24 hours a day year round?
Correct.
Except excluding holidays. So that's, are those products that a standalone solar or wind facility could possibly comply with absent battery storage?
Potentially, we feel that one of those products would be able to fit a renewable project.
No, but how could a solar facility without, you said it's unit contingent, that's even more so. How could a unit contingent solar facility provide power 16 or 24 hours a day?
Well, it could potentially provide 16 hours a day, but not 7 by 24. But wind could potentially be able to do something of a 7 by 24 product.
And would that take, well, you said it's unit contingent. Can you have a unit contingent wind PPA that has the turbines scattered geographically far enough apart that you'll have wind? You can be sure you'll have enough wind?
Yeah, so when it's unit contingent, that means it's contingent on the unit generating. So
Right.
we would not make them firm, because I don't think anybody would be able to firm up power coming from a renewable resource. So the best option for that would be making unit contingent, meaning that we would only pay for the power that's generated from the facility, and would not be seeking liquidated damages if they don't deliver the full amount.
There was a lot packed in there, so I'm going to ask you to break it down a little more for me. So the product that you were asking for, the product number 1, 6 by 16, that's 6 days a week, 16 hours, and you're asking for 10 megawatts, going up a little higher, 10 megawatts up to 50 megawatts. And then if we go, I think, to the preceding page, the general overview, was there a quantification of the desired amount of energy in terms of megawatt hours? I don't see that, but maybe I've missed something. Oh, here it is. I'm looking at the pricing matrix, and that's on page 4 of 4 of attachment 2. Why are you asking for quantity in megawatts and this other information and a premium in kilowatts per month, dollars per kilowatt per month, when what EPE needs for RPS purposes is just sheer energy, any sheer renewable energy any time of the year.
Madam Hearing Examiner, I'm going to object to the question as compound and
Okay.
a lot of lawyer testimony. It seems like there's a lot of assumptions going into these questions.
Ms. Stevens?
I think that Mr. Martinez is following where I'm at. If you want me to try to state it a little more succinctly.
Yeah, why don't you do that?
Okay. Let's look at let's just look at the pricing matrix page. And is it true that the company is looking here for pricing in terms of megawatts of that unit, and not a request simply for megawatt hours that would coincide with RECs?
Would be mainly looking for megawatt hours.
Well, are you looking for megawatt hours, but asking people to tell you what the quantity is in megawatts?
If it's coming, we wanted to give the bidder an option to be able to bid. Again, I'm going to give an example. Let's just say if it's a 25 megawatt solar project, then that would allow them for them to put 25 megawatts, but then be able to put on the megawatt hours, how many megawatt hours they expect for the month off of that 25 megawatt facility.
Explain to me where in this RFP pricing matrix or anywhere else in this RFP is anywhere for the party to tell you, the bidder to tell you how many megawatt hours they're going to provide or expecting to provide in each of the months.
Under the okay, I see it now. Yeah, we're mainly looking for the RFP was for megawatt hours. Now in this specific matrix, the bidder would be able to put the amount of megawatts that the facility is coming from, and then and in essence, we would take either a portion or all of the RECs generated from that megawatt facility. So again, for example, if somebody bid in a 25 megawatt solar facility, then under quantity megawatts, they would put 25 megawatts, and then they would just say EPE would purchase all of the megawatt hours from that facility.
And where in this bid form would you know how many? I do see now on the first page it says that EP is looking for up to 320,000 megawatt hours.
Correct.
But how would you know that a particular bid, assuming that you got more than one, how would you know how many megawatt hours you were expecting, and I'm not saying guaranteed, obviously, because it's renewable, you were expecting to get just on this form? I don't see it.
Yeah, so from the one bid received, they did provide a table of what the megawatt hours were for the last year, and then and that's all they provided. So one could assume it'd be the same amount minus degradation, which would be approximately about 5% degradation, or I apologize, 0.5% degradation.
You didn't ask for that information though in your RFP. That's not what the information you asked for. Is it?
We wanted up to what was the number again?
320,000?
There we go. We were looking for any part of 320,000.
But how would you know how many? How would you know how many of them to sign it? Let's say you got.
I think he already answered that. They
Okay.
provided a table. I think you need to move on.
One of them provided a table, but if you had gotten multiple parties and some of them provided a table and some of them didn't, how would you know what to procure?
Madam
Assuming
Hearing
the
Examiner,
price were equal.
this is all completely speculative and not relevant. There's one bid. That's what we got.
Ms. Stevens?
Well, the point of the question is that when EP goes out looking for something that they're not going to get, or that they're only
I don't
going to
think
get
that's
one
responsive
item.
to the question, to the objection, Ms. Stevens.
The city's object.
She's saying you're asking speculative questions. There was only one bid. What's your response?
The response is that I would like to ask questions about this RFP, because I think that it's possible that the terms of the RFP itself are one of the reasons, if not the primary reason, why the company only got one bid.
Then I think Ms. Stevens should ask questions about the terms of the RFP, not hypothetical scenarios of if
Okay.
it had happened.
I agree with you, and I'm going to sustain that objection. If you have any more questions,
Let me.
I'm going to have to
one
be.
quick look.
I'm going to tighter on your time, Ms.
Tighter on my
Stevens.
time. Okay, I think that's probably. I would just move to admit CLC Exhibit 18.
Madam Hearing Examiner, I'm a little bit concerned about CLC Exhibit 18 because EPE provided 2 supplemental responses to that discovery, and so the initial response that Ms. Stevens is seeking to put into evidence isn't complete because it doesn't have the 2 supplemental responses.
Ms. Stevens?
I have to go check what the supplemental responses are. I don't think that they're. I obviously they didn't alter the key thing here is the 2 documents, the September 2019 one that was referred to in the bench request response commission Exhibit 1, and the September 15, 2023 one, which is referred to, I think, throughout Mr. Novella's rebuttal and Mr. Martinez's rebuttal in terms of prices being 3-4 times as high. I don't think that anything. It's impossible that the RFPs changed unless there was a mistake in what they produced the first time, and I don't remember seeing a discovery response that said we gave you the wrong RFP.
If their representation is being made that CLC 18 has 2 more supplemental responses, I'll give you the opportunity to review the 2 supplemental responses to see if you want to include them. So
I'd be happy to include them if you give me the time. I mean, I can find them. I just can't do them right now. So if I could,
okay, I'll take it under advisement.
And
Yep.
give me direction as to when. I mean,
Madam Hearing Examiner, to make it easier, if Ms. Stevens will stipulate that the sole purpose of bringing in this discovery response is just to get in those 2 attachments, attachment 1 and attachment 2, the RFPs, I don't have a problem with that.
thank you. That would be perfectly fine with me.
So the supplemental responses weren't additional parts of the RFPs that got left out.
No, the second supplemental response was providing the bids to the RFP, which were provided as confidential.
Yeah.
And the first supplemental response, I can't remember exactly what it is. But if it's what's in the record is those 2 RFPs, then
yeah.
Okay, if that's
and I certainly have no desire to put a confidential exhibit. I just found that one of my things. I have no desire whatsoever to confuse this case and raise new issues by bringing in confidential information.
All right. Any objection to CLC 18, the 2 RFPs? Hearing none. CLC 18 is admitted.
Thank you.
Ms. Stevens, are you going to have any more questions?
I have, let's see. Oh, yeah, at page 11, this.
While you figure it out, I just was asking for quantity.
I have one question on that page. I have about 10 minutes more, maybe 5.
All right, well, we're
Okay.
gonna go ahead for the benefit of court reporter and myself and take a 10-minute recess. I have 3:40. We'll come back at 3:50 and you can ask your questions. And I just warned you, Ms. Stevens, you're already over 3 hours
Oh, am I?
of questioning, where you told me
Two.
on Friday you had 2 hours and a half for everybody.
Yeah.
So you're
And I
gonna need
have-
to move on, and otherwise I will just take notice of this next time and I will put very strict limitations
And
on exactly what people tell me at the pre-hearing. So we're recessed for 10
yeah,
minutes.
Madam Chair, I just want you
Remember
to know,
the
better.
YouTube is still streaming.
I have no, Madam Hearing Examiner, I have no questions for the next 2 witnesses and only the deferred questions for Mr. Schiestel. Okay.
Good boy.
Okay. I believe we are back at 3:50.
Okay,
Go ahead. We're
okay,
back from our recess.
thank you. Mr. Martinez, I really will keep this seriously short. Oh, you moved on my screen. There you are. So would you turn to page 11 of your rebuttal testimony
Yes.
and carrying over to the bottom, carrying over to top of page 12. You testify, beginning on line 19, that the commission could deny the proposed procurements and order EPE to instead purchase available short-term energy to meet obligations under the REA plan if Hecate is delayed. However, a short-term energy purchase may be substantially more expensive to customers, assuming that short-term energy is still available. Is it your testimony, I think, and Mr. Novello's as well, that the prices bid for you were something like 3 or 4 times as high as the Buena Vista one price?
Yes, that is correct.
That would be in the neighborhood of $100 or more per megawatt hour. And are you familiar with the RCT provisions of the Renewable Energy Act?
Yes, I am.
Would EPE be required to purchase energy at $100 a megawatt hour in order to fill its RPS requirements?
Well, what we're stating is that if the BB1 procurement is not approved, and if the DG-REC purchase program is not approved, and if the commission, in essence, ordered us to do it, then we really would not have any other choice but to go with this really expensive short-term RFP proposal in order for us to meet our RPS requirements.
But you're not denying that there is an RCT in the statute that would have some impact on that, are you?
Correct. I'm not denying that.
Very quickly, I'd like to go to page 21 of your testimony and ask you of your rebuttal and ask you some of the same questions that I asked Mr. Novella about the planning margin.
Mhm.
And I have page 21. And that starts planning margin on page 21. Has EPE previously proposed contingency plan for RPS compliance, to your knowledge?
Not that I know of.
And has EP previously proposed obtaining new resources in order to achieve an excess of almost 34,000 RECs? New procurement.
Yeah. So in order for us to be able to meet our RPS target, there must be some excess RECs. We're either deficient, we're either right on the money, or we're excess.
Yeah.
So, regardless of what procurement we put out there will always be some excess in order for us to be able to reliably meet our RPS requirement.
And are you aware of any other utility that has actually obtained approval of a contingency plan in a circumstance in which their baseline plan, their approved resources would put them at above the RPS?
I would not know that.
Mm-hmm. Okay, so I just have in last year, you testified in last year's RPS case, which seems like only yesterday, doesn't it?
Right.
It was only yesterday. So, and in that case, you provided a lot of evidence about the specific requirements of Rule 572 and the Renewable Energy Act, didn't you, Mr. Martinez?
I believe so.
Yeah, you and Mr. Novella sort of split it up, right? I'm having difficulty finding things in this year's application that systematically address those requirements. Can you point to evidence demonstrating that the proposed Buena Vista One reallocation and or the DG Rec purchase program was the result of a competitive procurement that included opportunities for bidders to propose purchase power, facility self-bid, or facility build transfer options?
Well, the BD1 procurement was as a result of a competitive bid process. Again, a result based off of our 2017 outsource RFP.
And that was for BV1 in 2017, correct?
Correct.
And that was with battery storage?
That is correct.
And the procurement you're proposing now doesn't include payments for the battery storage. So does that mean it does not include the battery storage?
Right now, we would only be allocating the energy, not the battery component.
Okay. What will you be doing? What would you be doing with the battery component if you don't allocate it in sync with, the share of the overall project?
Well, the capacity component would still be split based off of the jurisdiction allocation, would be approximately 2179.
And since asking you what the operational consequences of that are is going to probably take a 10-minute answer, if not longer, I won't go there.
Okay. Unless
you have a really short answer, which I'd be impressed if you did. Okay, so in general, Mr. Martinez, would you view a bid received in 2017 as representative of a competitive procurement in 2023?
Most definitely, especially when you compare it to our most recent procurement of the DESRI contract. That is a new procurement for 130 megawatt solar facility coupled with 65 megawatt battery. Expected COD in May of 2025. You'd see that the BB1 procurement is including the REC price is right in line with just the energy component of that DESRI procurement.
Okay, and I think that with that answer, you're responding to another requirement of the rule about a comparison of the bid prices received to other prices in the southwestern United States. Is that what you're getting at there with the comparison to Carne?
Yeah, I wanted just to show that it is competitively priced, especially when you look at our latest RFP.
And do you understand that there's a difference between competitively priced and the result of a competitive procurement process?
I may not know all of the intricacies between that.
So you're not certain of that. Okay, well, let's see. In your testimony, you're direct, I guess. When you're direct again, let me make sure. Yeah. Go back to your direct for a second. On page 28.
Okay, I'm there.
You're faster than I am. This is under the heading conveniently of other Rule 572 requirements. And on the question and answer beginning on line 14 through line 19, it is the company's testimony, your testimony on behalf of the company, that the baseline plan is consistent with the most recent accepted IRP of the company? Is that right?
I believe it is.
But what you're asking approval for is the contingency plan? Is that right?
That is correct.
And the contingency plan, you state here that EPE will file a notice of material change to that IRP, correct?
Correct.
Have you anywhere pointed out in your testimony or some other witness's testimony what the differences between the the contingency plan and the IRP are? What are the material differences?
The material difference would be the COD of Hecate being moved.
Okay. I think I have no further questions. Thank you, Mr. Martinez. Good to see you again.
Likewise, thank you very much.
Thank you. Ms. Souls, do you have any questions for Mr. Martinez?
Yes, ma'am, I do.
Go
Good
ahead.
afternoon. Good afternoon, Ms. Martinez. Good to see you again.
Likewise.
Would you please go to page 6 of your direct testimony?
I'm there.
At line 6, you reference supply chain delay risks. Are there specific supply chain issues that El Paso Electric is facing now?
I believe there would be. I think any questions specifically to supply chain issues, I think that'd be a better question answered by Mr. Brent Davis.
Will Mr. Davis be able to answer supply chain questions regarding what Hecate is facing?
Yes, he would be.
And also regarding what Desri is facing with the Carne project?
If there's any, yes, he would know.
Thank you.
Mhm.
If you go to page 11 of your direct testimony, beginning at line 9.
I'm there.
You are describing El Paso Electric's proposal for new procurements as part of its contingency plan. Is that correct?
That's correct.
And would the proposed rent purchase program for renewable DG customers, would it add additional renewable energy to Epe'S system?
Don't believe it would be.
Would the proposed rent purchase program cost El Paso Electric's New Mexico ratepayers more money?
It would be, but as Mr. George Novella explained, it'd be less than the alternative of either increasing the B1 procurement or having to go out for a short-term renewable procurement.
And with those caveats, it would still cost El Paso Electric's New Mexico ratepayers more money than they are paying today. Is that correct?
Pretty much, in order for us to be able to meet the REA requirements, I think there will be some increase regardless of what scenario we use. We're just trying to choose a scenario that'll be the least cost to our New Mexico customers.
Would the proposed REC purchase program cost El Paso Electric more money?
I don't believe it would.
Would the proposed reassignment of energy from Buena Vista 1, would it go through the battery?
Some of it would be, yes.
And yet, do I understand correctly, you're not proposing to charge New Mexico ratepayers for anything additional related to the battery? Is that correct?
That's correct, just the energy component.
With the proposed reassignment of energy from Buena Vista 1, would it add additional renewable energy to El Paso Electric's system?
To its system, it would not.
Would the proposed reassignment of energy from Buena Vista 1 cost New Mexico ratepayers more money?
Yes, but compared to the alternative, it would be less.
Would it cost New Mexico ratepayers more than what they currently pay for energy and RECs from Buena Vista 1?
Yes.
And with the proposed reassignment of energy from Buena Vista 1, would it cost El Paso Electric more money?
It would not.
Okay, thank you. I'd like you to go to your rebuttal testimony, please.
Yes,
At page 9.
I'm there.
Your table VMR-1. What does this table reflect?
This table is our contingency plan, making two modifications. The first one is the modification to the energy for our CRLEF QF facility. And the second one is for counting for round trip efficiency losses due to the BV1 battery.
And do you provide an updated baseline plan reflecting those updates related to CRLEF and the planned round trip efficiency losses?
We did not update the baseline.
Thank you. In this table, the column representing 2025, is that a contingency plan?
The only part of a contingency plan that it would have, it's the DG rec purchase, but the reallocation of BV1 is not included in 2025.
And that column seems to indicate that you expect to have an excess of recs on the order of 107,452. Is that correct?
That's correct, ma'am.
Would you agree that the DG rec purchase in 2025 is not necessary to satisfy your 40% RPS requirement?
I would say so.
Thank you. Also in the column for 2025, on the line planned New Mexico allocated energy from Hecate 1 and 2. There's a value of 204,401 megawatt hours. Do you see that?
Yes, I do.
Does that represent a full year's output from Hecate 1 and 2 for New Mexico?
It's yes, it's a full year of output that's allocated to New Mexico customers.
And am I correct, you expect no output from Hecate 1 and 2 in 2024?
Based off our contingency plan, that is correct.
Do you expect that Hecate will achieve COD, which I think stands for commercial operation date, achieve COD before the end of 2024?
I think for that, it'd be a better question to Mr. Bryn Davis. I think he'd be a better person to answer that question.
Would you agree that with your table VMR1, that you're making the assumption that Hecate 1 and 2 will achieve COD exactly at the end of 2024?
It would be, yes, or the beginning of, mainly the assumption that it'll begin exactly on January 1st, 2025.
That's a better way to do it. Thank you. So do you expect Hecate will generate renewable energy prior to achieving its COD?
Yes.
And do you expect that renewable energy will create RECs?
I believe so. The test energy, as long as we're able to register the facility within 90 days of COD, we should be able to go back and claim the RECs, any test energy that occurred during the testing phase.
Thank you. Mr. Novella has testified that El Paso Electric's proposal to reallocate a portion of BB1 would be reallocation until Hecate 1 and 2 have achieved COD. Is that what you understood him to say?
Yes.
And is that what's represented in your table VMR1?
I believe it is.
Very well. And the column for 2025, and this time related to planned 2025 New Mexico all source carne project. Do you see that?
Yes, I do.
You indicate an expectation of 265,562 megawatt hours. Does that represent the expected output from carne, assuming carne achieves its contractual COD of May 1st, 2025?
That is correct.
And is it correct that El Paso Electric's 2025 plan presented for informational purposes here in table VMR1 depends on several factors that are not already in place? I'll go farther. Would you agree that it depends on Hecate achieving COD by the very beginning of 2025?
I'm sorry, Ms. Silva, would you mind repeating it? I think I'm a little bit lost.
This 2025 plan depends on, now I'm going to list them and ask you to respond yes or no for each one of these. Would you
Okay.
agree that it depends on Hecate achieving COD exactly by the start of 2025?
Yes,
Would you agree that it depends on the commission approving EPE's DG rec purchase proposal?
yes,
Would you agree that it depends on at least 10 megawatts of community solar commencing operations before the start of 2025?
I would say probably sometime in 2025. We're accounting for a total of 10 megawatts. We're only accounting for 10 megawatts in 2025. Meaning it could be I apologize. It could mean either the full 10 megawatts starting in January or possibly up to 20 megawatts starting mid-year, but we're only accounting for 10 megawatts for the year.
And would you agree that that is not currently in place, that that's a projection, an expectation?
That is correct.
Would you agree that it depends on EPE's planned 2025 New Mexico All-Source Carnate project achieving COD no later than May 1st, 2025?
That is also correct.
Would you agree that compared to all of the other things, this is a fairly long list of things that are not yet in place that we're a short 14 months away from? Would you agree with that?
Yes.
Thank you. Please go to page 11 and beginning at line 19.
Okay, I'm there.
You state the commission could deny the proposed procurements and order El Paso Electric to instead purchase available short-term energy to meet obligations under the REA for plan year 2024 if Hecate is delayed. That's your testimony?
Yes, it is.
Would such a purchase add additional renewable energy to EPE's system?
Yes, it would.
Please go to page 14 at line 6.
Okay, I'm here.
You're discussing the financial cost to New Mexico customers related to staff's proposal to remove 44,016 of DG recs at the $5.40 per rec and replace with BV1 energy and recs at a price of $29.64 per megawatt hour. You state that this results in an additional $1,066,948 cost to New Mexico customers. Is that your testimony?
Yes, it is.
Does that additional cost to New Mexico ratepayers of over $1 million result in additional renewable energy on El Paso Electric's system?
The additional cost of energy allocated to New Mexico customers or renewable energy allocated to New Mexico customers.
Is it additional renewable energy on El Paso Electric's system?
Not on the system.
Would the proposed reassignment of energy from Buena Vista 1 cost New Mexico ratepayers more money? Mr. Novella said yes. Do you recall that?
I'm sorry, can you repeat it again? I believe so. Can you just repeat again?
Would the proposed reassignment of energy from BV1 cost New Mexico ratepayers more money?
Yeah, I think any procurement to meet REA, it's gonna cost money. So yes,
And
right.
the proposed procurement, would it cost New Mexico ratepayers more than what they currently pay for energy and RECs from BV1?
In order to meet REA requirements, any procurement will add more than what they're paying right now.
That's not really what I'm asking you. Would you agree that New Mexico ratepayers do get energy and RECs from Buena Vista 1 right now?
Yes, but not sufficient to meet the REA under our contingency plan.
And the price that they pay for that is what?
I believe it is $24 per megawatt hour.
Would you agree that is less than this proposed price of $29.64 per megawatt hour?
Yes, of course.
Now, I'm not sure this references to beginning at line 21. I don't think it's in your testimony. It was in Mr. Novella's testimony. I asked him about El Paso Electric intends for the BV1 reallocation to continue until EPE's Hecate 1 and 2 are commercially operational. And he said that was correct. But then I asked him, by commercially operational, do you mean until Hecate 1 and 2 achieve COD? And he referred that to you. Is that what commercially operational means to you?
There was a lot of things to that, but commercially operation means when the facility is up and running and it's transferred to EPE for us to be able to use it under normal operation.
Is that synonymous with achieving COD?
Can you repeat the question, please?
Is commercially operational, does it mean until Hecate 1 and 2 have achieved COD?
I'm sorry, Ms. Holmes, I'm not sure if I'm understanding your question. You're asking if COD is tied to Hecate 1 meetings. I apologize. I'm not following.
This was related to how long El Paso Electric intends for the BV1 reallocation to continue.
Okay, according to our contingency plan, the allocation of BV1 is only contingent on Hecate meeting its COD.
And you intend to say COD. Is
Yes.
that correct?
Yes,
You are not talking about test energy. Is that correct?
that is correct.
You're not talking about all the other things where Hecate 1 and 2 could be producing renewable energy and RECs. Is that correct?
Our contingency plan assumes Hecate will not be there at all in 24. So, which means there would be no test energy according to our contingency plan. There'd be no test energy, there'd be nothing in 24.
How does that relate to the official COD?
Again, if you want to see how this relates to the official COD, I would defer this question to Mr. Brent Davis.
Very well. Previously, when I've asked Mr. Davis such questions, he has not been able to reply. Madam Hearing Examiner, could I reserve that Mr. Martinez may come back if Mr. Davis can't answer this?
Well, I mean, I think he's answered your question as best he can. And he's telling you he's giving you what he knows. And if you want any more, you're going to have to get it from another witness. So I don't know that he's going to be able to tell you anything else, Ms. Souls.
Very well. Mr. Novella also referred my questions regarding an additional 8.69% would be initially assigned to New Mexico customers with additional reassignment as needed to fully meet 20% RPS in plan year 2024. Do you recall that?
I believe so, yes.
Does El Paso Electric consider the additional 8.69% to be the minimum amount reassigned?
Wouldn't say it's the minimum, but it is what our contingency plan has assigned from BB1 to New Mexico customers.
And is El Paso Electric asking the commission in this proceeding to authorize additional assignment as determined by El Paso Electric as being needed?
I'm so sorry, Ms. O. Can you repeat that one last time?
Are you asking the commission in this proceeding
Mhm.
to authorize additional assignment as determined by El Paso Electric as being needed?
Yes, yes, we are.
And then is there a requirement that the output of system resources like BV1 be allocated between Texas and New Mexico in a particular manner?
All I know is that the BB1 procurement was done it was procured during an all source RFP, and it was for capacity needs for both Texas and New Mexico. It just so happened that BB1, a renewable project, was the lowest cost. It was part of the lowest cost resource portfolio to meet the capacity needs. So as such, EPE's already committed that we would allocate the BB1 solar facility as a system resource allocated based off jurisdiction allocation.
Is there a requirement stated someplace that that allocation be in that particular manner?
I don't believe there's a requirement, but we have verbally committed that approximately about 80% of the BB1 to Texas.
Why does El Paso Electric believe that the output of a system resource can be reallocated?
For that specific question, I would defer to Mr. Shisto.
To your knowledge, has El Paso Electric done this before?
Not that I'm aware of, but I would also defer that to Mr. Shisto.
Okay, thank you very much. I have no further questions right now. Thank you.
Okay, you're welcome.
Thank you, Ms. Sol. Ms. Lynch, do you have any questions for Mr. Martinez?
Yes, I just have a few.
Go ahead, please.
Okay. Hello, Mr. Martinez.
Hi, Ms. Lynch.
I just have a couple of questions to better understand the approvals that you're seeking for either the baseline or the contingency plan. Why did EPE propose 2 plans?
Well, the first baseline was just to show exactly how it is to show the resources that EP has to meet an RPS requirement based off of the, I guess, latest information we have at this time, specifically with Hecate being online in June of 25. But being what's kind of been happening in the last few years with supply chain issues and so forth, we thought it was prudent for EPE to come up with a contingency plan in case Hecate is not able to meet COD in June of 24 as based on the latest information we have at this time. So again, it was just a way for us to, we did not want to be caught kind of flat-footed and wait until that time. And if for whatever reason, Hecate is not able to come online, we at least have now contingency or other scenarios that we could use to be able to meet the RPS requirements. And like I said, and not start the process then we wanted to be proactive, and we thought it was the most prudent thing to do.
Regarding contracts EPE may have in place with the developers of the Hecate project, are there certain requirements that you have of those contractors to meet the COD?
Yes, they are. Those specifics, I would probably ask if you can. I defer to Mr. Brent Davis. He has a lot of knowledge as far as the different milestones that are set up in the PPA, and he'd be able to tell you if those milestones have been met.
If those milestones are not met, are there penalties?
There are some, I guess, penalties or charges, but again, I would defer that to Mr. Brent Davis.
Okay. Does EPE have a preference for whether the baseline plan is implemented or whether the contingency plan is implemented?
EP would prefer for the contingency plan to be implemented, because in case if again the worst happens and Hecate's not there, then we'd have already something in place to assure that we can meet our requirements for New Mexico customers.
So if the commission approves the submitted baseline and contingency plans, does EPE plan to implement parts of either the baseline or the contingency plan, or is there a triggering event that would provide for EPE's implementation of the contingency plan?
So I guess a lot will be based on commission approval. So if say the DG Rec program was to get approved, it's EP would prefer to use that going forward, because those are recs that EP could use to meet New Mexico customers without having to possibly acquire more resources in the future. So we think it'll be beneficial by having to procure less resources in the future. And
so sorry to interrupt.
No, please do.
Is it accurate then to characterize EPE's position as being able to implement parts of either plan if this application gets approved?
Yes, what we want to be is we want to be compliant and make sure we do it at the lowest possible cost for New Mexico customers. So if it means kind of taking just certain portions of here and there, we would be okay with that.
What does contingency mean?
Contingency just means being prepared in case something happens. That's all it is. In case.
So there is no real triggering event.
No, I would say not.
Okay. That's useful to understand. My next question is just one of understanding common practice. Is it normal or common for utilities to submit contingency plans before commissions?
I would not know the answer to that. I'm not sure.
Okay. I really appreciate your meeting you. I think this is the first time we've had an exchange, and thank you, Hearing Examiner Hurst.
You're welcome.
Thank you, Ms. Lynch. Mr. Black, any questions for Mr. Martinez?
Thank you, Hearing Examiner Hurst. No questions, and I want to thank Mr. Martinez for participating in this matter.
Welcome. Thank you.
Thank you, Mr. Black. I have a few questions for you, Mr. Martinez, and I don't know if Hearing Examiner Fisk will have some questions. Were you listening to Mr. Novella's testimony?
Yes, I was, ma'am.
And I had asked him and whether or not he had reviewed the city of Las Cruces witness testimony, and he had indicated yes. And I asked him that there had been an assertion made that EPE was not requesting to have the baseline plan approved by the commission. And I asked him whether or not that was correct. Did you hear that testimony?
I believe so, yes.
And that his answer was no, that you're not asking the commission to approve the baseline plan, correct?
Yes, that is my understanding as well.
That all the baseline is a representation of what has already been approved and where and the calculations that you have if the procurements happen the way that you believe, or not the way you believe, but the way that they were approved to have happen, right?
The baseline, I believe it's based on the assumption that the resources will occur as they happen, as they're planned.
Okay, as they were contracted for?
Yes, you could say that.
Okay. Also, with regard to Mr. Novella's testimony, I had a question about Regis,
Yes,
and I believe he deferred that question to you.
yes.
And you know that means you get part of his paycheck, but you
If
have
I'll-
to collect it.
Yeah, I don't know if I'll be able to collect it, but yes, I do remember.
Okay, all right. Just like Mr. Davis will get part of yours.
Yes, he probably would.
Okay. But anyway, I was looking at a particular page. Of course, now I've taken the postie off because I wanted to put it on your testimony. But basically, if I can recall, it was a representation of Rex and reports being reported to Regis, and there were all these little ABCD footnotes that to me indicated there was a difference in the amount of Rex that EPE was counting and the amount that you were being given credit for with Regis. And the little footnotes all said something about Regis, problem with the Regis software update. Do you recall that?
I do recall that, yes.
Can you give me an update on that? How, has that been resolved?
Actually, Madam Hearing Examiner, as soon as I heard that, and when I heard that it was deferred to me, I did reach out to our energy accounting group, which is right now in charge of reconciling, the RECs generated compared to the RECs that should be in Regis. And I did ask if they could verify to see if that problem had been fixed. Unfortunately, I just wasn't able to get a response in time. So I think it might be something that we would need to get back to you.
Okay. Very, very well. I appreciate you doing that. And yes, Ms. Olson, let's consider that a bench request. As soon as that information is available. And again, I will have to, I'll have to go back and unless somebody wrote down what the page was,
Madam
I'll have,
Chair, oh, sorry. I think it's page 14 of Exhibit GN2 EPE's 2022 RPS report. I guess it's page 19 of 303, if you're looking at the top, the header on that report. Table 3.
Page 19 of 202?
Of 303.
No, that's not where it was in my copy.
Oh. Because that has all the footnotes about the Regis software update.
Okay.
But it might be in more than one place.
Okay, I had a little chart. I will find it again. And just consider that my bench request to give me an update on whether or not Regis has gotten its software issue fixed to the benefit of, because it seemed like the Regis, what you were getting credit for was lower than the amount you were actually claiming. Okay. I just had a question. Your direct testimony, page 7, your beginning section B, plan year and next year plan RPS calculation. How is it calculated on line 5? You're answering that. And I'm interested in the 13 through 16, where you say the net jurisdictional megawatt hour sales are the forecasted New Mexico jurisdictional energy sales adjusted for weather, projected energy efficiency, and DG. Is that correct?
That is correct.
And also in the and that's not new, is it? I mean, that's the way that they've been calculated for years, right?
That is my recollection, yes.
Okay. And I noticed, and not having had one of these cases for a couple of years, since at least since the rule changed, that the RCT calculation has changed, hasn't it?
I'm not sure if it has. I'm just aware of the current one right now.
Well, that it changed in the that it went from the constraint formula to the levelized cost of 60 per megawatt hour.
That's the one that I currently know of. It's $60 and then inflated as of 2020.
Right. Yeah, and I didn't recall that there was a inflation adjustment. So it says that I guess the definitional section has been revised in 21 and in 23. Do you have any, you refer on page 10 of your testimony to the commission approved renewable energy resources that contribute to the plan? Do you have any updates or information on those sources and whether anything has changed since you filed your direct testimony.
I'm not aware of any changes from the time I filed my testimony.
They're all still in operation and still operating within the required parameters.
As far as I know of, yes, they are.
Okay. And you say on line 9, approximately 21.31% of the energy generated by BV1 and Hecate 1 are allocated for the RPS purposes, and that's the jurisdictional allocation, right?
That is correct.
And then you're talking about SIRLEF and retiring RECs associated with them. But if I can recall the testimony correctly, it's not all of the RECs that they generate, correct?
Correct. Right now, there's a disparity between the RECs generated by SIRLEF and the energy delivered to EPE.
But they're also keeping some for themselves and then potentially selling some through the meter?
That is correct. Yes, as mentioned in my rebuttal testimony, SIRLEF is no longer selling all of the energy from its facility to EP. Some of it is being sold to, it's a research and development data center that's located behind the meter.
And then on page 11, you're using the word procurement, right?
Yes, ma'am.
Do you have a different definition of procurement than Mr. Novella does?
No, I believe that's the same definition.
Okay. And then you're summarizing the DG Rec program by saying EPE is proposing to, this is at line 16 on page 11, is proposing to purchase all DG customer RECs associated with renewable energy delivered to EPE, except for those that are already being purchased under rate 16. And that's because when you purchase the energy under rate 16, you get the REC, right?
Correct.
You're answering the question posed on line 15. How did EPE determine planned solar curtailments? And that's line 16 on page 15. And so you go on and you continue answering on page 16. Why do you include that?
In case anybody had any questions as far as how that line item was calculated in our, so I have an exhibit, I believe it's VM1, and there's quite a few of them, but that list, in essence, the plan on a table lists exactly what our load is, all the resource, what the REA requirement is, and all the resources that will be used to meet the REA, and then it subtracts round trip efficiencies and is also curtailed energy that is expected for that year. So
I'm sorry, sir. What is curtailed energy?
So there may be times where we may need to curtail some solar energy due to the fact that we may have more resources compared to the load that we're serving. So in order to balance the system, we may need to curtail it in our.
So does that mean you just don't use it? Do you store it?
No, we would not store it. We would just simply curtail it.
Do you sell it?
When we curtail it is only when we've exhausted uh, all other options. Our first option would be to sell the energy. But there's times where there either isn't anybody willing to take the energy, or maybe the market may have turned negative, which means we would have to pay people to take it. So during those rare occasions, we feel it would be most beneficial for New Mexico customers to curtail the energy.
Well, if the energy that's being curtailed is the DG, do you have to pay them anyway?
We don't curtail DGA, we're just talking about the larger scale PPAs.
Well, and then I found it interesting on page 16 at line 2, you say EPE calculated New Mexico allocated curtailment based on its jurisdictional allocation. So why is that?
So the analysis that we did in order for us to calculate curtailed energy was done on a system basis, including all the resources load. So once the analysis was done, we used the jurisdictional allocation just to determine what the impact would be for New Mexico customers.
Okay, so it didn't really make any difference where the energy was curtailed, if it was the New Mexico facilities or not. It's all based on the jurisdictional allocation.
Correct. We're making the assumption that the solar resource curtailed, the curtailment would be evenly distributed based off their jurisdictions.
Well, let's talk a little bit about your contingency plan. And on page 17, you're testifying about describing contingencies. And you say on line 2 on page 17, as I have testified above, CODs are unpredictable. That's your testimony, sir?
Yes, it is.
Well, that's not a new piece of information, is it?
I'd have to look back at my testimony to see if it is new or if it was mentioned before.
Well, I'm just wondering if in your knowledge and experience, sir, if, CODs being unpredictable is a new fact in your knowledge base.
No, it's something that could occur often.
And that's kind of what I'm wondering is it seems like in all of the analysis and contractual negotiations and RFPs and everything that goes in and then the whole, authorization process, I'm tired just talking about all those things. I mean, it just seems like to me that there's certain things that might happen in this whole generation asset acquisition process that have been going on since generating began, aren't there?
Possibly, yes.
And it just seems like to me that with all the people that and all the processes that EPE has, that they would be used to having some things happen. And it just, I guess I just want to try to put in context, why now? Why now are we doing a contingency? Why didn't we do a contingency 2 years ago? When other things were happening, when the pandemic first started? Or why didn't we do some contingencies back in 16 or 17 when, you figured out that you weren't going to make your RPS requirement because of the cost? Why didn't we do some contingencies then?
That's a good question. I'm not sure. I've only been doing this for 2 years. It's my second time doing it. I couldn't tell you exactly the reason why a contingency plan was not introduced before, but I think everything that you mentioned just goes to show you the importance of having this contingency plan based on everything that could happen, and to assure that EPE has a plan in place, to make sure that we meet our New Mexico customers in case those things do happen.
Well, on that point, I'm not trying to give you a hard time. I'm just trying to figure it out. But, I think as you probably know, there's some other IOUs in the state. And one especially near you that has cross-jurisdictional issues, and they seem to be able to comply. SPS, don't they?
I'm not sure. I wouldn't be able to say if they are or are not. I'm sorry.
Well, let me put it to you this way. If PNM and SPS were compliant in meeting the REA, and they figured out how to do it. I mean, EPE's just as smart as they are, aren't you?
I would like to think so, yes.
And it just seems like there's got to be a way, doesn't there?
That's what we're working on, again, especially with introducing the contingency plan.
But when? I mean, that's maybe that's a question for Mr. Schiestel. It's like, different things have been tried, and I'm just wondering if EPE believes that you're making any headway here.
We believe we are.
Well, let me give you the opportunity, Mr. Martinez. On 17, we're talking about the page 17, talking about the contingency again, and at slide 17 and 18, you're talking about those proposed new procurements, right?
Yes.
I just caution you, just like I did Mr. Novella. If we're going to say they're really not new and they're really not procurements, let's find some other way to describe them other than new procurements. It's really confusing, at least for me. And perhaps not for Mr. Fisk, and he'll just be able to better explain it to the commissioners. But I'm already worrying
Understand.
about how if you call it a procurement and then you say it's really not a procurement, if you say it's a new procurement, well, it's not really new. I need more arrows in the quiver to try to explain some of these distinctions. I also had a question mark by your excess recs. It seems like to me that the excess recs that you talk about on page 20 of your direct testimony, the 34,276 excess recs are basically equivalent to those 34,000 recs that you're proposing to get from the 8.69% of BV1, aren't they?
Yes, very close.
So, like, if we did away with that, then you wouldn't have 34,000 excess recs, would you?
It probably wouldn't be prudent to plan on hitting the mark right on the money. That probably wouldn't be prudent planning.
Okay, don't want to hit that bullseye.
Yeah, exactly. It'd be nice, but it probably wouldn't be the wisest thing to do.
Okay. And I did like page 23 of your testimony because it made me go look up all these things about where all these plants were. So Hecate is gonna be in Santa Teresa. that right?
Yes, that is correct.
And that's a 50. Hmm. I don't know. I wrote too close to Buena Vista. Buena Vista's in Otero County near Chaparral.
That is correct. Yes.
And one of those is a 50 megawatt solar with 200 megawatts of storage. Is that the Buena Vista?
BV1 is 100 megawatt solar coupled with 50 megawatt battery, and BV2 is a 20 megawatt solar facility.
And what will Hecate be?
Hecate 1 would be 100 megawatt standalone solar, and Hecate 2 would be 50 megawatts standalone solar.
Okay. And then I looked up Macho Springs, and that's a wind farm in Luna County.
It's a solar facility for 50 megawatts, Macho Springs. And it
Oh,
is,
it's not wind?
no, man, it's a solar.
Oh, okay. In Luna County.
That is correct.
And so for all of these New Mexico facilities that are allocated on a jurisdictional basis as system resources for both New Mexico and Texas?
Yes, right now I believe it's the Macho Springs and BV1 are both system resources allocated to both Texas and New Mexico.
And what about the Hecate are going to be?
Oh, I apologize. Hecate 1, thank you so much, sorry. And Hecate 1 is also a system resource allocated to both New Mexico and Texas.
So basically my understanding from Mr. Novella is that because the energy is not generated in Texas, they can't be used for RPS compliance in Texas, right?
That is correct.
Or the energy that Texas is allocated, they can't use for RPS. Except somehow energy that goes from one of the plants to Palo Verde, there's some kind of money that goes to the Texas allocation to purchase RECs. Correct?
Yes. Yeah, so I'll take, say, Macho Springs for example. 80% of all the RECs generated by Macho Springs, approximately 80% belongs to Texas. However, Texas is not able to use those RECs to meet their Texas RPS requirements. However, EPE has been able to certify the RECs generated from the Macho Springs facility. I believe the certification is PCC2, meaning that those RECs, once they're certified, PCC2, we're now able to sell them, sell those RECs, and people are able to take those RECs and take them into the California market. Now, in order for the facility to be qualified as PCC2, they need to have a direct transmission line from the facility itself into California. I believe that's what Mr. George Novella was referring to.
So is that market any better than that one bid New Mexico market?
Actually, that one bid, oh, I'm sorry. Which one bid are you referring to?
Well, wasn't there just this one, the RFP thing that you did, and there was only, that was like $5.40 a rec?
So there's two things. So the short-term RFP that we previously did, where we only received one bid, that was an RFP done for renewable energy plus RECs.
Oh, plus the RECs, okay.
Plus RECs, exactly. Now the $5.40 price that comes in is a year ago, EPE went out and sold the Macho Springs that were owned by Texas, and we sold those RECs into the wholesale market. We received 6 bids from that RFP. And if you're to average the price received within those 6 bids, you get $5.40.
Were you pleased with that?
Well, it is what the market is. Obviously, we would always want more for our customers, but at the end, we're price takers, and the market will dictate the price based off of kind of supply and demand.
Okay. So further on your page 24,
So my direct
yes, sir. You're talking about replacement cost? And you say, does EPE consider the replacement cost a procurement cost? Yes. However, this is at line 10 on page 24. However, EPE is not proposing to include this procurement cost in the RPS cost rider at this time. To the extent replacement costs are incurred, EPE proposes to address these costs as part of an RPS cost rider reconciliation in a future REA plan. That's your testimony, sir?
Yes, ma'am.
Well, I guess. I mean, I understand your point on page 25, line 7 and 8, whether BV1 gets reallocated or not. New Mexico customers would still have to pay the same amount for higher price replacement power sometime in the future. However, you know, I'm just sort of wondering here with your testimony on page 24, is you're saying, well, yeah, there might be some associated replacement costs. If we use that allocation for New Mexico, that's greater than that rec cost for us to get replacement energy for them. But my thought is, it's kind of like a pig in a poke, Mr. Martinez. How do you expect the commission to approve something that we don't know what the cost is? EPE wouldn't do that, would you? I mean, would you sign a contract that says, yeah, here's the price? Oh, and there might be higher prices, you know, sometime in the future. We don't know what they are now. I mean, don't you see that as problematic?
Not necessarily, because I think as you mentioned too in page 25, whether the BV1 gets allocated or not, the New Mexico customers would still be paying the same amount. So if anything, if I see this as kind of a no-brainer, because it's not really adding additional cost to New Mexico customers, especially if the cost of the replacement costs come above the BV1 price. So again, the way I see it is whether it gets allocated or not, customers are still paying the same amount. However, now they get the associated energy along with RECs in order for us to be able to meet the RA requirement.
And also, I wondered what the relationship back is on your testimony on page 28. Section C, other rules 572 requirements. And it says, did EPE consider strategies to minimize costs of renewable energy integration, including location, diversity, balancing area activity, demand side management, rate design, and load management? And you're saying yes, but then you're referring me to Mr. Novella's GN2, which is actually the annual report on the 22 plan. So how does what was discussed in the 22 plan meet your 572 requirements in the 23 plan? Unless you're referring me to something else.
No, actually, it was just referring to Mr. Novella's exhibit GN2. I guess it was my understanding that the information in GN2 would be adequate enough to be able to answer the Rule 572 requirements.
But you understand that his GN2 is the annual report for 2022, don't you?
Yes, I do.
Okay. I gotta kid you now. In your rebuttal testimony on page 14, line 18,
Okay, let me get to it.
I want to know what IYD is.
I'm sorry, I'm there. Where's this at?
This is page 14, line 18.
18.
EPE's objective is to meet IYD.
Obviously a typo. Let me see if I can recall what I meant to say here. I think oh, it's but IYD, it's supposed to be just it's ITS. A typo on my part. I guess I should have
Okay, it's
slowed down.
obvious. Okay.
Yes.
In your IRPs, do you address contingency plans?
We run various scenarios in IRP as far as what happens if either demand goes up or comes down, or if market prices go up or gas price goes up. So we run different types of sensitivities. So I guess in some way you could see that you could potentially say that there are some contingency plans in there.
And looking at your rebuttal testimony on page 19, the question posed at line 15, does this alternative allocating a higher percentage starting in the second half of the year change the projected cost? I think the answer is no, but are there any other positive or negative implications regarding the timing?
Yeah, the way I see it, it's the cost will either be distributed within a 12-month period, or we could distribute it within a 6 or 7-month period. Now, as far as is the exact implication that it could potentially have on customers, I think for that one, I'd probably defer to Mr. Gonzalez on that one.
Okay, and I'm not necessarily, Mr. Martinez, talking about any cost implications. I'm just talking about any other implications, good or bad,
No, I
other
mean,
than cost.
yeah, the cost will remain the same. Again, we know at the end of the year, based off of our contingency plan, we would need approximately about 30,000 RECs. So again, that cost could be allocated within a 12-month period or within a 6 or 7-month period, but the cost at the end of the year would be the same.
Okay, I'm just wondering if there was a time delay, if it might be an increased cost.
It might be an increased cost on a monthly basis, but at the end of the year, it'd be the same.
Well, would you try to make it up? And if it was not approved, if the commission adopted sort of like a wait and see attitude, and they said, well, maybe we could go with this after you see what happens on May 1st or June 1st or whatever that COD is,
Yes.
and if things aren't coming in, if it's really going to be delayed, then we'll wait, then you can go ahead and do it in June. I mean, are you going to try to collect the whole year in that 6-month period?
We would need to, because in order, we would have to collect that amount because we need that excess amount in order to be able to meet our REA requirements.
Okay. And along that same line, this backfill issue,
Yes, ma'am.
rather than sort of having that sword of Damocles over your head, why not go ahead and as soon as you have excess recs, just get rid of them and put them through to try to make up that deficiency as soon as possible.
That is our plan, ma'am. For any time we now have excess recs, our plan is to immediately go back and backfill any deficiency through 2021 and 22.
Okay. And then I had one more question, sir, with regard to your other miscellaneous issues. On page 29, you're responding to staff pointing out that you did not include your RCT calculation. How do you respond? And you say at the beginning of line 14 that you did. We calculated the adjusted RCT by using the consumer price index for all urban customers, CPI-U, published by the Bureau of Labor Statistics.
Mhm.
Why did you choose that reference or index?
We thought that'd be the best index to show what the inflation has been in the last few years. We thought that was a better indicator to use.
Based on what?
Well, I mean, we were using the consumer price index. Usually consumer price index is a good metric to help you measure what the inflation has been within the last few years.
Have you used it before?
Yes, we have.
Did you use it last year?
We don't believe we used it last year.
Did you use something different last year?
I believe last year we did not give the adjusted amount. I believe we just gave the $60, but I need to go back and double check on that. But I'm not sure what we did last year.
Okay. Very well, sir. That's all the questions that I have for you. Let me see if I had one. Oh, no, that's not for you.
Okay.
Ms. Olson, any redirect for your witness?
Madam Hearing Examiner, I just have very, very, very brief line of questioning.
Go ahead.
Mr. Martinez, there appears to be a lot of confusion around the timing of EPE's contingency plan proposal with respect to BV1 allocation. And I believe you testified that EPE's initial proposal was to start the reallocation on January 1st, 2023. Is that correct?
That is correct.
2024, sorry. It's been a long day. January 1st, 2024. But I believe your rebuttal testimony also provides various modifications to that. Is that correct?
That is correct.
And one such modification is to wait and see if Hecate meets COD on June 1st, 2024. And if it doesn't meet COD, to start the reallocation on June 1st, 2024. Is that correct?
Yes, that is correct. That is an option that we said we would be willing to do in order to address any issues of potentially starting to procure a little bit earlier.
And then I think another option that you proposed is to offset the amount being reallocated by any test energy to the extent there's test energy available in 2014 and 2024. Is that correct?
That is correct. To the extent that there would be any, we would also use some of that to offset the allocation.
So is it your understanding that EPE is seeking approval of the reallocation in this proceeding? In other words, approval to reallocate the BV1 resource?
Yes, that's correct. That is how I understand it.
And is it also your understanding that the commission could either leave up to EPE when to start that reallocation based on EPE's understanding of when that allocation would be needed, or the commission could direct EPE to start that allocation at a particular time based on a potential triggering event.
That is correct. We would be fine either way. We want to make sure just at the end of the year, we have the enough recs in order to meet our requirement. As far as the timing, when to start reallocating, we'd be open to whatever the commission feels it's best.
And I think you sponsor the procurement cost tables, is that correct?
That is correct.
And is it your understanding that the procurement costs that you've provided are based on starting that allocation on January 1st to procure the amount of energy? I think that is it the 8 point, I forgot what the actual number is, but the approximately 8% additional BB1 energy that you anticipate needing for a 12-month period?
Correct. Yeah. So what's on the procurement plan table, or the cost table, is just based off of the energy needed to meet our requirements for the end of the year. So as far as the timing allocation, it wouldn't matter when it gets allocated. As long as we still have the amount needed to meet our requirements, the cost will not change.
And you're and so that's based on 0 hectare energy in 2024. That price amount is based on 0 hectare energy in 2024.
That is correct.
And are you, or is another EP witness, I guess I'll ask you, and if it's not you, then can you tell me who?
Sure.
Can testify to how, if that energy projection changes, how EPE can address the cost impact of that change? In other words, if EPE ends up needing to allocate a greater portion of BB1 energy than you've projected in that procurement table, or you over projected the BB1 energy that needs to be reallocated and you end up using less? That question wasn't articulated well.
Yeah, if you're asking if I'd be the best person to decide whether I'm sorry. Yeah, actually, could you repeat it one more time?
Yeah, let me try it again. So you recognize that if EPE uses a lesser amount of BB1 energy or requires a greater amount of BB1 reallocated energy to meet RPS goals, that will have an impact on the procurement costs that you've projected?
Most definitely, yes.
And would you agree that in any plan year, those procurement costs are a projection, and they're often not on the money?
Yeah, that is correct. I mean, when you're talking about projections, it's pretty much based off of estimates based on the best information you have at hand.
And are you aware of the method or mechanism that EPE uses to address when the RPS procurement cost projections are off in a plan year?
No, I'd probably defer to Mr. Schiestel on that one.
Okay. And I guess my final question on that is, does EPE have a strong preference of when to start the BB1 reallocation in 2024?
EP does not. We just want to make sure we have enough recs to meet our RPS requirement and be compliant. As far as the timing, we have no preference.
Okay, and so with respect to the term contingency, which appears to be causing a lot of confusion, is EPE seeking approval of this contingency proposal, but defer to the commission of when that contingency could be put into place?
That is correct.
Okay, thank you.
You're welcome.
I believe that's the only questions I have.
Thank you, Ms. Olson. Hearing Examiner Fisk, did you have some questions for Mr. Martinez?
I have no questions.
All right, sir. Ms. Stevens, anything further based on mine or
I'm afraid I do, because of the last, I had a few based on your questioning. two of which were very simple and one was a little complicated. It's got a lot of back history that
Okay,
Martin, but one, Miss Olson's questions, I do have some questions on as well. So may
all
I,
right,
let's go for it?
make it brief.
Okay, so Mr. Martinez, I believed earlier, I know it's maybe 3 hours and it seems like a lifetime ago, but when I asked you the questions about the contingency plan, specifically you let testimony of your own that said that the company can start and stop procurements. Your testimony was that the company's proposal was to start on January 1st. Is that right?
Based off our contingency plan, yes, that is correct.
Now so did you just change your testimony and change the company's position in response to Ms. Olson's questioning?
I don't think I did. What we're simply saying, if the commission has a preference for us to be able to start at a later date, EP would be in favor of that. What we mainly want to make sure is that we're complying. Now, as far as the timing for us, we don't have a preference for that.
So unless the commission specifically orders that the application of Buena Vista reallocation is deferred until a later point in the year, the company's proposal rubber stamped would be start January 1st, 2024. Is that right?
No, if the commission prefers for us to start in June, then we would start in June.
If the commission were silent, it would start on January 1st, correct?
We could.
I don't want could, I want would.
No. I guess it'd be something we would probably have to discuss, but all I could tell you is based on the contingency plan, it could be starting in January. But as far as what we would actually do, I'd probably defer to Mr. Schichtel on that.
Okay. Ms. Olson also asked you several times about the reallocation being based on the amounts required to meet RPS. Do you recall that?
Yes.
And is it the company's position now that it will stop or curtail? I won't use the word curtail because that's the next set of questions. It will cease doing those reallocations, whatever, if they were approved somewhere in October, November, whatever, if it saw that it was going to be in a surplus position, regardless of whether what caused it to be in a surplus was the arrival of Hecate.
Well, potentially, but as the Madam Hearing Examiner and I were speaking about earlier, it's hard for us to be able to hit the target exactly. So we would want to make sure we plan that we have enough to meet our requirement, but also a little bit excess as well in case of other contingencies might occur.
Well, are you still thinking that 9.6% surplus is a little surplus or enough, or are you narrowing down or honing the margin?
I think the margin that we have is adequate enough to keep. Again, there's different things that could potentially occur, from retail sales being off, or saying another facility not producing the way it should. So we want to make sure that we encompass everything within the 34,000.
Okay, so my question is, come November, when you see that you didn't need a 34,000 margin, are you going to make adjustments to the allocation to align closely with reality? I know you can't be perfect. I mean, obviously you can't be perfect, but will you try harder than that 9.6% differential?
We would try to make sure we have enough recs, again, to meet the RE requirement, and a little buffer just to make sure we cover.
Well, what's the little buffer? Is it 9% or is it a little buffer?
It's a little is relative, I guess. Just enough adequate amount to make sure to meet our requirements plus any contingencies.
I think, I don't want to speak as the hearing examiner did earlier, but saying an adequate amount for yourselves when you already asked for 9.56% or whatever it was. I want to know whether that's what you consider adequate, or whether as the end of the year approaches, you can be more refined.
Yeah, we will try at the end of the year to try to be more refined, but obviously we would expect excess recs.
And working backwards, just before Ms. Olson questioned you, she asked briefly about the backfilling situation.
Mhm.
Now, and I wasn't clear with your answer. Are you saying that the company would immediately backfill at the end of the year, or determine that backfill obligation at the time of its next annual report? What did you mean by what is your expectation about the backfill obligation? Because it ties into what we just talked about. In reality, at the end of the year,
Okay, you ask a question, stop, let him answer it.
Yeah, so as soon as we've determined that we've met our requirements for the year, and as soon as we see that we have excess recs available at that moment, well, I want to say at that specific moment, but around that time, we would be backfilling any type of deficiencies, using any excess recs to fill the deficiencies for previous years.
well, are you going to backfill? Or are you going to ramp down or cease the Buena Vista reallocations in order to come close to nailing the number?
What I'm talking about is after the year has ended. So after what we've known, that what we've met and what excess recs. So by that time, there should be no more BB1 procurement.
The hearing examiner asked you about your direct testimony on page 16, which talks about the jurisdictional allocation of curtailments.
Yes.
And he asked whether based on, at the end of the day, whether it doesn't make any difference. And I believe your answer was true. And my question to you is, assuming that the company curtails jurisdictionally,
Mhm.
aren't ratepayers going to still pay the full contractual amounts for any PPA that's previously been approved by the commission?
Yes, most PPAs are structured so that it's a take or pay contract, which means that if the energy gets delivered or curtailed, they would still have to pay for that amount.
And a jurisdictional allocation of those curtailments is not going to alter the reality of the contracts?
I'm not sure if I follow.
Well, for example, if a contract such as the Carney contract has that extra charge, or the PTR credit thing,
Yes.
are you going to curtail? Are you going to curtail that one? Are you going to curtail jurisdictionally and then cause New Mexico customers to pay that extra surcharge because it's in the contract?
Madam Hearing Examiner, I'm going to object to this. I don't think, certainly curtailment of Carney is not at issue in this case. I think this is going beyond the scope of the single line item in Mr. Martinez's projection sheet that you asked him about.
The question with the hearing examiner was whether it makes any difference to customers, and the concern is that his answer was that it's true, it doesn't. And I just want to clarify to what extent it does make the curtailments do make a difference to New Mexico customers.
Do they make a difference to any of the customers? Mr.
Yes.
Martinez?
Yeah, anytime there's a curtailment on any of the PPA, there'll be, I guess, the customer will pay for the energy whether it gets curtailed or not. But deciding whenever do we decide to curtail, that would actually be because that was the lowest cost option to our New Mexico customers, which means our alternative was either possibly, either to sell into a negative market, causing a higher cost to New Mexico customers, or curtail it. So any action we take, it'll be based off of the fact that, one, we need to make sure we get the system back in balance, and we'll take the options that's the lowest cost option to our New Mexico customers.
Mr.
Stevens?
Martinez, is that to your New Mexico customers or to both customer bases?
I'm talking general to all of our customers.
I think that- Oh, and this one is a really quick one. I'd like you to turn to page to Mr. Novella's direct testimony, which I hope I still have here. Yeah. And it's exhibit GN2, page 19 of 303, page 65, PDF page 65, EP exhibit 1.
What was it again? Exhibit GN2?
Exhibit 1, Mr. Novella's direct.
Exhibit GN1, okay.
The exhibit GN2 is inside Mr. Novella's direct. It's page 65 of 358 in the PDF.
Okay, I'm sorry. I'm not sure I'm finding it.
You're not with me?
No, I'm not.
65 of 358.
65 of 358. Do I have the wrong direct testimony of George Novella? EPE exhibit 1? Not Mr. Martinez's testimony, Mr. Novella's.
GN2 is only 303 pages in my.
Correct, on mine too.
No, GN2 is an attachment to his direct testimony. So when you get to GN2, it's some 45 pages into the exhibit. Are you with me?
No.
What page GN2 are you asking for, Ms. Stevens?
I'm asking for, well, it's labeled GN2 on the top. Are there two sets of?
No, I'm looking at the actual PDF, so I don't have the comprehensive page number. So can you just say at the top it's labeled Exhibit GN2, page blank of 303? Which page of 303 are you looking at?
On the top, it's labeled Exhibit GN2, page 19 of 303.
Okay.
And in the PDF that has Mr. Novella's testimony and the tariff before you get to GN2, it's page 65 of 358. And that's what I downloaded from the Dropbox, I'm pretty sure.
I think you're just looking for page 19 of 303. Is that right?
I'm looking for page 19 of 303 of GN3. Yeah, this has to do with both the hearing examiner's questions it has to do with the hearing examiner's questions about those footnotes on the Regis software update.
Right. Okay.
Are you with me, Madam Hearing Examiner?
I am. It is.
I'm there.
Is
Okay,
everybody
go ahead.
else? Okay, thank you. Okay. So I believe that this might be what she was referring to, Mr. Novella, but whether it is or whether it isn't, I'm looking at row E, footnote E, and it says that due to Regis software update implementation issues, EPE has not yet received approximately 59,682 recs for 2022 from Regis. That number, that's for 2022. Has that in your reporting to the commission? Did you report that as recs received in 2022 to fulfill your 2022 RPS?
I believe we did put the recs.
Even though they hadn't been fully processed, you included them in your report to the commission?
Yes, because we believe that once the software issue gets addressed, we will have all those recs and we'll be able to use them for 22.
So I don't need to ask you questions about whether or not it is going to go to 2023 or 2024. Is that true? You've already taken care of it yourselves.
Yeah, we would use it for 22.
Yeah, thank you. That's my last question for clarification.
Thank you, Ms. Stevens. And yeah, I finally found the page again. It's the one that Ms. Olson was trying to refer me to earlier and that I couldn't find. And so that's the the substance of the bench request is that page and finding out whether or not there's been any update and whether or not these Regis software implementation issues have been corrected, and if so, how? Okay. Any questions, Ms. Olson, on that?
Yeah, I just have one point of clarification. I'm assuming you haven't read all 303 pages of the report. Maybe you have, but that footnote about the Regis software implementation issues is, my recollection is that that's inserted throughout on a number of things. And so
Okay.
I think what I hear you asking for is just clarification. Has the software update implementation issues been resolved? And so really you're looking for a yes or a no answer.
Sure. I mean, it would be, it would be helpful if it has been resolved to get clarification that those recs were actually received.
Okay.
Okay.
So if the answer is
right.
yes, then it's a second piece of have those recs been received? And if the answer is no, then the answer is no.
Well, if the software implementation issue has been taken care of and the recs haven't been received, then I guess I would want to know why.
Sure, no, I understand.
I don't know if I would understand why, but
yeah,
I mean, I just thought this was like a permitting process, and you submit the paperwork, and then they say, okay, you've paid your money and you've given us the paperwork, and then you get to count them. So yeah, let's start with that. Let's start with, and if we need more, we'll get more, but I don't want it to be a big deal further. Okay.
understood.
All
Thank
right.
you.
So Ms. Stevens, thank you. Ms. Souls, anything further based on my questions, or Ms. Olson?
No questions, thank you.
Thank you. Ms. Lynch?
No, ma'am.
Thank you. Mr. Black?
No questions, thank you.
Very well. Mr. Martinez, thank you.
No.
You are excused, sir.
Thank you very much. I appreciate it.
All right. Well, I believe we've reached the time to stop for the day. And I think we're going to have a few more witnesses and hopefully get done pretty expediently tomorrow. Do we have anything that we need to discuss before we recess? Hearing nothing.
Madam
Thank
Hearing
you all.
Examiner.
Oh, Ms. Souls?
I'm looking for guidance.
Yep. Where'd you go?
And today is the end of, oh, sorry. I thought I was on.
There you go.
Okay. Today is the end of the month, and I received at 3:30 El Paso Electric's monthly status report regarding Hecate project and the Buena Vista project. And since that is kind of at the root of what we're talking about here, is there a way to get this into the record?
I don't know. Think about it. And I know you are as part of your testimony, you already have reports, right?
I have the previous ones. That's correct.
Right.
Up through
Okay.
the ones that were submitted at the end of September. This is the one for the end of October.
Okay. All right. Well, look it over and then you can make your request
Yes, ma'am. Thank you.
tomorrow. Okay. All right. Anything further? No. All right. Very well. Thank you all so much. And Melissa, thank you for staying later. Really appreciate it. And I will see all of you tomorrow morning at 9 o'clock, and we're recessed until then. Thank you.
Can I ask one question?
Sure.
Do we have a different link for tomorrow or this same link?
I believe that it is the same link. Should it not be the same link, I will find out from Ms. Kippenbrock and make sure everybody knows.
Oh, thank you.
All right, very well. Thank you all.
Bye-bye.
Nice,
You.
nice pup there,
Thank you.
Mr. Black. Okay, we're recessed. Thank you, Mr. Fisk.
Have a good evening.
Same to you. Trick or